Hello, chat. What the? I think there's something wrong with my camera here. I don't know. I might have to reset the camera, but there we go. Good afternoon, day 29 of Karen Reed, and that was weird. But anyways, guys, welcome day 29 of Karen Reed. I know the view's a little weird. Something happened to the camera. It's not adjusting properly. So once we get started, Karen Reed, I'm probably gonna hop under the desk, unhook it, and reset it or something because I don't know what's going on. Does Costco sell fried chicken? Woo, child. That sounds great. But anyways, welcome to the show. My name is Sean, also known as Potentially Criminal. I'm an attorney in the Cleveland, Ohio area. And today we've got day 29 of Karen Reed. This is day 2 of Dr. Wolf, which once again, guys, I told you, this is the make or break for Karen. Dr. Wolf, Dr. Rentschler, I mean, like, this is it. If these guys flop, Karen's toast. So we'll see how it goes. Trump has been stolen. I had video court today and real life court today. So I had video court this afternoon. If I got to put Trump back up. My mechanic shirt today. Jeez. Where's our dog? Our dog. Our buddy. Come here. Our pupper. Come here. Come on, bud. Hey. Clyde. Hey. Clyde. No. Come here. Yeah. Oh, I know. You've been hiding from the media for so long. Hello, Bubberkins. Chairman of the Republican Party. We're going to give you a Clyde treats. Because you're a good boy, and Clyde gets Clyde treats. Once again, thank you to Kimbo Nice for his Shih Tzu treats. I'll give you guys a little dog ASMR chat for 10 subs. Dog ASMR. Good boy, Clyde. Good boy. Anyways, guys, I hope today was I don't, like, it's Mondays. The Mondays suck, but, like, I mean, today was an interesting Monday. It was fast-paced. A lot of stuff happened. So, I mean, like, it was good. Some things I didn't like happened. Some things I did like happen. So, I mean, say la vie, but it was a good day overall. Hope you guys had a good day today. I know some of you out there are going through stuff, and hope today's a little better. If it's not, hopefully we can hang out and it's a little better. But yeah. Hoping you guys are there. Jesus Love You says, gotta run, but whoa, buddy. I mean, based on what I saw from watching a couple of different people's Twitter feeds, I was like, woof. But I apologize for running late, guys. I was working on a brief and also explaining to a young buck that when you write into battle on the internet, people, the risk is people will learn who you are because of the internet. And to get upset about that is shocked Pikachu FaceTime. So $4 a pound says Clyde. Yes. Such a good boy. He's such a good boy. I love him so very much. So does 2.0. Mwah. So does Laney. You're such a good boy, Bubba. Mwah. Yeah. Hi, buddy. Johan says you love my shirt. Thank you. It's my best buy shirt. How much for an oil change? I only do brake jobs. I don't do oil changes. I don't have a lift. But I'll do your brakes because I just didn't mind. That took for fucking ever. Yes, Russell Greer did a very interesting filing today. We'll cover that this week, chat, because you know what? Karen Reed's trial, someday this war is going to end. And someday, chat, Karen Reed's trial will end and we'll be back to the normal schedule. So Friday night, we're probably going to do Russell Greer. Unless there's Karen Reed still going by then. Oh, God, I hope not. But, yes. We'll be doing Russell Guia. Hi, Clyde. Can I set you on the ground, Bubba Bear? Huh? Do you want to go outside and explore? Can you a woo? Ooh. Can you do it for the chat? Do it for chat, Clyde. Come on. Ooh. All right, Bubby. I'm going to set you down so I can keep working. There you go. Good boy, chat. Clyde, give him a round of applause. Our best boy. Our Best boy. Mescavator says, yes, our Clyde. He was never your Clyde. Also, man, it was humid today, so my hair looks like shit. I've been fighting that all morning. I work at Amazon now. Hello, Angela. Polymarket says, Karen Reed not guilty. I told you guys she stands a chance of getting convicted. Her odds are higher and higher. And yeah, she's still behind the curve at the end of the day. It's up to the defense to bring it 50-50. Whiskey 77 starts trying to self-build. You can't build your own towers, sir. Clyde towers are the only self-built towers that are zoned here. Your tower does not get recognized. I'm sorry. Yeah, you guys can't. This is absolutely not. But yeah, you guys can't build your own. You have towers are a team building effort. That's part of the. It's part of the fun. So, yeah, we'll be in verdict watch by Friday, I think, but who knows? Drummer says he's getting chonky. No, he just needs to get his hair cut. He's doing actually. His weight really hasn't changed. I'm my Amazon delivery uniform. Yes. Welcome to your door. I got a package for you, lady. Got a large sausage pizza. John Simmons saying, are you familiar with the most famous podcaster from Ashtabula? I'm not sure I want to know. Who are you referring to? Because I don't know. I'm hoping you're telling me Cyrax isn't from Ashtabula. Yeah, Sholo Towers are a shame, yes. Sly Stone died. Ooh, that's no good. I couldn't even fix my collar for you guys. What do you mean? Oh, sorry, I didn't notice that. I thought we were all set. Sorry, chat. Sorry. There. Oh, I was wearing a different shirt all day. My collar was set all day long. This is going to be a good episode. We'll see. We'll see. I'm a tech and a slug. God. All right. No, I can't figure out. SAR? You know, I need you to give me your credit card number and give me the three numbers in the back. The date and give me the last 4 digits of your credit card, the date, and then the three numbers on the back. That's what I need from you. Yes, the 2 YouTubers. God, these dudes got into there was a murder over copy strikes, apparently. 2 YouTubers in Vegas confronted each other, and the one just pop, 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 right on the strip, man. Yeah, there was some crazy stuff that happened there. So, chat is a major delay today. Oh, that's no good. That's no good. Anyways, guys, let's get on to Karen Reed. It is time for Karen Red. Let's do this. Here we go. Okay. All right, chat. Sorry, no closed captioning. But we will go to 1. Ooh, wow. Won't let me do it. There we go. All right. All righty then. Oop. Up. Oop. Up. 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 You guys thought we'd be watching the writing? Yeah, it's going to get going, but don't worry. We got to finish this. We're a channel of integrity, chat. We finish what we start. Yeah, the guy who did the streaming murder, he's still on the run. The dude got murdered on a live stream. So, he killed the dude's wife as well. I mean, why would you bring your life to go, I'm not going to lie, 2.0 loves me, and, if there was somebody here in town and we were A-logging them, she wouldn't go with me. She'd tell me I'm a retard and I'd have to go by myself. But why would you bring your wife to an A-logging in person? When A-logging goes wrong. That's what it is. Oh, he turned himself in? Wow. All right, guys. Chalabordo says, it's always day 29. funny. Here we go, guys. Let's do this. We got our banners. Hold on. And guys, we're still on the defense expert, Dr. Wolf. Sorry. Had to get the banner going. All right, chat. Here we go. It is time. Ooh, wow. We got going right off the bat. 20 minutes in. Here we go.
But now we'll be in AT.
Hi, good morning. So I just saw
It's not me, guys.
a transcript that was placed here on maybe referenced this morning, and there's a motion to limit Dr. Rentschler that I just got that I'm not prepared for. So that we'll do later today, okay? All right. So the Commonwealth's motion to call witnesses in.
Hi, Charlie. Good to see you, man. I'm glad you're back. Good to see you're back again.
Rebuttal. I've read everything. Ms. Little, I appreciate you getting your opposition to me. I think I had it by Saturday morning, so I appreciate it. I read all the cases on it. Does the defense want to be heard any further on this?
Yes, Mr.
Okay.
With regard to Dr. Crosby and Ms. Coon, as a first,
Speak into a microphone. Speak into a microphone.
with regard to Dr. Crosby and Ms. Coon, the Commonwealth has been on notice that the defendant intends to present a defense regarding the arm injuries, that this was caused by a dog bite. They have been on notice of that, not just for months, but for years. That was presented at the first trial. The Commonwealth does not have a right to rebut information that they have been on notice of from the start of the case. So their decision to wait for rebuttal to call these two witnesses is improper, and we're asking the court to exclude their testimony.
All right.
As it relates to Dr. Welcher, the scope of his testimony, our request is that that be limited to very specific information, specifically responding to the new testing that ARCA has done. As the court knows, the Commonwealth has proposed a number of new testing ideas, as well as information that is greatly outside the scope of what ARCA intends to testify to. And so we're asking that the court limit their testimony from engaging in new testing that has nothing to do with what ARCA has testified about at this trial. With regard to Dr. Welcher's testimony, the court has made very, very strong rulings that Dr. Wolf, as well as Dr. Rentschler, are not allowed to speak to the credibility of Dr. Welcher himself. And so some of the information that the Commonwealth proposes is to directly attack the testimony of Dr. Wolf and Dr. Rentschler. And under the court's rulings, we're asking that the court limit that scope as well.
And I told you I would.
Thank you.
All right.
That's all,
Brennan.
Your Honor.
Thank you. Mr. Brennan, do you want to be heard?
Regarding DNA evidence, evidence cannot be rebutted until it is introduced because the defense has a number of potential ideas of areas of testimony. It does not compel the Commonwealth to try to anticipate or deflect attacks, especially if they're meritless. And so the issue of dogs and dog DNA does not become relevant until the defense calls a so-called dog expert. They raise the issue in proper grounds for rebuttal. There are three witnesses, Ms. Hartnett, UC Davis, and Dr. Crosby. If Dr. Lapisada is precluded from testifying about dog bites, we would not call Dr. Crosby as a witness. However, regardless of what Dr. Lapisada says, we would ask to call Ms. Hartnett and to call the witness from UC Davis. It is an issue that directly affects the assessment of Dr. Russell, the very expert they chose to call in the case in chief, and so we can now, from my perspective, properly rebut it. The second issue regarding Dr. Welcher, limited to the new information you will see from the testimony or have heard. Most of the testimony is new, but we understand it's limited. We don't expect Dr. Welcher to have a direct comment on the credibility of any witnesses, but he will address the tests, how he believes would be the proper procedure, and there'll be a number of issues that have been raised on direct examination, but he will not in any way have a comment on the credibility of the defense experts.
All right. So the case law supports me allowing this motion. I'm allowing the Commonwealth's motion. So the motion for rebuttal witnesses is allowed. Mr. Brennan has said he will not call Dr. Crosby, depending on the testimony that comes in. So, all right, Jim, I'm just going to give you this.
Thank you.
All right, so the motion regarding the testimony of Dr. Lapisada. So the Commonwealth is moving specifically to exclude, there's a motion to exclude irrelevant photographs.
Okay, guys. So that whole issue, I mean, yeah, you're doing what you can to keep out Hank's experts and rebuttal witnesses. I understand why they did it. They knew they were going to lose that ruling. They did anyway. That was kind of like an obvious one. So don't. Nero, from what I understand, that probably was going to happen. So, yeah, that, like I said, that's not going to make or break Karen ultimately. So, and anyway, that's something he's allowed to do. I'm not upset with that one. Like that one's okay, fair. So
We'll deal with that after the main motion to exclude certain testimony. So if we start on page 7 of the report, that's where you want me to start, Mr. Brennan?
Your Honor.
Okay, page 7 of your report. I have some questions. So, Mr. Jackson, Dr. Lapisada cannot opine about the investigation of the case, the law enforcement investigation. She does that throughout her report. So she can't opine to that. But when we get to page 7, what do you say is out, Mr. Brennan? I mean, I've gone through it. I know what I think, but it's the Commonwealth's motion.
I think that her opinion about no object being present to cause a pattern injury is appropriate.
And where are you, on page 7, the first paragraph?
Yes, photographs and descriptions of the site. It is the
All right, I might have a different page 7. So my page 7, okay. Okay, yep.
Dr. Lapisada's proposed opinion that photographs and description of the site where Mr. O'Keefe's body was found show no object capable of producing a pattern injury, I think is appropriate. His body was found on flat, grassy ground, probably frozen and covered with a minimal amount of snow. I agree is appropriate. It is the next paragraph where it begins in the middle of the sentence. It is logical to conclude that Mr. O'Keefe was injured elsewhere and his body was moved to the front line. There is no basis in fact for that. It's the proper opinion.
Yeah.
That's the argument.
So I told you that on Friday, Mr. Jackson. Great, okay, so that's out. And Mr. Jackson, again, the medical examiner erred in her diagnosis of hypothermia. Again, that's the improper critiquing of the expert. She can say that it wasn't hypothermia, obviously. Okay, so same with the first sentence of the next paragraph, the Wisniewski spots were misidentified. Great, all right, so we can probably do this much quicker then. All right. All right, so page 8 is fine. So now we go to page 10. So this is the dog bites. So if you want to pick it up at, what does the Commonwealth say about this?
At this point, there's no basis provided that she has the training, expertise, methodology to provide an opinion regarding the dog.
What's the offer of proof on this, Mr. Jackson?
It will be more extensive when I establish the foundation. Testimony, basically, she's not only done autopsies involving dog bites, the wound pattern recognition related to the source of those dog bites. She's also taught classes on wound pattern recognition, source of coming up with diagnoses concerning the source of specific pattern of wounds. She has a methodology she uses. Medical school classes, I mentioned, the courses.
What does she teach? Is this in her CV? Because I didn't see it.
It will be in her foundation that I relay from the theory.
All right.
I don't see any opinion unless and until the foundation is properly laid, but she has extensive experience, not only with specifically with autopsies that she's conducted herself, but supervising.
I'm right here. I'm just working on something. I have to turn up the camera.
Methodology involved in pattern recognition.
How about dog bites?
Dog bites specific, 5 autopsies. I believe she will indicate that she's done 5 autopsies as they relate to dog bites.
Okay.
A medical school class specifically on the issue of wound pattern recognition, which that class includes dog bite recognition.
All right, so we'll need a short voir dire of her on this before she testifies.
Because the court doesn't believe that I can lay the foundation in front of the jury to forego a voir dire. I won't ask any ultimate questions until we go to sidebar, but I think we can short circuit that.
She's very specific about the dog bites here. So if she's seen 5 autopsies with dog bites, I'm not inclined to give it to you, okay? Seen only 5 in her 40 years or whatever.
It's not that she's only seen 5, she's performed 5 autopsies.
Okay, so that's why we need a voir dire. So we need a very short voir dire.
She's also been qualified on the issue of dog bite wound pattern recognition in federal court as well.
Okay.
She has a plethora of foundations.
Has that been provided to the Commonwealth in advance of today?
None of it has. So here's the difficulty, whether it's a voir dire or it's in front of a jury, I have absolutely no ability to research and cross-examine her on dog bites. She can say she had 1 case or 50 cases, that she testified in state or federal court, or she took a class. I can't verify it, I can't contradict it. I have no ability to prepare for this witness about her basis, methodology, and experience in dog bites. What I have is her showing a couple of pictures that she pulled from her book, and then she has some Google or Shutterstock research in her report. And so the idea that she has a history or basis is going to be uncontested, because there's nothing I can do to contest it, and that's not appropriate. I should be able to research, get transcripts, vet, and be able to approach the witness on whether or not she actually has the reliability of education and experience. I can't do that if we call her an accident or a voir dire.
So that's where, if we want to compare apples to apples, Dr. Wolf, AZ Wolf, was allowed to testify, to specifically testify to the wound pattern, his interpretation of wound pattern recognitions back then. That was nowhere in his report. That was objected to by the defense. Mr. Alessi went to sidebar, strenuously objected, said this is nowhere in the report. We didn't have any notice of this, and the court said, overruled, he's allowed to testify to the pattern of recognition, at least in his mind, you can cross-examine on. There is no requirement that the Commonwealth have every single case that Dr. Lapisada has ever dealt with, dealing with.
No, we had an expert on dog bites who I allowed to testify as to dog bites based on, we had a whole, as you know, it was Mr. Leslie, I think 3 days with Dr. Russell on the voir dire. This is new to me. I'm going to have a short voir dire on to what she can testify to.
I have no problem with voir dire, I just want to short circuit it.
So, all right, so let's go on to page 17.
Commonwealth has an objection to the third line, to show Keith's pattern injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm. She is not qualified as a reconstructionist or biomechanical engineer. She has tried another course and been rejected. She does not have the experience, the background, or the ability to do that any problem.
What do you say, Mr. Jackson?
No, I believe she does, as a medical examiner, have the experience, and it's the qualification, it's the specific job of, and the qualification of a medical examiner to opine on pattern injuries. If the foundation is laid, especially as it relates to motor vehicle accidents, and now we're not talking about dog bites, which are a more defined subset of her overall experience. Now we're talking about motor vehicle incidents and accidents that she has specifically seen thousands of.
Okay.
Thousands, multiple thousands.
So-
But if she does have the qualification to say, if the proper foundation is laid, that the wound pattern that I see on Mr. O'Keefe's arm is inconsistent with anything that I've seen in terms of a motor vehicle accident.
Let's just find out how many motor vehicle accident autopsies she's done during that voir dire. What I have a question about is tail lights are typically made of durable polycarbonate or acrylic plastic. I would keep that out. I'd be inclined to allow in the injuries on his right arm do not correspond to injuries that could have been produced by plastic pieces impacting his arm. But let's hear about that.
I wouldn't ask for polycarbonate. I have no intention of asking about that.
And also, the last sentence, I think it's okay, and we'll see with voir dire. Neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes, assuming she has experience with autopsies of motor vehicle accidents. But I would keep out the part as would be expected from pieces of shattered tail light. Was there more on that?
I object to that because this is now yet another witness that's coming in under the guise of some type of specialty, but really for accident reconstruction.
All right, so let's see what she says on voir dire regarding her experience.
Wait, how does
with
that turn into
accident
accident
victims. I think she gets
reconstruction,
more
Hank?
into the accident
Wait.
reconstruction
Wait,
on the
wait,
next
wait,
page that
wait.
I don't think is proper.
Wait, that's not them turning into accident reconstruction. I mean, like, Hank, you can't just hide behind that as your shield anytime there's an expert who says something he doesn't like. Well, they're not an accident reconstructionist. Like, really? That is bullshit. She should be allowed to talk about pattern recognition for a wound. Whoa.
Proper.
Which I am not seeking to introduce.
All right, so that whole first paragraph on the next page, you're not seeking to introduce? Yeah.
But at least the first, we're starting with the first sentence, but yes, we would be seeking to introduce that.
Okay.
Like pedestrian injuries.
Clyde is the only solo tower that is allowed, chat. Clyde is the only solo tower.
Produced by contact with motor vehicle, including component tissue crushing force as the car profile protrusions connect. That's basic, I believe.
There is no closed captioning until we get going. Sorry.
She does have the qualifications to opine about that. That's pretty standard, and that should be admitted.
She has absolutely no experience in accident reconstruction or the injuries. She is not a biomechanical biomedical engineer. They have one, and he's going to testify to it.
Yeah, I have that as out, Mr. Jackson.
The reason that I believe that it's appropriate is because you don't have to be a biomechanical engineer to understand when you see for instance, a known pedestrian accident, what are the results, especially if you've seen hundreds or maybe
This is actually literally Hank's argument. You can only call him out on medical wounds and medical matters. Well, an accident came in, and it was from a kitchen knife. Well, Hank's argument would be, are you a chef? You can't comment on knife wounds if you're not a chef. That would be Hank's argument. Sadly, it would be.
thousands, what the results that you typically see in the wound patterns, for instance, crushing forces, broken bones, fractured bones, crushed soft tissue, things of that nature, internal bleeding. That's the province of medical exam.
Okay.
Exactly what they are trained to identify and to opine on.
Okay,
I
so
don't get into things like, for instance, what she doesn't have the experience to do is say, when a car is involved in a rollover collision, these are the mechanical forces that are exerted on the body during a rollover, and the G forces that are subject, the body is subject to a rollover, things of that nature. When a car is impacted head-on by another car, there are a number of G forces that are put on the body, etc. Those are biomechanical issues, have nothing to do with her expertise, and I wouldn't be seeking anything like that. But once the body is removed from the car, and then it's on the autopsy table, that's where her expertise begins to fly.
Okay.
She can talk about, and I believe she has the experience and the qualifications to talk about, what the body suffers at the hands of a vehicle, pedestrian, incident, or accident.
okay, so the first two sentences are out. The third sentence, she can testify that Mr. O'Keefe had no bruising on his arms or torso. And she can testify, and she cannot say that would have resulted from the impact with the SUV rear profile. She can say Mr. O'Keefe did not have bruises on his legs. She cannot say from bumper contact, but she can say as shown by dissection of leg tissue and muscle at autopsy. And she can't testify to anything else in that paragraph.
Your Honor, is the court ruling that she cannot say anything about the human body contacting a motor vehicle? That sounds like what the court's saying.
No.
I think that's too narrow a rule.
It is. You can put this in, what I said you could put in, can come in, and the rest cannot. We could,
And just for point of clarification, if I ask her, would you expect, I'm just going to make a hypothetical, would you expect if his legs were contacted by a moving vehicle, would you expect to see bruise or contusion?
what do you say about that?
I'd object, one, it's leading. Secondly,
Well, I'm not asking the question.
Secondly, this is asking to have Dr. Lapisada do accident reconstruction. She's not assessing the award. I'd ask you to consider the case of Commonwealth vs. Tompkins Appeals Court. I think we provided at 105 Mass App 1124, 2025 case. And a similar attempt was made to try to use Dr. Lapisada as a biomechanical accident reconstructionist. The trial judge did not credit her proffer and found that she failed to meet the requisite criteria pursuant to Daubert Lanigan. And so recently it's been found by at least another court that she's not competent to do this because she's a medical examiner, does not allow her to come in and start endorsing or vouching for the ARCA witnesses. They already have witnesses to do that. And so not only on page 18, going back to page 17, about the pattern injuries or corresponding injuries to a light, she would only know that if she had the training
Where,
experience.
I'm sorry, where,
You said on page 17 you would allow Mr. O'Keefe's pattern injuries on his right arm to not correspond to injuries that could have been produced by regular fractured plastic pieces impacting his arm. That's not her role as a medical examiner. That is the role of a reconstruction or biomechanical engineer. And she clearly is not competent, at least as cited by the appeals court, to have that type of opinion. And so there's one thing to assess wounds, there's another to try to correlate or draw a distinction between the wounds in a car collision. It is essentially giving an opinion to the jury, he didn't get hit by a car. That is the core fundamental theory of defense. This is simply trying to bootstrap another witness to give that opinion. That's improper.
all right, sure.
Mr. Brennan's going to cite the Tompkins case. He needs to cite the Tompkins case. That dealt with a situation in which the witness was called, and she was asked by the lawyers, specifically in that case, the people that called her, the lawyers that called her, to opine about blood-stained pattern recognition, blood spatter evidence on the driver's seat versus the passenger seat, and what her opinion was about who actually was driving the vehicle. It was a rollover collision in which people were ejected from the car. She was then asked to opine about blood-stained patterns in the driver's seat and whether that was more or less consistent with the blood, the originator of the blood, one particular individual, was he more likely in the driver's seat or the passenger seat at the time of the bleeding, and was it before or after the rollover? Very, very different set of facts. And of course, that is a biomechanical engineer's product. And the court was correct in saying, I'm not going to credit her testimony on that issue, but that's what she was asked. She opined on it, and the court said, I'm not going to credit her testimony.
All right, so-
To do with this type of analysis and wound pattern recognition, which is what she's being asked to do.
So let's see with her voir dire this morning.
Okay.
She actually was allowed to testify about blood spatter. It is the reconstruction testimony that she was not allowed to testify about.
I read the Superior Court judge's decision. I have not read the appeals court rescript, so I need to do that. I'd like to get going, but there are photographs of inside the garage. You intend to put this in through Dr. Lapisada?
No, not through
Through whom?
With regard to these photos, well, ultimately, the Lapisada will be shown them, correct? That they'll be introduced through our investigator who took the photos. We intend to call that investigator after Dr. Wolf testifies.
And what will that investigator say? These are photographs.
So he will testify to two subject areas. One would be took measurements from the street to the various entrances to 34 Fairview. He's got to testify about what those measurements were. And then where he took self photographs, we have pared them down to, I think, 3 or 4, just of one establishing shot showing the garage from the street, and then a couple of photos showing the side entrance to the garage, the pedestrian entrance to the garage, which also shows the interior of the garage, including a step and a
For what purpose? How are they relevant?
I'm sorry?
How are they relevant?
So the defense is presenting a bogus defense in this case. We are alleging that the police did not do a thorough investigation. They did not really investigate anyone other than Karen Reed. The Commonwealth's own evidence, including the testimony of Ian Griffin, is consistent with John O'Keefe after what they claim to be the trigger event in Dr. Welch's initial report. John O'Keefe walking in a westerly direction, which would be from Fairview Road to the house, taking approximately 36 steps over a distance of 25.4 meters, which is approximately 84 feet. That is consistent with him entering the house. It's consistent with him entering the garage. The police did not take photos of the garage. They didn't investigate, is there a hard surface in the garage? Is there a ridge-like surface in the garage? And these are photos are introduced on that road mission to say that there was evidence in the house. If the police only went in there, they would have seen that. And that may have sent them in a different direction. So it's relevant for that purpose.
Do you want to weigh in on this?
These are not only relevant and not material, it's misleading. They're not seeking to have measurements from the flagpole to the door. They're trying to seek measurements from the driveway to the door. There's no evidence whatsoever John O'Keefe was ever on, near, or anywhere by the driveway. The evidence is that he was at the flagpole. While the data showed there was a turn westward, it didn't show movement westward. It did not. There was a measurement from the flagpole to the garage door. That is something that I think would be appropriate. From the driveway, totally irrelevant. There's no evidence, no witness, no substantive evidence in this case that John O'Keefe went in the house, went near the house, was dropped off. They're relying simply on the fact that there were 37 steps. They have no idea what direction or where. What they want to do to argue this is to show inside the garage and then posit the theory that somehow John O'Keefe was killed in the garage, it was colder than it was in the regular house. That would account for the temperature on the battery. They have no evidence to support that. You can't use Bowden as a panacea. You can't just say Bowden, they should have done what we want them to do. It is what is reasonable. The police went into the house. They spoke to the occupants of the house.
Was it really feasible?
That Mr. O'Keefe went into the garage. You might as well take a photograph of anybody
Is it
else's
really?
garage in America and put it up in front of the jury. So this is going to create a mistaken, baseless argument that this evidence somehow shows that Mr. O'Keefe was A, in the garage, and B, he was injured in the garage. That's why they want to show Dr. Lapisada. Couldn't some of these angles have caused the injury? Total speculation, no relevance at all, and it is just prone for an opportunity to mislead this jury. This should not come in.
If I may respond in 4 ways. First of all, Mr. Brennan just informed this court that there was no evidence of movement of the phone. I'd like to quote his own witness. At 12:25:30, the device's bearing shifts to a westerly direction, as location records also show the device moving west from the roadside toward the house. So that was false. Secondly, with regard to, we should be measuring from the flagpole, our theory is not that he entered the house from the area of the flagpole. Our theory is that he was placed at that flagpole, and as Mr. Brennan correctly points out, there's no evidence that they introduced as to where he was on the road prior to walking into the house in that westerly direction. Our theory is as good as his. He cannot prove anything to contradict our theory. The third thing is that Ryan Nagel and Heather Maxson saw Karen Reed in her vehicle alone. The passenger seat was illuminated and empty. John O'Keefe was nowhere in the area of that vehicle. He was not in that vehicle. There's only one other place that he could be, and that is in the house. So finally, the fourth point, Your Honor, this court has continually always done, as the court should, a 403 analysis. The probative value we have established through their own witnesses. They called all of these witnesses, and they established the foundation for the admission of these photos. There's no unfair prejudice. I argue that anytime there's exculpatory evidence or a case that advances the defense theory, that's by definition going to prejudice the Commonwealth's case. This is not unfair prejudice. He is allowed, Mr. Brennan is allowed to cross-examine this witness and to make whatever arguments he wants to make about the likelihood
Sounds
of
fair to me.
being involved or not.
Let him cross-examine.
He should not get the benefit of the fact that his investigation, the police investigation, didn't do what we just did. And this evidence should be admitted.
The argument is purely rhetorical. There's not one fact. The officers, the witnesses that saw the car saw it in front of them. Nobody ever got out. A light on doesn't mean that he wasn't near the car because they didn't see him in the front seat. So there's no evidence that Mr. O'Keefe went anywhere near the house, on the breezeway, in the door. It is speculative. It is baseless. They want to take that baseless argument and then bootstrap it to Dr. Lapisada to further speculate that something in the garage that could have caused the injury. That is not potent. That is not a due process right. That's not 403. It's empty. It's no factual predicate whatsoever.
Okay, so,
The only other thing, just to put a cap on this, the location data circles, again, Mr. Brennan's only evidence, he introduced it, puts John O'Keefe in process.
all right, so I'm going to allow you to do the measurements. These photos will mark for identification. The photos are not admissible. So, all right, Chrissy, can you just mark those, please?
So I couldn't
All
hear.
right,
Is
let's
she
bring the
letting
jury
them in
over.
or
We will
not?
do- Mr. Jackson, how long will you be with Dr. Wolf?
There are going to be measurements? Okay.
Probably 20 minutes.
Yeah, I don't know who
and
Carl Dougal is,
depending
or
on-
Dougal is.
On that.
So-
All right, so during the morning recess, we'll do the voir
We'll
dire
get
of
to
Dr.
that.
Lapisada. All right, let's bring one over, please.
No. All right, Chad, I think we're going to move on to the jury here. But no, I think that Dr. Lapisada should be able to talk about the fucking dog bites. I mean, the entire argument there is completely preposterous. If somebody got burns, Hank would say, well, she's not a firefighter. She can't talk about burns. I mean, just this is such garbage. Let's see here today. Here we go. All right. Back to Dr. Wolf. Here we go. Oh, John's a private investigator? Okay. All right. I just couldn't tell who they were talking about because I didn't know the name.
Mr. Harmon, you're still under oath.
All right, good morning.
Good morning. All right, Chad, I'm going to be right here, but I got to step away.
All right,
for 1
Mr.
second.
Jackson, whenever you're ready.
Thank you, Your Honor. Dr. Wolf, thank you for joining us again this morning. I'd like to draw your attention to a picture. I'm going to... May I approach, John?
Yes.
I'm going to show you. You ever seen that photograph?
Yes.
Lightning Dave, I'm sorry. I can turn it down a little bit, but it becomes an issue for everybody else too, though. A lot of people can't hear it well, so I'll turn it down just a hair for you.
You were shown this photograph last week, is that right?
Correct.
By Mr. Brennan, correct?
Correct.
Do you recognize the photo as the same photo that you were shown last week?
Yes.
Under questioning by Mr. Brennan?
Yes.
And what does that appear to be a photo of, just generally?
It appears to be a photo from the test dummy from the 29 mile per hour impact
sorry.
test.
My volume. Is that
Does that
better?
appear to be a true and accurate photograph?
Is this better for you, chat? My volume. Is this better now? Sorry. StreamYard adjust it shittily once in a while. It like readjusts the sound volume. Let me know. Is it better? Your ears are now dead. Thanks. Is it better? Is my sound better, guys? Lower still or no? Because I can do a lot. This is better. No, it's too low already. Oh, well, somebody said it was loud, so I was just making sure they're all good. All right, let's keep going.
Of the condition of the dummy following that 29 mile an hour crash test?
Yes.
With the court's permission, I'd like to enter this as next in order, please. If you could hand that to the court clerk.
Exhibit 218.
Permission to present that, Your Honor?
Yes.
Is this the photograph?
Yes.
Dr. Worf, first of all, what caused the damage? Well, let's start with the most basics. Which arm is this, left or right?
This is the left arm.
What position was, you called this dummy Rescue Randy, is that right?
Correct,
What
yes.
position generally was Rescue Randy in upon impact during this test?
He was oriented such that the right side of his body and his right arm would be contacted by the vehicle.
What caused the defects in the damage to the sweatshirt as we see it here?
That was due to the interaction from the Rescue Randy sliding on the pavement surface to his position of final rest.
Is that sometimes called road rash?
Yes.
Did you see any road rash in any other place on Rescue Randy in this photograph?
Doesn't appear so in this photograph, no.
Can we highlight the face? What about there?
Sorry, I thought you were talking specific to the clothing. Yes, as I mentioned on Friday, there were signs of road rash to the body of the dummy itself, on the face and on the torso and arms.
Can we zoom in on the sleeve a little bit? Do you see any staining on the sleeve as well as the defects, the holes and the tears?
Yes.
What is that staining from?
Again, just from that sliding contact with the pavement, so it's just likely debris and kind of a film from the pavement surface being deposited onto the material.
With regard to John O'Keefe's sweatshirt that you reviewed photographs of, did you see any other defects other than the right arm and the fact that it was cut off of him medically?
No.
Any other indication or any indication whatsoever of anything that you see consistent with road rash?
No.
Okay, let's go back to full frame. The second image I'd like you to take a look at. If we could have the lights for just a second. Do you recognize what's depicted in that photograph?
Yes.
How do you recognize it?
It is the backside of the test dummy from the 29 mile per hour full-on impact test.
Which arm is featured in that photograph?
That would be the right arm.
Move that into evidence as next in order, Your Honor, with the court's permission.
Exhibit 219?
Permission to display.
Yes.
Does that appear to be the right arm of Rescue Randy as he's face down?
Yes.
Is that following the impact?
Yes.
Do you see any, were you shown this photograph by Mr. Brennan on cross-examination?
No, I was not.
Can we highlight the right sleeve just a little bit, please? Do you see that defect in the sleeve?
Yes.
Do you also see some artifacts above that defect, above and to the left?
Yes.
Can you tell what those are?
They appear to be fragments from the back window of the test vehicle when it shattered.
Does there appear to be any additional, let's go back to full frame. Does there appear to be any additional defects on that particular sleeve?
There appears to be some material transfer, likely from the pavement, and also some road rash.
Does that appear to be transferred from the pavement?
Okay, chat. Finding the fucking glass on him, that's not a good look. It's not a good look. As far as I understand, it's not exactly where it was found on John, but I'm just saying that's not a good look. The jury might put 2 and 2 together there. They might put 2 and 3 together and come up with 4. Just saying. I'm just saying. Something to think about. Something to think about.
I think that might be a shard of glass from the back window.
What was the condition of the back window after this test?
It was completely shattered.
The defect that we're looking at, that large gash, was that from road rash sliding on the pavement?
Yes.
If we can go back to the full frame, please. I'd like to show you an additional photograph. Do you recognize what's depicted in that photograph?
Yes.
What is it?
It is the front side of the test dummy from the 29 mile per hour full-on impact test.
Does that appear to be a true and accurate depiction of the condition of Rescue Randy in that sweatshirt after that 29 mile an hour impact?
Yes.
Move for the admission of that photograph, Your Honor, is next in order.
Okay. Exhibit 220?
Permission to display.
Yes.
Can you describe what we're looking at in this photograph?
This is mainly showing the upper body of the test dummy from the 29 mile an hour impact test, showing the road rash to the front side of the body.
Were you shown this photograph on cross-examination?
No.
What caused the holes in the bodice of the shirt? In other words, the part that covers the chest and the torso.
After the impact, the dummy was projected and sliding on the pavement surface. So again, this is consistent with the front side of the body making sliding contact with the pavement, creating those abrasions and holes, and again, that asphalt material transfer that you see on the front.
Can you go back to the full frame, please? Do you see additional road rash? Take a look at his right arm. You see additional road rash on Rescue Randy?
Yes,
On both the fabric and the arm itself?
correct.
Go back to full frame. And can you see his face as well in this photograph?
Yes,
Are those the chin and nose defects that you saw?
yes.
Are the defects in the shirt that you see here consistent with the condition of the shirt
So-
of John O'Keefe?
Real quick, guys, what's the relevance of this? It's to show that John would have gotten really fucked up. His arm was broken. Randy's arm was broken. Look at all the damage John has suffered. If he really got shot through the air and landed, even in the grass, his clothes would be fucking torn up and fucked with. He could have gotten, road rash depending on where he hit. There's nothing clear. There's no this is what happens when somebody gets hit by a car and thrown down the road. What happened to John that's indicative of this? Nothing. There are no injuries on John that indicate all of this. So that's the issue. The issue is he got hit and there's evidence of being hit. These other things there's no evidence of John being hit at all. So that's the relevance of all this. So how did Chloe hit him at 29 miles an hour? No, they're not. And they are going down a retarded argument of there's something about the dog biting. I still think they should have avoided all that. They shouldn't have talked about Brian Higgins wanting to sniff Karen's puss and they murdered John. They should just focus on the fact that Karen didn't hit him. Would have been a much cleaner case. Yeah, no, John had no road rash. No road rash on John at all. So. Jeff, if he was hit, he's the cleanest car crash victim I've ever seen. And I've seen a lot as an attorney. So, yeah.
Keith, as you saw it in the photographs?
It is inconsistent.
May I approach, John?
Yes.
Another photo, and I'd like to show you.
Good question. We'll get to this.
Do you recognize what's depicted in that photograph?
Yes,
What is that? We can take this down.
it is the rest position of the test dummy after the 29 mile per hour impact test.
Were you shown this on Friday?
No.
Is that a true and accurate depiction of the condition of Rescue Randy just from a different angle after that 29 mile an hour impact?
Yes.
Move for the admission of that photograph.
Okay. Exhibit 221.
Permission to display that photograph, Your Honor?
Yes.
Is this an overview of the entire body of Rescue Randy after that impact?
Yes.
Take a look at his torso, the exposed portion of his torso. Do you see road rash on his exposed torso?
Yes.
You also see that the road rash that you earlier described on the bodice of the shirt, the front of the shirt?
Yes.
And what about, let's go back to the full frame. Is there also road rash on his jeans?
Yes.
If we could go back to full frame. Have you ever heard a phrase, knocked out of your shoes?
Yes.
Where are the dummy shoes?
They're still on his feet.
And this is at an impact of 29 miles per hour, correct?
Watch the form of the question.
Sure. What was tell us one more time, what was the speed of this impact?
This was a full-on 29 mile per hour impact.
We can take that down.
Yes.
Take a look at that photograph and tell me if you recognize what's depicted in it.
Yes.
What is that?
It is
Sorry,
the back
chat.
of the test Lexus after the 29 mile per hour impact test.
Is that a true and accurate depiction of the condition of that Lexus following that 29 mile an hour impact?
Yes, and I should be more specific. It's post the 29 mile per hour impact with the test dummy, not just the arm.
Understood. Thank you. The collision that caused the damage to Rescue Randy that we've just been looking at.
Correct, yes.
Okay. Move for the admission of that photograph, Your Honor.
Okay. So 222.
Permission to display that?
Yes.
Is this the the photograph that we were just talking about?
Yes,
And this is the condition of the vehicle after that rearward impact with Rescue Randy, correct?
correct.
Did the subject vehicle photographs that you looked at, were those consistent or inconsistent with this photograph?
Those photographs were inconsistent compared to the test.
Was there anything consistent about the shirt that you were shown on Friday, the left sleeve that you were shown on Friday with John O'Keefe's actual sweatshirt?
Was any of that consistent with?
Correct. Was that consistent or inconsistent, now that you've seen all the photographs, with the condition of the shirt that John O'Keefe was wearing on January 29th?
The test clothing was inconsistent compared to that of Mr. John O'Keefe's.
Thank you. You were asked on cross-examination several times about the weight of the hybrid 3 arm. Do you recall that series of questions?
Yes,
You were asked how much lighter the hybrid 3 arm was than the static estimate arm, correct?
correct.
I want to make sure we're clear about this. The hybrid 3 arm is the physical arm that you attached to the ATD and did testing with, correct?
Correct.
The statistical estimate arm is something in the ether, right? It doesn't exist.
Sustained.
How would you describe a statistical estimate arm?
It's probably from taking a sample of the population and getting an average and a high and a low.
Okay. That's not is that a physical arm? You can touch and feel?
No,
Okay. Do you have any information based on everything that you've reviewed at all about the actual weight of John O'Keefe's right arm?
nothing in terms of a weighed measurement of the arm, no.
What was the percentage that Mr. Brennan gave you in terms of how much lighter the hybrid 3 arm was than the statistical estimate arm that he gave you?
From what I recall, I think the percentage was 26%.
Did you calculate that yourself, or did you take Mr. Brennan's word for it?
I believe I took his word for it.
Do you recall what the weight of the hybrid 3 arm was exactly?
9.38 pounds.
What is the difference, if you can calculate, what is the difference between what was the statistical estimate arm, the number that Mr. Brennan gave you?
I think I heard him say 11.8, but I also think he said at one point 11.6. So I'm not sure of the kind of the final number he landed on.
Does
Sustained is to ask the question to stop striking the end.
does 11.86 sound right?
Yes,
Okay, let's use 11.86. You have a calculator with you?
I do.
With the court's permission, could Dr. Wolf use a calculator if he needs to?
Yes.
Thank you. What's the difference between 11.86 and 9.38? Just in raw numbers?
You're looking at just the difference between those two?
Subtract
Okay.
9.38.
2.48.
Is there does that mean there's a 2.48 pound differential between the statistical estimate arm, the heavier arm, and the 9.38 arm from the hybrid 3?
Yes, that's the difference in pounds.
All right. How would you calculate how much lighter? What's the proper way to calculate how much lighter, in terms of percentage, the 9.38 arm is?
You would want to do a percent difference calculation.
Divide 2.48 by 11.86?
Sustained. Watch the form, Mr. Jackson.
How would you tell the jurors how you would calculate that percentage difference?
You would subtract the 11.86 minus the 9.38, and then you would divide by the sum of those two and divide by 2, the average of them.
Can you do that calculation?
Yes. Okay.
And what's the number?
23%.
Not 26%?
Sustained.
Is 23% smaller or, not, or larger than 26%?
Sustained. Let's move on from that, Mr. Jackson.
What is the number that you get if you were to divide 2.48 by 11.86?
0.21.
In percentages?
21%.
Thank you. Was the hybrid 3-arm 21% lighter by that calculation than the 11.86 estimate arm?
Yes.
On cross-examination, Mr. Brennan asked you several questions related to kinetic energy formula, correct?
Correct.
You referenced that. Did you reference that formula in some of your answers?
Yes.
May I approach?
Yes.
Approach. May I inquire?
Yes.
You're looking at something that's been identified, a document that's been identified as 3 X's, XXX. Do you recognize that? Oh, you're not looking at it.
Not yet.
You see it now.
Yes.
Do you recognize what that is?
It is the formula for kinetic energy.
With that, Your Honor, may we display the formula? We don't have to cut the lights. I think it'll be very obvious.
Yes.
Can we bring the lights back up and see if that's visible? Can you still see that, Dr. Wolf?
Yes.
Your Honor, is that okay?
Yes.
Great. You said this is the formula for kinetic energy, correct?
Correct.
You were asked a series of questions about whether the weight differential in the hybrid 3-arm would make a significant or material difference in your testing as it pertains to the velocity of the vehicle that you were testing. You remember those questions?
So watch the phone again. Ask a different question.
Just foundationally, were you asked about weight differential of the hybrid 3-arm?
Yes.
Were you also asked about whether it would make a material difference to the testing if you didn't adjust for the velocity?
Sustained.
What were you asked in terms of, what was the question that was posed to you about the weight of the hybrid 3-arm versus the velocity of the testing?
That there would somehow be an influence on, I think, wanting to make a reduction to the velocity of the vehicle.
Does that make mathematical sense to you?
Sustained is to that point.
Would that have a material difference? With the weight of the arm at 2.48 pounds, would that have a material difference in the testing that you were doing?
No.
Why is that?
Well, to start, that's one of the reasons why we went above and beyond the 24 miles per hour to impart significantly more kinetic energy to the arm. So if you look at that equation, it's a quadratic equation because you're squaring the velocity. So if you double the velocity, you quadruple the amount of kinetic energy. So you get a significant increase in small changes in speed because of that speed differential.
Did you do a test with just the hybrid arm, contacting the taillight at 24 miles per hour?
Yes.
Did you also do a test with that hybrid 3 arm contacting the vehicle at 29 miles per hour.
Yes.
I'd like to talk about those two tests. Okay? Can you explain to the jurors what they're looking at? I want to start with going from left to right. What does the E sub K mean in that formula?
So that stands for kinetic energy, which is the amount of energy that an object has when it's in motion and has a velocity to it.
What is the 1/2 on the other side of the equal sign?
Just a constant.
And what does the M, as in Mary, stand for?
So that would be the mass, in this case, the mass of the arm.
And what's the V, as in Victor?
That would be the velocity of the arm as it's accelerated.
Why is there an exponent at the top of the V?
Because you're squaring that. So you're basically multiplying the velocity times itself. So it'd be velocity times velocity.
Is this a formula that's traditionally used in accident reconstruction?
Yes, it's very common.
Is it sort of one of the foundational formulas? When did you learn this formula?
Probably back in high school physics.
I'm going to ask you, if you wouldn't mind, to walk the jurors through a calculation dealing with the 24-mile-an-hour test using the 11.86-pound statistical arm as an assumption of the weight of the arm.
Okay.
You
Your Honor,
understand?
may I have a pen and paper to write?
May I approach you, Your Honor?
Yes.
I have a pad here too, whatever's easiest.
Okay, whatever's easiest. If you assume the mass of 11.86, that's the statistical arm weight, and you assume the V for velocity is 24 in miles per hour. I don't care about the units, doctor. Just assume 11.86 and 24. Can you calculate this quadratic equation?
Yes.
What do you get? I want to do it step by step. What's the result of squaring 24?
So again, you're not concerned about the units?
I do not want to talk about units.
Just, okay.
If you mention the word joules, my head will explode.
That's what I didn't know if you wanted, Newton meters, foot pounds, okay.
Stop it.
So
Immediately.
just 24 squared
Correct.
is 576.
Do you always, in this calculation, do you always use the exponent first? Do you always do the square first?
Sustain.
What's the first thing that you do in solving for this equation?
You would want to square the velocity, but it's ultimately all going to be multiplied. But yes, you would square the velocity, multiply by itself.
What's the next step after you get 576?
Again, assuming we're not concerned about units, you would multiply by the 11.86.
Can you do that for me and tell me the answer?
How many decimal places do you want? Nearest whole number?
2.
Okay. 6,831.36.
What's the next step once you get that number?
You would multiply by 1/2 or 0.5.
Can you do that for us, please?
That'd be 3,415.68.
What does that represent in terms of the energy into the taillight? I realize that we're not dealing with the proper units, but does that represent anything as it relates to the energy that's imparted on the taillight?
That would be the energy to the arm
Okay,
that's being transferred.
understood. 3,415.68, is that right?
Correct.
And that was at what mile per hour?
24.
Let's move to a different equation.
Okay.
Now I'd like you to presume different numbers.
I don't know what the question is.
Can you do the same calculation using the 9.38-pound arm that you actually used in your testing for the mass?
Yes.
And can you use the velocity of the actual test you did of 29 miles per hour?
Okay. And same thing, not worried about units?
Correct.
Okay.
What's the first thing you do in solving that equation?
So if you square the 29 miles per hour, you'll get 841.
What's the next thing you do?
You multiply by 9.38,
What's the number?
7,888.58.
And what's the next thing you do in the equation?
You multiply by 1/2 or 0.5,
And what's that final number?
3,944.29.
That would be the number or the amount of energy imparted on the arm at 29. Is that right? 29 miles per hour?
So ask it to.
Sure. What is that 3,944.29 number? What does that mean in terms of the kinetic energy?
That'd be the kinetic energy that the arm has if it were moving at 29 miles per hour and weighed 9.38 pounds.
One final calculation. What is the percentage difference between 39, 44, 29 And the other test that we just did, or the other calculation, 34, 15, 68.
So in terms of a percent difference, again, when you're subtracting the two and then dividing by the sum divided by 2, so that's basically the average of the sum, it is 14% difference.
Which of the two tests, the two energy equations that you just did, which represents the higher kinetic energy imparted to the arm? The 24-mile-an-hour test, that's the hypothetical, or the actual test at 29 miles an hour? Which one?
The 29 mile per hour speed with the arm weight of 9.38.
What does that mean, Dr. Wolf, in terms of the testing that you did with the lighter arm, 9.38 pound arm, at the 29 mile an hour test, as it compares to the hypothetical 24 mile an hour test?
It would be more force and more energy in the 29 mile per hour impact test.
Even though you used a lighter arm? Objection.
Sustained.
And what was your opinion and conclusion as it pertained to the subject taillight using the 29 mile an hour test? What was your opinion and conclusion as it pertains to the subject taillight? Was that consistent or inconsistent with the damage that you saw on the 29 mile an hour test?
It was inconsistent.
Thank you, Your Honor. That's all I have.
Okay, sorry, chat. My other monitor's gone down. I'm trying to figure out what happened. So it's the one over here, not the main one. Overall, he did a pretty good job of rehabilitating. He did a good job at rehabilitating. I think for a lot of the jury, they probably forgot what happened over the weekend. So it's kind of like, they're just moving forward there. Am I checking the cables? Yes, right now I am. So we'll be working on it. And you guys asked a bunch of questions and made some comments here. We're going to take a look at those in a little bit. Real quick, though, Sweet Tooth Fairy's been a member for 26 months. Thank you, Sweet Tooth. Saying, I'd like a 26-month celebratory Clyde Awoo, please. We don't know how to make him do that. He does what he wants to, but we'll try. We'll try later. I do like to comment, Randy had a wife and 10 kids. I know. F in the chats for Randy, guys. So, Eric says, the defense have to offer an alternative theory. No, they never have to. You never have an obligation because, remember, the burden's on the state. Now, they're hoping they can offer an alternative theory that they can... Remember, you're selling something. In this case, you're selling a theory to the jury of, hey, here's our theory of what happened. Buy this theory versus their theory. The problem is, when you're selling a competing product, you better win, because if they don't buy what you're selling, you're fucked. It's really hard to then turn around and say, well, hey, but their shit sucks too. The jury's not, you're kind of toast. That's why I've said I've had problems with this whole Karen Reed was framed thing and all that. Like, I think that's a horrible sell. And I know, like when I said on the mic, I said on the Young Jerks, like, you're not going to get a jury to buy the murder. I don't think you will. Now, I think it's a great idea to show those marks on his arm are weird and they don't match up and the state can't tell you why it happened. Therefore, reasonable doubt. I think that's correct. Show it was a dog and leave the jury to figure out what happened with the dog. I think that's a great idea. But the rest of it, though, I don't think is going to do it there. Now, same difference saying he can't do it in his head. He probably can, but here's the problem. Hank's going to be sitting on the calculator, and if you don't have it right, you know what Hank does? Isn't it true you're off by a decimal point? And then Hank would go, and if he says yes, Hank will go, some engineer you are. Like, just doing the math, just doing it right, making sure it's good. He's an engineer. He's going to do it the right way. I'd rather him do it that way than, like once you get into complex things, it becomes an issue. So I think it's correct. I think it's correct to do it that way. Ag Biochemist has been a member for 26 months as well. And also, Sweet Tooth, you and Ag, 26 months. That's crazy numbers, humbling numbers, really. Ag says physics rules, bitch. Yes, yeah, science. Yeah, so we'll see from there. Let's see. There's another one I want to get to right now. We'll keep going from here. But those are some good questions, guys. If you guys are new, put your questions out there. You don't have to do, like, if you do a super chat, it's great. But if you don't, I'm definitely going to answer them anyway. If they're good questions, I try to catch them. So, let's see here. All right, we're going to keep going. Here we go, chat. Here comes it.
May I, Your Honor?
Yes.
Good morning, Doctor.
Good morning.
Doctor, did you have a chance to speak to anybody from the defense this weekend?
Not over the weekend, no.
After you left here Friday?
On Friday, I let them know that I was returning back home, and then I let them know last night that I had arrived, yes.
Did you receive any new information or have any conversation before you came in today?
No.
Now, when we asked you about weight last week, you did not go into any calculations about the difference between the standard arm, 11.86, and the 9.38, did you?
I don't believe we did, no.
In fact, when you testified last week, at the end of the day, you were asked questions by Attorney Jackson about the weight of that arm, correct?
Yes.
And when you were asked about the weight of the arm, Attorney Jackson asked you if you were asked a lot of questions about the difference in the weight of the arm, about 11.8 pounds statistically as it relates to Mr. O'Keefe versus 9.4 pounds. Do you remember him asking you about that?
Yes.
And you were asked whether you were aware whether anybody had measured the weight of John O'Keefe's right arm. And you responded, I'm not aware of that, no. Remember that testimony?
Yes.
And then you were asked, when you asked questions about whether or not his arm was 11.8 pounds, are you aware of anybody ever just weighing just his arm? And you said no.
Correct.
And finally, you were asked, what is that based on, 11.8? Where did that come from? Remember what you said?
Yes.
I don't know. Remember you answered Attorney Jackson and you said, I don't know where that came from.
Right, referring to, I don't know what source you pulled that 11.8 from.
Uh-huh. And so you were suggesting that that is just a number pulled out of thin air, right? Was that a surprising estimate, 11.8 to you?
I don't know that it was surprising. I don't know what your source is for it.
Well, when you engage in accident reconstruction, you never just take somebody's limb and sever it and throw it on a scale, do you?
I'm not usually doing that part of the analysis, no.
So when you're relying on body weight and different parts of the body, there is strong statistical studies that give you a guide, isn't there?
I would agree with that, yes.
Well, the numbers just out of thin air. If you're doing a study and you have to figure out damage to an arm or a foot or a leg, and you have to come to an estimated value or weight, you have to get that information from somewhere, don't you?
I would agree, yes.
So you just make it up out of thin air. You have to find a resource, a reliable, vetted resource. True?
I would agree.
And that's what you do.
In some instances, yes.
Well, in this case, you chose an arm that was 9.38 pounds. Where did you get the support that the 216-pound, 6'1" man would have an arm that weighs 9.38 pounds? Where did you get that from?
Well, it's conservative from the standpoint, if you think about one of the equations we talked about last week, force is equal to mass times acceleration. So if we take the acceleration data from our test and we multiply it by a lighter mass, the 9.38 pounds, it's less force to the arm. So now if you want to increase the mass of the arm, you're now talking about a greater net force to the arm. So it's conservative from a force perspective.
Put aside your story about the force perspective. My specific question is...
So it's sustained. Ask the question
Thank you.
differently.
I'll ask you again, Doctor. Tell us where you got the 9.38-pound value from when considering a 6'1", 216-pound man. Where did you get that from so you could be statistically accurate?
It is the mass of the hybrid 3-arm. We saw the photograph that depicted the weight. Again, how you account for that when you're doing the force calculations is you would utilize the acceleration data that we measured, and then you would apply a different mass, in this case, a heavier arm. And I will note, it's the same thing that Dr. Welcher did in his drop test with the hybrid 3 head. He ultimately measured the acceleration of the head, and then to calculate the force, he adjusted the mass of according to Mr. John O'Keefe's mass of his head.
So for the third time, I'm going to ask you just a very simple question. Dumb it down for me if you can, okay, doctor? Where did you get the source to legitimize using a 9.38 pound arm for a person that's 6'1", 216 pounds? Where did your source to say that arm is validated to use for that size man? Where is that?
Again, it's the weight of the ATD arm. That is what the 50th percentile arm weighs. As I mentioned, in our field, it's accepted to utilize the acceleration data, and then you adjust the force based upon an increase in mass.
Is that your answer?
Yes.
Mr. O'Keefe's body weight and size does not put him in the 50th percentile like the 9.38 arm. He's closer to the 95 percentile, isn't that fair to say?
Correct.
And there is, in fact, the 95 percentile crash test dummy, isn't there?
There is, yes.
Yeah. You chose the 50 percentile, which is shorter, yes?
Correct.
Weighs less, yes?
Correct.
And the arm weighs less, true?
Correct.
The truth is you have absolutely no study, no paper, no article that supports using a 9.38 arm for a 216-pound man who's 6'1". You have not one reference or study you can offer us right now, do you?
I don't agree with that, because again, if you look how Dr. Welcher did it, he used the 50th percentile in his drop test with the head, and to calculate the force, he adjusted for Mr. John O'Keefe's mass of the head. Same thing is done in this instance with the lighter arm. We adjust for that in the calculations.
So you have one paper, one study. I know the answer to this, but let me ask. You have one paper, one study to support that it is appropriate to use the 50 percentile 9.38 arm for a person who is 6'1", 216 pounds. I won't ask you again, but if you can answer this once for me. Do you have one paper, one study?
So I'll take out the commentary. Can you answer that, or answer that question, please?
Sorry, can you repeat the question?
You have one paper. Give me a name, an author. One paper, one study that supports using a 9.38 arm, 50 percentile, when you're doing a crash test for somebody who's in the 95th percentile who weighs 216 pounds and is 6'1". One paper, sir.
I don't have a paper because Dr. Rentschler is addressing the forces and the injuries to the arm.
You talked about, however, would you come up with the number 11.8? Like it was something that is curious or foreign to you, right?
Objection.
Sustained.
Are you confused how the number 11.8 would come up?
Objection.
I'm going to allow that.
I'm not confused, I don't know your source for it.
When you do studies, would you agree that the head has a similar weight to the arm and that the weight of an arm would be about 5.48% of a person's body weight?
All right, guys. So far, yes. Wolf is doing a great job at battling back on Hank. This was actually masterfully done, is fighting back. Yeah, I mean, it's funny because he says, like, well, I'm doing the exact thing Mulcher did, but do you have an answer? Like, I'm doing the same thing your expert did, too. And once the guy says that, Hank really needs to be careful. Because now he's saying, I did exactly what your expert did. You know, we're doing because here's the point. It's an acceptable industry standard of research and testing. I mean, that's the issue here. Yeah, and that's the point. Welcher used the wrong head, too. And LK, well, this is where, is there one paper that shows for it? This is where Jackson has to be able to fight back and help, and I don't know if there is one. Here's the problem. There isn't always a paper on every bit of that subject. Like, there's a lot of papers done, but there might not be one for this as part of the problem here. So, Marco says, I would support Welcher because he's got no dog in the fight. No, he does. He's getting paid by Hank. This guy right here. This guy got paid by the FBI before he even heard of Karen Reed. This guy rendered a report before Karen Reed was, going to trial. This guy rendered a report before Karen Reed ever retained him or hired him. This guy did his report in the blind, not knowing what it was going to do. He didn't have a dog in the fight. I mean, his initial report, are you saying that was wrong, Mark? His initial report was wrong? I mean, saying you have no dog in the fight, motherfucker's getting paid. This guy had no dog in the fight when he did his reports. I mean, let's be real, honey. Honey. Let's be real. Let's be real about that. I'm just saying, sweetie. Like this right here, this is one of those honey moments. Honey. Come on now. Come on now, honey. Honey, come on now. Come on now, baby. You got this. I know it. I believe in you.
I'm sure that there's various studies out there that talk about that. Could be one particular study.
Well, let's talk about one study. What do you think? You're the engineer. You're the expert.
Well, now we're just like, oh, we're shifted. Oh no, they're shooting back. Shift fire right. No, baby. Come back here, honey. No. Stay right here, honey. Focus on that prompt. Focus on that prompt from before, honey. Honey, you got to get that prompt right. We're back here, baby. We're back here now. We're back here to have a no dog in the fight, honey. Come on now, honey. Let's go right here. You don't, no. You dug in. I'm still here, baby. I'm still standing. I'm a big fat guy. I ain't moving that fast. We're on the street corner. I mean, if you're gonna give the corner up, that's fine. You can take the L's, but you have to tell me you want the L's. Why did ARCA not apply the text stream, Jada? Are they supposed to be experts in text stream? They didn't use that expert. I don't know. Maybe because they looked at it and realized this is all fucking retarded. I bet that's the answer. If you asked ARCA, like, they talked to their crash experts here and they're like, what happened? And Rentschler and Wolf are like, these guys are fucking retarded. And they're like, good enough. We're not going to waste money and time. Because unlike the Commonwealth, Karen's checkbook isn't unlimited. There's a big difference. Also remember, too, whose burden is this? I mean, you're right, though, Mark. Instead, we trust the text stream data from Hillbilly Jim. So, once again, don't trust that Schamberg guy. By golly. He reprogrammed his cousin's VCR. That's who you trust. That's who you trust. That's who you trust. I guess, man. Unhung hero for 20 subs. Let's go, chat. Let's go. And Marco, you still can't explain why John O'Keefe doesn't have any injuries. That's a big one, buddy. Still the biggest one of all. Karen could say she hit him, and if John's got no proof he got hit, then how did she hit him if there's no proof she hit him? Still the one thing, you guys, nobody can explain. There's this magical car accident that nobody gets hit with. I don't know. Anyways, let's keep going, chat.
When you're weighing an arm by percent, what is the percent of the arm of the total body weight?
I don't know as I sit here today off the top of my head, no.
I'm sorry?
I don't know as I sit here today off the top of my head.
Well, if you don't know the percent of body weight of the arm compared to the whole body, how would you ever come up with a number for the arm?
Well, from the work that I've done with Dr. Rentschler in this case, dating back to last year, it's my understanding that his calculation for the arm was approximately 11 pounds.
So you're relying on somebody else's study? You're doing an independent assessment of the evidence, and you're relying on other people's math? Is that what you're telling us?
You don't actually know that because you don't know what speed he got hit. So, like, now you're just making shit up, but okay. We actually don't. Because if she hit John, she could have kept going at any point on that road. You don't actually know. Mark, you can't prove it. The defense can't prove it. So I don't know what to tell you, honey. The prosecutor can't prove it. Welcher doesn't know. Honey, no one knows. If you knew, I don't understand why you didn't go ride into Hank's office and go, Daddy Hank, can I play with your wiener while you read my math? Let Daddy Judson check it out. If you knew this and you're not riding to the rescue, buddy, there's money on the table. You could have felt it, Arca, but here you sit talking to me. Seems a little tardo, but okay. Like, you're in Massachusetts. Go now. Save it. Break the story. I'm just saying. Like, go prove it in court. You still can't prove why John doesn't have injuries, so you still can't prove that. Prove to me why John doesn't have injuries. I've been beaten, except it. Yeah. Oh, yeah. Oh, well. Let's keep going. Thank you for being here, Mark. I appreciate your comments.
I don't agree with that because, as I've mentioned numerous times, Dr. Rentschler and I worked as a team on this case. You can't separate the reconstruction part from the biomechanical part. It's an integral part that works together on it.
Would you agree that the arm is about statistically vetted, that it's 5.48% of the total body weight? Would you agree with that?
It sounds about right, but again, I don't
Okay.
have the percentage off
So
the
if
top
you
of my
take 5.48% of a 171-pound man, which is the crash test dummy you were using, the 50 percentile, what do you get?
You said 5.48%?
Yeah.
Just over 9 pounds.
Okay. Close to 9.38?
9.37.
Okay. Now when you have 216 pounds, 5.48%,
11.8.
11.8. Sound about right, doctor?
By that calculation, yes.
Okay. Now, you said you had some confusion where I'd get that number from, this 11.8. Do you remember that?
Yes.
And when I threw out that number, is that the first time you heard of that number?
The 11.8?
Yeah.
Yes.
Or 11, is that the first time you heard of it from anybody, 11 pounds? Is that a new number to you?
I don't understand your question.
Well, you're saying that when Attorney Jackson asked you where did Brennan get those numbers from, you said, I don't know. Remember that on
Correct.
Friday? Do you know where I got the number 11 pounds from?
11.8
Yeah.
or 11?
11.
As I just mentioned, last year, I believe I testified in a previous proceeding that it was about 11 pounds.
Yes. Your testimony, 11 pounds. Your prior testimony, right?
Yes,
You testified before under oath in this case, didn't you?
correct.
And when you testified under oath and you were giving a general estimate about the pounds of Mr. O'Keefe's arm, based on your experience and your training, you said it was around 11 pounds. Those are your words, right?
Correct, yes.
Under oath.
Yes.
Right. You can't delete something that's under oath, right?
Sustained.
And so when you feigned confusion on Friday about this 11 pounds,
Sustained.
so when you answered questions last Friday about wherever this 11.8 pounds came from, you weren't so confused about that because you've used 11 pounds before yourself, haven't you?
Yes, but again, I don't know where you got that 11.8 from, so.
Well, we just
but-
did the math, didn't we?
Yes,
Okay. And you used a calculator to help you, didn't you?
I did, yes.
Calculator works.
Yes.
Okay. You said you wouldn't calculate the difference, but you did. And so what you just went through this exercise is you divided that difference, that 2.48 pound difference, right?
Correct.
And then you divided it by 11.86. Divide 2.48 by from the 9.38.
Okay,
What percentage do you get?
26.
Would you agree with this statement about whether the arm and body weight, comparing the weight of the head to the arm, would you agree that the head and arm are actually almost identical because your arm, just one of your arms, including the hand, forearm, and upper arm, is about 5% of your total body weight? So for someone who weighs 216 pounds, that's about 10.8 pounds. Would you agree with that?
I didn't do that calculation, so
Didn't ask you. I'm asking if you would agree with that.
can you repeat the question, please?
So ask the question.
Does the arm weigh the same as the head? Or the arm does weigh the same as the head, almost identical, because your arm, just one of the arms, including the hand, forearm, and upper arm, is about 5% of your total body weight. So for someone who weighs 216 pounds, that comes out to about 10.8 pounds. Would you agree with that?
I haven't done the calculation, but if the math checks, then yes.
Okay. Would you agree with this statement? The heavier the object, if it gets hit center mass, that's going to be even greater force, because that is more mass than just 11 pounds. So the acceleration is the same for each body part. It just depends on the weight of the body part and how heavy it is to determine the force that's actually exerted on the body. Do you agree with that?
Objection. Source.
I'm going to allow the question.
Do you agree with that?
Yes, and I think I described that a little bit earlier, is you would increase the mass, you multiply it by the acceleration, that's going to increase your force. Force is equal to mass times acceleration.
Right. So mass has a direct correlation to force. You agree?
Correct.
So therefore, the heavier the object, if it's colliding at the same speed, will create more force than a lighter object. You'd agree with that, wouldn't you?
Correct. More force on the arm, yes.
Right. So weight matters, doesn't it, sir?
Yes.
Force is mass times acceleration. So if the arm weighs the same as the head, you're still going to get the same force. And so inevitably, you change the mass, you change the weight, same speed, it changes the amount of force.
Correct, yes.
Yeah. Okay. When you did calculations in this case, you never took the estimate of 11 pounds, although it didn't exactly calculate the 5.48. You never took that 11 pounds and determined the percentage difference between the mass in that arm and the mass in a 9.38 pound arm, did you?
No, I did not.
You didn't include it in any of your PowerPoints.
No.
You didn't explain it to the jury that there's a difference in weight matters.
Again, that's something that Dr. Rentschler is going to discuss.
I'm asking you because you testified, you gave opinions, you got a PowerPoint. Did you explain to the jury about the difference
I will say this
in
much.
force when there's a change in weight? When you did all
I mean, yes, Mark, he is actually bringing things up. Here's the problem. I don't think he's a hack, but you realize Hank probably could have got there without acting like a douche nozzling fuck nugget. He could have just been like, your numbers aren't right, right? And just gone through all of that. He could have just done that whole thing. He wasted 10 minutes of getting sustained, asking a question, getting sustained, asking a question, getting sustained. He could have done this and been more effective. This is an effective question, but it's a sloppy cross. He is a hack. Honey, honey, what are you doing? Huh? Honey, you're on here with me. I'm just telling you. Open your mind to the evidence. Once again, why is John's arm not broken, Mark? Why is John's arm not broken? Why are there no marks on John? That's a critical piece of evidence you still can't explain. You still can't explain. But no, I want to point this out right here. Getting to this point is actually very, very good cross. Spending 10 minutes of going through that looking like a big asshole cycle, I don't know what that did for Hank. Once again, I think Hank is stuck in defense attorney mode and isn't smart enough to handle that. Hey, Mark, this is the last time I'm going to highlight your post tonight. You know what that means? That's reasonable doubt. If you don't know, that's reasonable doubt. I understand you might be an engineer and you know math, but honey, I'm here to teach you about law. That's reasonable doubt. So you don't have to worry about equations. We don't have to know about Pascal's dildo conservation formula. No, this is reasonable doubt. It's doubt. And is it reasonable? Yes. We don't know if he got injured. So there you go. This right here. Reasonable doubt. So thank you, Mark. You ran right into it. You ran right into it, sweetheart. So good. Tastes so good.
all your PowerPoint and calculations. Did you break it down for them?
Well, I think it was certainly stated. I mean, I know that we went over Newton's second law, force is equal to mass times acceleration, right? So if you increase that mass number, it will increase the force.
When you were putting up your PowerPoints with the speeds, did you explain to us that there's a difference when you change the mass, so that if you used a lighter arm, there would be a difference in force? Did you explain that to us in any of your slides?
I don't know that I explicitly stated it, but again, that's why we went up to 29 miles per hour to account for that difference in weight.
Were you trying to inflate the force for the speed of test so it looked like the collision had to happen at a faster speed to cause a certain amount of damage? Were you doing that intentionally?
No.
You didn't overstate the mass. You didn't use an arm that was 14 pounds that would have created the opposite illusion, right? You used a weight that was lighter than Mr. O'Keefe's estimated arm.
Right, because again, it goes both ways. If you increase the mass of the arm, you increase the force on the arm. So there's going to be more force acting on the arm.
Let's talk about your studies with Mr. O'Keefe's sweatshirt and his arm, and you gave some opinions about what you would expect for damage to his arm. When I asked you on Friday whether you had any support, any vetted journals, learned treatise, any support whatsoever about whether you should use a crash test dummy arm for these types of studies, you didn't have any support on Friday. Do you have any today that you can refer to?
No.
Putting aside the fact that you have absolutely no professional studies or journals to support that you should be using a crash test dummy's arm for these types of tests, are you aware of the expert literature in this case that the opposite, you specifically should not use crash test dummies when you're trying to do this type of analysis on clothing and a person's body? Are you aware whether that exists?
I'm not aware of those studies, no.
As a inquisitive engineer, wouldn't you want to know if there was legitimate studies in your work, in your profession, that suggest or states that you should not be using crash test dummies to determine injury to the arm as far as lacerations? Would you want to know that?
I think, again, you're getting confused between my role and Dr. Wren. Can I finish, please?
No.
Okay, so
No.
no comment, Mr. Brennan. Answer the question, please.
I wasn't addressing the lacerations or the abrasions to the arm, sir.
You had photographs and you were opining that you would have expected or you would not expect there to be abrasions or cuts on that clothing in your test A and B, didn't you?
There were no holes or cuts in the material, no.
I understand, but you offered opinions. Didn't you offer to the jury an opinion that the abrasions on Mr. O'Keefe's arm were inconsistent with your tests in A and B?
The cuts and the holes are inconsistent.
Sir, when you are assessing cuts and holes on clothing, you need to make sure the predicate as a basis that you're using the right properties, right?
I would agree with that.
And so if there was literature directing that you should not use a crash test dummy to assess injury on an arm, would you follow that instruction or would you do it anyways?
Again, you keep saying injury to the arm. I was looking at what happens to the material when it makes contact with the taillight.
A crash test dummy's arm is harder than a human arm, isn't it?
Yes.
You push a human arm, it's like an indent. You can push in, can't you?
Yes.
And that property of pushing in, if a cloth is on it, it is easier for a cloth to tear pushing in than if it's hard, isn't it?
I don't know that I agree with that.
Well, do you disagree with that?
Well, the hybrid arm is of vinyl flesh, so it's not rigid.
Do you disagree with what I just said?
Can you repeat your question?
Sure. Human arm, softer than the hybrid, yes?
Yes.
When you push it, you can push in, much different than the hybrid arm, which is stiffer, yes?
I don't know what you mean by much different, but there will be a difference, yes.
Well, is it a noticeable difference to you if you push a hybrid arm as opposed to a human arm?
Yes.
When you push a human arm, it indents, yes?
Correct.
And so if you push with cloth on, the cloth indents, yes?
Correct.
Which creates an easier, tear in the fabric with less force if you can push in as opposed to a hard arm. Would you agree or disagree with that?
I would agree with that.
So when you're replicating studies and giving opinions about a person's arm, a real person's arm, using a hybrid arm doesn't seem to be an appropriate standard, does it?
I don't agree with that because, again, when the taillight breaks in the test, the arm is now moving with that taillight. So it's, again, like we talked about on Friday, you'd somehow have to have those fragments accelerating at a greater velocity to penetrate that.
We're going to get to that, but I'm talking about the stiffness. Let's get back to the appropriateness of using a crash test dummy. Now conceding that a human, it pushes different than the crash test dummy, would you agree that a crash test dummy is not an appropriate tool to use when determining tears in clothing on somebody's arm? Would you agree?
I don't think I would agree with that, no.
When you used the crash test dummy in test A and B, that was the 5'9" dummy?
Yes.
When you considered tears to clothing, you bought a new sweatshirt that was similar to Mr. O'Keefe's, an extra large sweatshirt?
Don't know if I recall the exact size, but I think one of them might have been extra large.
And then you bought a second one that was medium. So when you used the smaller dummy, you weren't actually using Mr. O'Keefe's size of extra large, you used a medium sweatshirt, yes?
Yes.
Because it was a smaller dummy than the size of Mr. O'Keefe. That's why you needed a smaller sweatshirt, yes?
I think it was more or less just what we could get our hands on.
Well, you had an extra large and a medium. You didn't put the extra large on in tests A and B, did you?
I don't recall off the top of my head what sizes were on each test.
Okay, could we show a picture of A to remind Dr. Wolf? And while she's pulling that up, is there a difference between, see that's how that's blue? You see that's medium?
Yes,
So the blue ones that you use for test A and B, correct?
correct.
The smaller crash test dummy than Mr. O'Keefe, the 5'9" crash test dummy, yes?
Correct.
And then when you used Randy and brought him into the scene, you used the extra large, the gray one.
Correct.
Right, so you used a different one because it was a smaller anatomical doll than the size of Mr. O'Keefe, yes?
We used different sizes. The material blend was the same.
This was new.
Correct.
The extra large you put on Randy was new.
Correct.
Did you consider the wear and tear on Mr. O'Keefe's sweatshirt, the extra large sweatshirt he was wearing that night?
The wear and tear?
Yes, the wear and tear.
No.
Did you ever consider the differences between a brand new sweatshirt and one that had been worn?
No.
Had you ever had clothing, sweatshirt you used repeatedly, maybe put in the dryer, wears it down, sometimes you can get holes more easily? Did you do any type of analysis on that whatsoever? Any type of analysis whatsoever on the age or whether it's stretched the same, anything like that?
No.
No variables whatsoever on the sweater, did you?
No.
Okay. Does it matter whether or not the sweatshirt is tighter or looser or how it fits the body? Is that any part of your consideration?
No.
Have you ever done testing like this before for clothing?
In terms of impacting a taillight?
Yes.
No.
So this is the first time ever that you've done this type of analysis and offered an opinion in front of a jury on this?
Specific to impacting an arm with a taillight, yes.
Before you decided to come in and give an opinion, did you take any study or look at any journals on fabrics?
No.
Did you consider any of the variables that one would want to consider regarding fabrics before you came in and gave this opinion?
No.
Did it concern you when you were coming in to give a professional opinion about something you've never done before, whether or not you were studied in the area before you did it?
Well, I think I relayed my observations from the test, right? I certainly explained how we set up the arm, how the arm was closed. You all obviously saw the impact testing to the arm, so I'm relaying my observations from the test that we did.
Did it concern you that you were coming in to give an opinion on something you have never done before, and that you did absolutely no study on fabrics or any of other people's analysis on fabrics and cutting? Did that concern you?
No.
So you were comfortable just coming in with no experience in this whatsoever, without even studying or doing any research? You were comfortable to come in and just throw out an opinion?
No, again, and Dr. Rentschler is going to address part of this. Again, we worked as a team, so there's a synergy between the two of us.
Well, putting aside the synergy, you're the one on the stand under oath, yep?
Correct.
You're the one testifying, giving opinions to this jury, yes?
Yes.
You're the one asking them to rely on your experience and training, true?
Correct.
You're the one asking them to rely on your judgment and your effort to be accurate, yes?
Yes.
So when you give the opinion, you have a personal responsibility to support that opinion. Putting aside Dr. Welcher or Dr. Rentschler, you have responsibility for your opinion, don't you?
I would generally agree with that, yes.
Generally?
Yes.
When wouldn't you? When would not be general? Don't you have an obligation every single time you take the stand and give an opinion to be supported, valued, vetted?
Yes,
single time?
and again, Dr. Rentschler is addressing those abrasions and lacerations, which certainly correspond to the material.
But you didn't wait for Dr. Rentschler. You offered a number of opinions to this jury. You personally, under your name, you came in and presented yourself as an expert in this subject. You, didn't you?
Correct.
So putting aside Dr. Rentschler, his opinions, do you stand behind your opinions?
Yes.
Okay. And you do that despite the fact you've done no study, no research, haven't vetted, and have no authority whatsoever?
Yes.
You wrote a report back on February 12, 2024.
Correct.
In February 12, 2024, do you remember talking about injuries to the arm and damage to the taillight?
Generally, yes.
Okay, that's fair. Do you remember writing in a report, it is significant to note that the injuries have been classified as abrasions and analysis of the autopsy photographs indicates minimal bleeding or lacerations of the dermis?
So the report that you're referring to is a joint report authored by myself, Dr. Rentschler, and Mr. Scott Klein. So that would have been a portion drafted by Dr. Rentschler addressing the injuries.
I see. So in this report, it has your name, Dr. Rentschler, and another person, Scott Klein, yes?
Correct.
But in the report, none of you ever differentiate which opinions you're standing behind or somebody else's, right? I'll move on.
The objection sustained.
I'll move on.
The objection sustained.
Did you agree with that?
Sustained.
Did you write or endorse these injuries would not result from impact with a non-damaged tail lamp cover and the amount of force required to fracture the tail light cover?
So I'm going to see you in Sidebar.
Okay, chat. Here's a problem. At times, does it look like he's fine? Maybe, but here's the thing: how is he cooked with a jury? I don't think you could say that. We don't actually know. Like some of you say, "Oh, the jury was laughing." Were they laughing at Hank or were they laughing at Wolf? I don't think that's been clear or established. So remember what I told you guys. You know, like you see, all you're seeing is footage of a soccer ball sailing into an empty net. You don't know which team's net that is right now. Okay. So I'm trying to tell you, be careful. Like I said, Hank has asked a lot of good questions here. Hank has brought up a lot of very good points. 2.0 is doing dog things with the dogs. God, that sounded bad the way I said it. 2.0 is taking care of the doggos. Hank has asked a lot of questions, but Hank diminishes every good point he asked by acting like a dickhead. Remember, there are times where you can act like a dickhead, but you can overplay it. Like I said, Hank has asked a lot of good questions here on Recross. But he's acted like such an asshole, I don't know if those have washed itself out. If they haven't, then Hank is doing very, very well here. So. Well, Tracy says, according to Larry, the jury's fed up with the Commonwealth. I mean, was Larry there today? Because I'm a little like, one day isn't enough. And I mean, yeah, we're on day 29. Like, I'd like to think so, but I am not 100% sure this is done. And yes, Nova's right. I don't even have a micro peen counter. I mean, who can you trust? Who can you trust, chat? Who can you trust? No, gangster, I understand the judge is literally like the jury is done, but we don't know what that means. Yes, are you sure you're an expert line? Yes. I think that's funny Hank would ask that. Like I said, guys, you have to be careful when you do this. Because Hank's trying to do that. Well, are you really gonna You literally have the problem with them is Hank literally proffered an expert that lied about going to college. And apparently is too retarded to get a college degree. It sounded like Hillbilly Jim, the yokel man. So Hank has to be, once again, you have to be very careful. But we'll see how I'm really curious to see what the jury thought. The jury, like I said before, guys, the jury might look at Hank and go, I didn't even bother. I didn't have time to think about Hank. I was just focused on the trial. Time will tell. Time will tell, chat. Oh my God, have I been muted this whole time? Oh my God, have I been muted? Oh, Jesus Christ, I've been muted this whole time? Oh no. Gotta figure out what I was gonna say now. Well, that's when I don't have my second screen up. I can't see. I don't know what happened. It went down. So here's where we are. Hank has asked a lot of good questions. I'm the worst blogger ever, I know. Hank has asked a lot of good questions. Did you guys hear me on that part? That every time he asks a question, he shits on it by acting like an asshole. So I don't know where this is going. Yes, the second tower was hit. So hold the L. I'm keeping the L's in my pocket. But yes, Paul is looking at them like Paul sit in law house for a month. Paul want to go to park. Paul not like law house no more. Karen lady live at law house. So what would I say here? Several minutes on mute. Fuck. Okay. So ultimately, the whole thing about Larry, I trust Larry's judgment that the jury is getting tired. I just naturally do. I'm an attorney. That's what I do. I trust his judgment. I hope it's right. I hope these juries are getting put off by Hank and the way he's acting. But they also cannot be. I mean, remember, they're laughing. But what are they laughing at? Who are they laughing at? Remember, you guys are watching a ball. You're watching a ball. Oh, that was weird. You're watching a ball sail into a net. And you don't know which net it is. And that's a problem. That's a very big problem for us. We don't know what net we're looking at. And I don't know why my camera's moving around here, but that was weird. Anyway, that's kind of our situation. We don't know what's happening. So why am I? Whatever. I'll worry about the camera in a second here. So hit the like button for more mute. Yes. So I've really been muted for like this whole time. Okay, well. Yes, Karen lady live at Law House. Paul think. Oh. But yeah, I think it's, you guys have to be careful. We don't know. And honestly, Hank has done I told you this. Hank has done a pretty good job at being able to counteract what's out there. Now, you may think it's all bullshit, but it only matters, is the jury buying it? So, Trace says, it's crazy to hear about all of our opinions and how different they are. Well, that's the thing. You could put, you put 10 attorneys in a room and you get 30 opinions. I mean, there's a lot to think about here. I think this is a lot closer than a lot of people think. And I still think right now, if you told me I had to bet on the outcomes, outcome number 1, hung jury. Hung jury. I think that's a likely outcome here. Outcome number 2, she gets convicted of a lesser included offense. Outcome number 3 and 4 are going to be tied. Guilty and acquittal. Guilty and acquittal, I think, are 1 and 2. So, it's kind of what I'm thinking here, guys. That's kind of what I'm thinking. So, yeah. This ain't soccer, I understand, but you guys see Hank kicking a ball into you guys see, like, the jury's, like, you're just seeing the ball go into a net. I don't know if the jury's seeing that go into Hank's net or Karen's net. We don't know. So, by a lesser offense, do you mean manslaughter? Yeah, or the DUI and leaving the scene of an accident causing a death. That's what I think that, like, that's a very good likelihood. That's number 2 on the list. So, yeah, it's my lock of the week. Sure, you can keep that. Write that down now, chat. Hung jury, lesser included, and then I'm kind of like on guilty or acquittal. I think it's going to be either mistrial or a lesser. I think it's going to be a mistrial or a lesser. Yes, acquitted means she's all the way done, but I don't think it's going to happen. Joe, you bring up a great question here, and I'm going to touch on this. Not taking x-ray seems like a big deal. Here's the problem, though. A medical examiner can look, generally, a highly trained medical examiner would look and say, hey, is that guy got a broken arm or not? You could generally tell because there are other injuries or indicators present on a broken arm, especially something like this where you're in a motor vehicle accident, because there's like your arm's all flipped around. Okay, well, broken arm. You got a green stick fracture. There's massive discoloration and bruising and internal marks and damage where he got hit. Those would all be indicators. So the fact that they didn't examine it because they didn't think there was a broken arm. It's a clear answer. Why didn't you check it? I didn't think he had a broken arm. I looked at it. They probably picked his arm up and it didn't feel broken. And it wouldn't just be like a little crack. This would be like significant bone breakage, and you can tell when the linkage isn't there. So I don't think that would have been an issue. They just didn't think there was a broken arm. I think that's clear. There would be deep bruising. There might be. Maybe not. But there were no indicators of a broken arm. I mean, that's why I think that happened. So, do you think they're limiting? No, they're trying to win. Hank wants. No, here's the thing, guys. Nobody's shooting for appeal. Everybody wants to win. So it doesn't matter. Like if you're prosecuting, you're always going. If there's grounds for you to make experts attack them and make motions and do all that, you're always attack. On defense, that first motion where Bev's like, "There's no supporting case law on your side." You attack anyway. You're always attacking. You're always pushing. You're always going for the thing. So, yeah. Summonable Trap says, can bruising occur if the heart stops beating? Well, remember, John O'Keefe had raccoon eyes. So bruising can occur. And then remember, his heart didn't stop beating until he got back to the hospital. So it's clear bruising happened at some point. And bruising can develop. But there was no bruising or marks there. So that's what I would say to that. So coffee's only for attackers. Coffee is for closers. Okay, why is this? Got it. Why is this freaking out about a whiteboard? I don't need a whiteboard. It keeps on shifting back for some reason, but I don't know. Anyways, guys, we're going to keep going here. Let's keep going here. We'll get through this. And I'm going to duck down and try to take a look at why this camera's not working here, chat. Hold on.
You were asked questions about impact with the taillight. And in fact, in one of your answers to me today, you talked about after a vehicle collides with a pedestrian, there's continued movement between the vehicle and the pedestrian, isn't there?
Correct.
And so while glass or plastic that shatters from a taillight might not impale clothes of the skin, would you agree, if your dummy wasn't restrained, when the Lexus collides with the dummy, there'd be continued contact for some time, extended contact between both the dummy and the taillight?
Well, the arm, as is demonstrated in the test, would be moving at roughly the same velocity as the vehicle.
Yes. And don't you think that the vehicle would continue to drag the arm until the body either was thrown or spun off? Would you agree with that?
At some point, they will separate, yes.
At some point, but before the at some point. What I'm asking is, at the collision, when you see all the taillights shatter, right, wouldn't the Lexus, if it continues at that speed, say 24 miles per hour, for example, it would continue to drag with that dummy's arm longer than is shown in those experiments because the dummy is restrained?
Sorry, can you repeat the question?
Yes. Would you agree that if a Lexus is backed up at 24 miles per hour and hits the dummy's arm and the taillight shatters, if the dummy wasn't restrained and moved regularly, it would extend the contact between that shattered taillight and the dummy's arm? Would you agree with that?
It would move with the vehicle until it got pushed out of the way, just move to the side, yes.
And so what you're saying is it would move with the vehicle but wouldn't touch the vehicle?
Well, in the one test, if you remember, because of the restitution effects, the arm reached a speed of over what the impact speed is. So in some instances, it actually might move at a speed greater than the vehicle.
Fantastic. In some instances, would it move slower and be dragged by the vehicle's broken taillight?
Dragged?
Yeah,
I don't know
so
if I
say
understand.
drag, push. How about we use the word push? Pushed by the broken taillight. Could that happen?
The arm would move with the taillight until it moves out of the way.
So you're saying it would move with or faster, but never would slow down where it gets pushed by the car?
It's moving with the vehicle, sir. I don't understand your question.
You said it moved the vehicle. Sometimes it moves even faster, suggesting space.
I mean, guys, it's clear. Hank is trying to say car hits the arm and it carries it along. But Wolf is confused because he's not really confused. Hank is asking an intentionally shitty question. And the reason why he's doing this is because Welcher's told him how to ask it in a way that makes Wolf look bad. And this is what Hank gets to do. He does get to talk to his expert. So this is a question that is intended and designed to trip up Wolf, and it's actually working here. So, Hank's not being stupid. He's intentionally being obtuse there. So, anyways, let's keep going.
Between the broken tail light and the arm.
And now I've got my two screens back.
Correct.
We're good.
With, it can move
We're
faster.
back in
If
business.
it ever moves slower and the vehicle pushes and drags against the arm.
I mean, it might be able to move a few miles per hour if it doesn't have as much of a center of mass hit, but it's still going to move out of the way because it's on a joint.
I understand. Before it moves out of the way, could it be pushed by that broken tail light? That's the simple question I'm asking you. Could it be pushed by the broken tail light?
Just moving adjacent with the taillight, just moving along. Yes.
Would you agree with this? If you have an arm struck at 25 miles per hour, significant more damage to the that tail light shatters, hits and moves forward into arms, parts of tail light pushed into arm as vehicle pushes forward and pushes arm out of the way. So the word push, would you agree with that general characterization that the broken tail light can, in fact, push the arm? Would you agree with that?
Generally, I guess, again, it would move with the vehicle, the arm together.
Not move with. I'm asking you if you would agree about pushing. Would you agree with that?
As long as we're on the same page about it, it's pushing the arm, but it's with the vehicle. They're moving together. So, but in essence, yes, the arm is being pushed due to the fact that there's a force on it.
And the pushing could have that arm in contact with the broken pieces of a taillight if the taillight broke, correct?
Just moving at a common velocity.
The operative word here is push. And so, do you like to agree with me or you can disagree with me? Can the broken taillight push the arm so it contacts and provides force against it? Could that happen?
Yes.
When you were showing those photographs today regarding Test F, now you used Randy in Test F, right?
Correct.
How tall is Randy?
He's 6 feet.
And he weighs 200 pounds?
Correct.
So still 16 pounds less than Mr. O'Keefe, yes?
Correct.
And you keep referring to Randy as a crash test dummy. Randy's no dummy, right? He's a mannequin.
He is, but he signifies basically what happens when you have 200 pounds of mass striking the rear of that vehicle.
I don't want to misrepresent Randy. He's not a crash test dummy, is he?
Well, it wasn't used for biofidelic purposes. It was to, again, what happens when you have 200 pounds of mass strike the vehicle.
So when you've been referring to Randy as a crash test dummy, you don't mean to do that. That's a misnomer, isn't it?
I don't know that I agree with that.
So you think that Randy is a crash test dummy? He's a certified, approved crash test dummy.
No, and I think I made it very clear that there is no instrumentation on it, right? And one of the reasons why I mentioned that is those ATD dummies are $150,000, so we're not going to risk impacting it with the Lexus and destroying that.
I can understand the cost analysis for you, but I want to be clear.
Well, if you understand the cost analysis, Hank, it's the same reason why Welcher didn't do it.
He's a mannequin. It's used by firefighters and drills pulling a body, dead weight, out of a house to replicate certain scenarios. That's what Randy was made for, yes?
He can be used for those, yes.
Right. He's not a crash test dummy in the parlance of a legitimate, studied crash test dummy, is he?
I don't agree with that because, again, we use that type of dummy in all different types of tests.
There's an H395M PED, which most closely replicates John O'Keefe's size and body, isn't there?
Correct.
You didn't have that when you did your test, did you?
No.
When you do crash tests, you can put a magnetic control on the crash test dummy, so upon impact, it releases and is thrown. You could do that, couldn't you?
That is one way, yes.
Right. So that way you don't have to put the dummy on a forklift, and then it creates a different scenario than real life, correct?
That could be one way that you could do it, yes.
It doesn't impede any roll or drag when the dummy's hit. That's one reason you would do that rather than a forklift, yes?
Correct.
Also, it might show some throw, which could lead to other type of damage like holes in clothes, yes?
Correct.
But you didn't use the magnet, you used a forklift.
Because, again, the purpose of the test was to evaluate, we talked a lot about those time frames, right, that 10 millisecond window. It's to look at, from the vehicle damage perspective, what happens to the taillight, right, in that interaction. And then ultimately, what is the acceleration that the arm experiences in that, 10, 15 millisecond window, right? What happens 1 second after, 2 seconds after? Again, that wasn't of concern for me in my analysis.
You didn't use a magnet, you used a forklift, right?
Correct.
And when Randy went for a ride, you didn't expect him to break off the string and slide across the street, did you?
We didn't expect him to.
You didn't expect him to be thrown. You didn't expect the string on the forklift to break and then Randy to go flying. You didn't expect that, did you?
Oh, I certainly expected that.
So you expected a throw with that.
Yes.
And the street has hard concrete and has a lot of irregularities to it, doesn't it?
It's asphalt, yes.
Yeah. In the photos that you were shown today on redirect examination, did the defense show them to you during the direct examination? Any of those?
No.
Ms. Gilman, can you pull up that last exhibit with Randy on the ground? I think it's exhibit 221. Okay. And so this is Randy, right, doctor?
Yes.
Zoom in a little bit, please. What's that red thing near his shoe?
Appears to be a fragment of the taillight.
Can you zoom out? Could you go back an exhibit to the one before? Could you zoom in? Did you see any taillight fragments on his body or in his clothes?
I can't tell from here.
Could we have the exhibit before, please?
Chad, I told you. Isn't it funny how I could see that? And I'm like, well, that's something Hank is going to use. Now, you might say, oh, that's back window glass. Remember, that was brought up, and now there's no chance for Jackson to go back and say, wait, what about that? That this is Hank setting them up. Now, I'm a little disappointed. Hank probably knows that's what he might or might not. If Hank knows that's back window glass, I mean, he's using it, though, to say, look, there was glass on John, which, yeah.
Can you tell from here?
Yes.
And finding taillight fragments on the clothes after a collision, that's not unique, is it?
Unique? No,
Yeah.
it's possible.
Well, according to this, it's probable, yes?
In this test that did occur, yes.
Well, what chat? See, now this is the funny thing. Hank went through all of that. Hank went through all of that bullshit earlier. And I guess this is my point. The efficiency, making the use of your time. You can make the use of your time without acting like a dickhead. He could have been harping on this. Like the last since they came back from their sidebar, Hank's been very good about what he's asking. I don't agree with it, but he's doing the right things. He would have had a far more effective questioning of this witness had he just done this from the start. But no, Hank wanted to fucking fight with people. And yes, now the jurors are going to say, oh, we found glass on people. There was glass on John. Therefore, it's possible. So, I'm just telling you guys, as far as any evidence right there, that's actually good evidence for Hank he can run with. I'm not even talking about cutting John. I'm just talking about finding pieces of glass on him.
Could we have exhibit 201D, please? Do you know what this is, doctor? Did you see this picture in your analysis?
Don't know if I recall that specific photograph.
Do you know this is taillight shards found in Mr. O'Keefe's clothing?
Objection.
Did you consider this photograph during your analysis before you gave your opinions regarding cuts and tears and lacerations?
No, sir.
Can you take that down, please?
I mean,
When you did your analysis, did you know that a drinking straw was found on the concrete on the street in front of 34 Fairview?
I don't know if it was on the concrete, it might have been on the asphalt, but I do recall a drinking straw, yes.
Did you know that there was a glass found near Mr. O'Keefe? Could you put that up, please, Cindy?
Objection.
Did you talked about cuts and injuries. Did you?
sustained. It sounds like it's beyond the scope.
Very well. When you did test D, did you say the peak acceleration was 780 Gs?
Your Honor, may I refer to my notes?
Yes.
Page 11 of your report.
I think I lost an exhibit. Okay.
Is that what you described it as?
For test D,
Yes.
the acceleration of, we talk about the hand,
Yes.
780 Gs, yes.
780 Gs. Okay.
That's a lot of G's.
When you did your comparison before you gave your opinions, you showed us a scuff on the exemplar vehicle, photo 77.
Objection.
Beyond the scope, Mr. Brennan.
A few more questions, Dr. Wolf. You showed us holes in Randy's sweatshirt from test F. You remember that?
Yes.
And you talked about what you would or wouldn't expect in a collision as far as holes. And did you say something like that was inconsistent with Mr. O'Keefe?
Yes.
That's what you said on redirect, right?
Correct.
Okay. Did you consider whether there were holes in Mr. O'Keefe's sweatshirt separate from the holes in the arm?
Sorry, can you repeat the question?
Yes. When you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm?
Well, I know that there was cutting to the,
May I approach and retrieve the exhibit, Your Honor?
Yes.
See, now that right there. So Hank is now coming back to get something. Okay, let's see what this is. Oh, he's bringing out the slab, chat. We're bringing out the John O'Keefe slabs. Limited edition, chat. One of a kind. One of one.
Did you ever look at the back of the sweatshirt to see if there was any holes to the back of the sweatshirt other than the right arm when you formed your opinion?
I don't recall.
Take a look at the back. Do you see other holes on the back of Mr. O'Keefe's sweatshirt?
It appears I see one hole.
Let me get a little closer so you can get a better look. I'll direct you to here, 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 here. Do you see more than one hole in the back of Mr. O'Keefe's sweatshirt?
Yes.
When you were forming your opinions,
Okay, guys, I know this is the part I think everybody shit their pants about, but we never talked about the backside of John O'Keefe's sweater at any point during any other witness examination.
that the collision would be inconsistent to damage to Mr. O'Keefe's sweatshirt. Did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, in looking at those holes, they're inconsistent with road rash. And again, to get those kind of holes, you have to have prolonged sliding contact on a rough surface.
Did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, if you just fall and land on your back, you're not going to be sliding to get those abrasions and tearing. And again, those are not consistent with road rash.
Didn't ask that question. Did you consider?
Sorry, can you?
Did you consider whether Mr. O'Keefe had fallen or landed on his back?
No.
Did you know about or consider the multiple holes on the back of his sweatshirt when you came and formulated your opinions?
No.
You did no studies whatsoever about the damage to the sweatshirt if he fell or landed on the cold, hard ground and had broken taillight shards in his clothing, did you?
No.
I have no further questions.
Yeah, just a moment, Your Honor. Very- If I may, Your Honor, very briefly. You were asked by Mr. Brennan, give me one name, very dramatically, of someone.
Objection.
The objection sustained.
You were asked to give me one name to support using a 50 percentile hybrid 3 in testing forces on a 216-pound man. Do you remember that question?
Yes.
How about the name Judson Welcher? How about that name?
So the objection sustained.
Did Judson Welcher use a 50 percentile hybrid in his drop test?
Objection.
So that's sustained as to form.
What did Judson Welcher use in his drop test?
A hybrid 3 50th percentile male, the same that we use in our testing.
You were also asked whether or not using that hybrid 3 arm with the same speed would have an effect on the force equation, on the force calculation, correct?
Correct.
And you agreed it might have a small effect on the force calculation, correct?
So sustained as to form.
This is just foundational, Your Honor.
Sustained as to form.
How did you answer that question?
I'm sorry, can you repeat the question?
Sure. Let me ask it this way. In the 29-mile-an-hour test with the hybrid 3 arm, were you going faster than 24 miles an hour?
Yes.
And what was the calculation again on the increased force that would be exerted on the taillight, on the arm area of the taillight? 14%?
Yes.
Objection.
So sustained.
How much, what was the percentage that you calculated? The increase?
14%.
And did you find damage, even with the increase of 14%, did you find damage on that exemplar taillight consistent with the extensive damage on the subject SUV?
Objection.
No.
Can we have 201D put up one more time? Mr. Brennan just asked you if you made note of these little red pieces, correct?
Correct.
Do you have any idea the size of those pieces? As you sit here.
Not without a scale of some sort, no.
So as you sit here, do you have any idea what the size of those pieces are?
I couldn't tell you as I sit here today, no.
No idea if they're a foot long?
Objection.
So the objection sustained.
You were asked, when shown this picture, if you accounted for this in terms of damage to the garment, the sweatshirt, right?
Correct.
What if I told you those were,
Objection.
So the objection's sustained. He said he doesn't know the sizes. That's the end of that, Mr. Jackson.
I realize he said he doesn't know, he was
That's
asked
the
questions.
end of that, Mr. Jackson.
Wait, why isn't he allowed to ask him about that? What? What? All right, well, whatever. You're fucking hack, Bev.
Do you have
Jesus.
Mr. Wolk, do you have the picture of the tin? The TIN, tin, the little round tin? Do you see that tin?
Yes.
Are you aware that all those pieces are inside that tin?
Objection.
Sustained. And jurors disregard that.
Did you ever see this tin in your analysis?
I do recall seeing, yes, in the evidence photographs of all the fragments, yes.
In your experience, are very large pieces or very small pieces put in little tins about 2 inches wide?
Sustained.
You were asked a question about the arm being pushed by the taillight. Asked a bunch of questions about that, right?
Correct.
You indicated, what did you say in terms of the the contact by a vehicle, pushing arm.
It's going to move with the vehicle until it separates.
In your testing, how long did it take the hybrid 3 arm to get up to speed of the vehicle in the 24-mile-an-hour test?
About 10 milliseconds.
I'm sorry, say that again, louder.
10 milliseconds.
10 milliseconds, correct?
Correct.
So when you say the arm is being pushed, it's being hit, correct?
The objection sustained and struck.
In every one of your tests, every single one of your tests, did any taillight fragment tear a hole in the sleeve of the shirt that you were testing?
No, there was no holes, punctures, fraying, nothing to the material.
Was there ever a defect in that garment in any of that testing other than the road rash that we saw in the 29-mile-an-hour direct impact?
The only test that showed the holes and the abrasions was that full-on hit where the body was sliding on the ground. There was no test where the taillight caused any type of punctures, holes, or fraying to the material.
And in that test, what happened to the back of the lessons, the test lessons?
Destroyed.
Or I have follow-up questions.
Okay, go ahead.
All right, chat, let's go here. Let's see where we're at. So I guess this is where I'd like to ask Mark, is it okay when the prosecutor has to lie? Because is that really a mistake or is that a lie when you completely do that? I mean, that's I mean, if you have to lie like that, Mark, is it really worth the dub? Because you're supporting that action. I'm just saying, if you really want to support that, it's never okay. Well, guess what just happened? Guess what just happened? You're supporting it. You're condoning it. You don't believe he intentionally lied? I understand. He's a nice boy. He didn't do nothing wrong. I get it. I get it. He's a nice boy. He just trying real hard, boss. He just had an oopsie poopsie. That might send an innocent woman to prison.
You again talked.
We're going through another
On
round,
redirect,
chat. Here we go.
You again talked about the impact between an arm and the.
Jack D65 is a sport defense line. No, nobody should lie in court. But really, are you going to argue if the defense lies, the prosecutor can lie? Oh, the defense team lied, therefore the prosecutor can lie, make up evidence, have witnesses commit. Like, are you really going to bake the? Well, we get to do it too if one side does it. Remember, man. Like, no. But honestly, if they can lie and get away with it, then your case is really fucking shitty. Like, it shouldn't be that hard to point out lies. But it's happened both sides. Okay, great. Like, if we're going to the ARCA stuff, fine. But the ARCA stuff didn't happen in front of a jury. Hank lied in front of a jury. I mean, to argue that some of this stuff is all the same, come on now. Come on now, kids. Just if, like, this is the problem. If you guys are going to troll, you can't troll with a dildo up your ass because it doesn't work. Got to pull it out so you can wiggle around freely. Come on now, children. Jackie D says the game is to pretend that you didn't do it on purpose, right? I don't like it, but both sides have done it. Remember, one side is supposed to be the rule of law and it's supposed to be righteous and seeking justice. If you have to do this to seek justice, you're not seeking justice. The other side, you're like, but the defense attorneys and the bandman, they're doing bandman. Like, that's the game. That's the game. The defense is doing what they can to win. The prosecutor is supposed to be on the side of justice. Karen's team's about winning. They don't have the same goals. You're telling me it's okay for the defense to lie. I mean, not okay with it, but are you going to tell me it's okay for the prosecutor to lie? I mean, at some point, like, one side it's acceptable for, the other side it's no justification at all. The defense are literally zealots. Yeah, well, that's how it works on defense. You can't go in there. You can't go in there being. You can't play patty cake on defense. You go all out. So,
Broken taillight.
Correct. Yes.
And I had asked you
we're going to speed up a little bit
on
now, Chad.
cross-examination or recross-examination whether that broken taillight could push the arm, which of course would create force or friction, yes?
Well, once it's moving at a common velocity, I'm just not understanding your question then.
If it's not a common velocity, if the broken taillight is,
Ask the question.
if the broken taillight is pushing the arm, which would mean the broken taillight is going at a faster speed than the arm, if it pushes the arm, the broken taillight can come in contact with the arm, can it?
It's moving with the arm, sir.
Okay, let me ask you this. Would you agree with this? If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So if you have the taillight coming in, it's hitting the arm, it's moving forward into the arm. Do you agree with that?
Objection, source.
No.
Dr. Rentschler, do you agree with that?
Objection.
So I'm going to allow it, strike the source.
Do you agree with that?
I'm sorry, can you repeat?
I can. If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, specifically if there's a taillight that shatters, so you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. Would you agree with that?
Objection.
I'm going to allow it.
In reference to the greater damage, we're talking about damage to the arm?
Do you agree with that phrase?
The best way I can characterize this is it's moving with the arm, sir.
So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way.
Objection.
Do you agree with that?
I'm going to allow it.
No, I need to vote. I need to vote.
So let's see here, chat. I mean, I just. All right. Oh, well, that was a quick sidebar.
I'm going to read this one more time, okay?
Okay.
Would you agree? If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. Would you agree with that?
Again, my area of expertise is not injuries to the arm, so whether or not those fragments would be embedded or cause any type of damage to the arm, no. But what I would say is that I would agree with the taillight being pushed into the arm. It's going to cause the taillight to fracture, and then the arm will move with the taillight.
When you do a demonstration, isn't this exactly what you see? Could you play E again for me? Isn't this exactly what you see? Play that, please. And now, stop, please. If Randy is not restrained by a...
Also, the one thing I think that Wolf and Jackson and them should have focused on is that people were standing nearby. Like, did any of the glass hit them or touch them? Did any of that glass strike with enough force to penetrate clothing or anything like that? I think that's stuff they could have probably brought up. Because remember, the idea is this is like a fragmentation grenade going off, shredding it up. I think that's something they maybe would have been able to focus on. Like, I really would have focused on the aspect of, like, how much, like, and I hope Rentschler could say this, how much velocity do you need to pierce the skin? So, I agree the glass doesn't cut you. I'm just trying to bring up the idea here.
forklift, he is going to move with the car, correct?
Well, if it's just the arm, his arm's going to get accelerated to move, and then his body will be there still.
And that broken taillight, if Randy is not restrained on a forklift, is going to be pushed, like this says, by the arm, by the broken taillight, isn't it?
It's going to move with the arm.
Thank you.
All right, so jurors, we're going to take a morning recess. We'll see you in about 20 minutes.
Please rise for the jury. Right this way.
All right, chat. We're going to skip ahead here. All right, here we go, chat.
All right, so I'm told counsel wanted to see me.
Your Honor, issues has arisen related to the cross-examination or recross-examination of the last witness, and Mr. Alessi would like to address the detail about that.
All right, so the last witness was your witness. Is there a reason?
This is a separate issue. I'm asking Mr. Alessi to address the point on this.
Okay. What do you want to tell me, Mr. Leslie?
Bear with me a moment, Your Honor. I need to put on evidence gloves. Your Honor, the defense moves for a mistrial with prejudice based upon intentional misconduct that just occurred before the court and for the jury. And what I'd like to do, Your Honor, this regards the Hoodie, in this regards questioning and representations and questioning by Mr. Brennan. And what I'd like to and need to do, Your Honor, is to have two documents marked as exhibits, and then I am going to use Exhibit 88, which is an evidence, which is the Hoodie, which is why I'm putting on the evidence gloves, and it will become quite obvious very shortly what the issues are.
All right, so what are the things that you want to have marked?
What I would like to have marked, the first document, and I want to get the specific title. These two documents are from the criminalist file, specifically Ms. Maureen Hartnett's notes regarding cuttings from the Hoodie sweatshirt that's in the crime lab file folder.
Okay.
So the first is the back of the Hoodie. So with Your Honor's permission, I would have that marked for identification.
Exhibit YYY. Friday.
And may I see that, please? Thank you. Okay.
Bugger, let's see, I was a steel chair.
And, if I could please
Bugger.
have the next mark in order exhibit for identification.
Exhibit ZZZ, Friday identification.
Just give me a minute to read this, Mr. Leslie.
Yes, Your Honor.
So is it that there are no holes in the back? There were no holes in the back of the sweatshirt?
That's only part of it, but that is in fact the case, Your Honor.
Okay. I can't tell entirely from ZZZ, but if that's your argument, why, for identification appears to support that.
Your Honor, may I have the exhibits marked for identification back for my argument?
Okay.
Thank you, Your Honor. Thank you, Madam Court Reporter. Your Honor, what we just saw is Attorney Brennan question Dr. Wolf with regard to the Hoodie sweatshirt that heretofore has been in the plastic casing for trial. And this is the, what happened was Attorney Brennan held up the casing with a Hoodie sweatshirt, went to the back of the Hoodie sweatshirt. First point to note, Mr. Brennan did not show Mr. Jackson the back of the Hoodie sweatshirt, didn't give Mr. Jackson an opportunity to look at it.
Can I just ask a question? I noticed that it was over here at the witness stand this morning, so I assumed everyone was aware that something was going to happen with it. Is that not the case, Mr. Jackson?
That is not the case, Your Honor.
Okay.
The first time I realized that line
Okay.
of questioning was going to be asked was Mr. Brennan pulled the casing out.
Okay. Go ahead, Mr. Leslie.
Thank you, Your Honor. So, to do it in order, Mr. Brennan takes the Hoodie sweatshirt in the casing, without notice, shows it to Dr. Wolf, and shows the back of the hoodie, which has certain holes, and I'm going to limit calling them holes to do this chronologically. I'm going to refer to exactly what they are in moments.
Okay, so I need to see it. I know you've got gloves on. Where is it right now? It would help me if you held it up for me now,
Absolutely,
Mr. Leslie.
Oh, he
So,
got to like.
Here is
Oh, they took.
the back.
He took it out of the wrapper, Chad. He took it out of the wrapper. Alessi, you broke open the slab. No, it's no longer mint. Why would you do that? Now nobody's going to buy it. Yes, the resale value's just gone. Deep. What'd you say, babe? Yeah. It's the value, chat. It's worth half the can use now. You're going to have to get it regraded. Yeah, it's going to have to go back for regrading now. They're going to know you opened it up. eBay sniper seething, yes. Should I open it or should you keep it sealed? It's like, Bob, you know, Bob's being a boomer. Bob, they didn't mean like you open up the exhibit. It was the pack itself. Bob, that's not what they meant. Why the gloves? Because this is actual exhibits. You could leave DNA on it. Because let's say somebody touched it, and then you swab that area for your DNA. Well, now that there's another male mixture on there, it's a piece of evidence you can't touch. Liam Rayer's like, wait, the game box is empty this whole time? Yes! Yes, it was all the scam, chat. It was a work. Oh. Bob, well, actually, here's a good point, Jay. Jay's brought up a great point. Bob Alessi touching it, you know, added more provenance. Remember, when it comes to collectibles, it's about provenance, just like art, provenance. What's the story behind it? So now it's near mint. Bob added his aura to it. Oh my God, chat.
Okay.
Of the hoodie.
Okay. All right. Thank you.
It's very obvious that these are cutting holes cut by the criminalist. And I'm going to get back to this in...
So if I was Jackson, because I heard she's coming back, that Maureen bitch is coming back, allegedly, I'd be like, so if somebody tried to claim that you made those holes, right? Yeah, and anybody who said otherwise is a fucking liar, right? That's how I do it. But those of you out there sucking the state's dick right now, this is what you're condoning. Hank did that, and you're like, this is okay. No, this should be a mistrial. He intentionally misrepresented evidence.
But I would like to do it, and certainly entertain any of your other questions, but in a logical order.
Sure. So I'm not. What about the jurors and lunch? How long do you think this will be?
I think this will take about 10 to 15 minutes, Your Honor.
Okay.
You're telling me violating Karen's constitutional rights is something we shouldn't cry about? Like, that's a pretty big deal, 12 Monkey. I mean, would you be okay with this happening if you were facing a speeding ticket or anything like that if the cops and prosecutors started fucking lying and they knew it was a lie? Would you accept that? Would you accept that? No. You should be upset about this. This is fucked up. This is Is it moving and following me? Oh, it is. This is fucked up, chat. It's entirely fucked up. You shouldn't accept this conduct. You should never accept this conduct. If this is what Hank has to do to win, he doesn't deserve to win, guys. Just telling you.
All right. Thank you. Go ahead, Mr. Leslie.
Thank you, Your Honor. So I just want to get the flow back going here in the logic. So, and I'll do it quickly. So Mr. Brennan grabs the hoodie sweatshirt inside the casing, doesn't show it to Attorney Jackson, goes up, we have no idea that this was going to happen, goes up, confronts the witness, Dr. Wolf, shows the back of the hoodie sweatshirt, to my knowledge, the first time the back has been referenced of the hoodie sweatshirt, shows Dr. Wolf, confronts him, and basically says, couldn't these holes be caused, and I'm paraphrasing, from a fall backwards? Obviously positing in the juror's mind after remember, we just saw all kinds of videos with regard to Rescue Randy and impact at 24, 29 miles an hour, more aptly 29 miles per hour, and damage to the hoodie, etc. So what then happens is Dr. Wolf is asked a series of questions, very much with the indication that somehow, in the clear implication, that these holes are being caused by road rash, and that the holes in the back of the hoodie sweatshirt, Exhibit 88, could have been or likely were caused with regard to some type of impact. Clearly presented to the jurors with that in mind in that questioning. Here is the basis for the mistrial with prejudice. Those holes in the back of the hoodie sweatshirt are clearly, unequivocally, without doubt, caused nothing to do with any type of event on or about January 29, 2022.
So do you have something you said, when you said obviously cut by the criminalist, do you have something that shows that chart that I couldn't understand quickly? Is it on that?
Yes,
Is that
Your
to the
Honor.
back?
What
Okay.
we have is two documents to show that.
Right, so the second one, when was that provided?
These, when you say provided, you mean with regard to when did the defense get these in
Yes.
a discovery? Let me get the date, Your Honor.
Sure.
Notice of discovery, May 2023.
Okay, thank you.
And I will note, Exhibit YYY. The only, I believe, I'm holding up YYY, which is the back of the hoodie, I believe is the only one, to my knowledge, not put into evidence, not turned into evidence. This is the one that it clearly shows the hoodie before the criminalist.
We should all be seething when the Constitution gets violated. Karen's rights to a fair trial have been violated here. We should all be seething. We should all be seething about it. This should not be acceptable to you.
Started her work with the cuts. There are no cuts to YYY, and if we need to, we'll bring Ms. Hartnett in to confirm.
All right, so is ZZZ in evidence?
ZZZ is not in evidence, and that is part of the basis for the mistrial. It is no coincidence that these two documents are not in evidence, because if they were in evidence, they would clearly have prevented the stunt that we just saw occur with regard to Dr. Wolf. So that is part of the intentional misconduct, Your Honor, is these are documents from the criminalist's file, that it's the Commonwealth's documents. And it is very clear when you go to Exhibit ZZZ, the cuts that the criminalist made to the back of the hoodie are specified.
So where on that? Because when I quickly looked at it, I didn't see it. What does it say? Go ahead and read it to me, please.
It's item number 7. I'll read it from the top. LIMS 22-2184. Analyst MSH, which is the initials for Ms. Hartnett. Dates: May 11, 2022, May 12, 2023, and then May 18, 2023. And what she does is she's got the...
You know what? Can you bring it up to me, please?
I certainly can, Your Honor. And I can conduct my argument from right here if that helps, Your
I
Honor.
just want to see, point out to me where it says, where it shows the back.
This is the back. So you can see the back of the hoodie, that's the back of the hoodie head, and then you can see the various...
Oops, sorry, chat. Sorry.
Let me just get a check on this, Your Honor. I'm not...
Mr. Brennan, you should come up and look at this as well.
And I'm
So Mr. Wesley's statement.
yes.
All right, so this is why.
Can I get the check?
Label cuts.
Pardon me?
The label cuts.
Right, but if I can, Your Honor, I want to clarify this. Yes, I do will. Let me just make sure I get...
Mr. Jackson, it says
We're
exterior
not-
front. What,
Guys, we're not operating the idea of sterility here. Like, this is not a sterile situation.
Mr. Leslie was pointing me to.
Well, just a second. It may print the wrong page. I can do it, Mr. Wolf, can you print the back? And then, Your Honor, are you comfortable using the computer or the back? Because I think we just had the wrong one.
We need to mark it, though.
Understood. We will. He's printing it right now. We printed, we wanted to have the front and the back to show all the cuttings, but what only printed out was the front. We are now printing the back. Your Honor is correct.
Okay.
But Your Honor, I'm advised it will take 2 minutes because it has to go.
All right, so go ahead with your argument.
Thank you, Your Honor.
So, Your Honor, what is being printed is which we will mark, will be the front of the hoodie. The purpose of Exhibit ZZZ and the one that is being printed is to show and to give the court, and we're going to request to give to the jury the complete picture and the complete true story about these holes in the hoodie that were presented as if they were caused in some manner by something else other than the
So
criminal.
that seems perfectly reasonable, and I'd be inclined to do that.
I appreciate that, Your Honor. And here is the reason for the motion for a mistrial with prejudice. On its own, to do this, and you put together all of the parts of what just occurred. You start with the fact that
And if I could, Your Honor, now that I haven't yet marked so I can then refer to it.
All right.
Thank you.
Can you print extra copies too, so I can have my own copy?
Absolutely.
And for the Commonwealth to see?
And I'm going to show the Commonwealth what I just printed.
Exhibit A.
Thank you, Madam Court Reporter. Sure. And here's another document, chain of custody document. Well, Well, Mr. Brennan is reviewing that, when I had to Madam Court Reporter the chain of custody document for these and asked that he mark it as the next exhibit in order.
Okay.
And then with Your Honor's permission, I would have Madam Court Reporter hand them both up to Your Honor so
Sure.
Your Honor can see what I'm writing.
Thank you.
Exhibit B for ID.
Thank you.
Here's, thank you, Madam Court Reporter.
Do you need this, Mr. Leslie?
I do not need either of them, Your Honor, and I have the extra copies as well. Okay, so Your Honor, I now have enough copies for Your Honor and for the Commonwealth.
Oh, thank you. Okay.
So if I could have one set, that would be great. Yeah, Your Honor, thank you.
I still do not have ZZZ. All right. Thank you. Okay, go ahead, Mr. Leslie.
So, Your Honor, to do this quickly chronologically, so we have a hoodie sweatshirt that was brought into the criminalist, Ms. Hartnett, with the back of the hoodie with no holes on it. The criminalist makes cuts to the back of the hoodie, makes cuts to the front of the hoodie. The exhibit, Your Honor, depicts those. There's a chain of custody document that describes the chain of custody for the hoodie and the cuts in the chronology. And of course, we have Exhibit 88, which is the hoodie. So, what Mr. Brennan did, and I'm now pulling Exhibit 88, he holds up the back of the hoodie, which has cuts in the back from the criminalist, somebody from the Commonwealth, a witness in this case, Ms. Hartnett, she's testified, and Mr. Brennan has indicated he wants her to come back and testify, which we welcome. And now what we have is we have holes in the back of the sweatshirt that were dramatically held up to and confronted with Dr. Wolf, and then the jury sees it. With the clear, unmistakable, purposeful intention of having the jury conclude that these holes could have come from events on January 29th of 2022, when in fact the Commonwealth well knows from its own documents, from its own criminal list, that those holes in the back were caused
by their criminalist as part of their examination and sampling of the hoodie. What could be more egregious? What could be more misleading than that? And what could be more important for a context than the alleged collision?
And now remember, Hank's going to have to come in here and say, I'm just a big idiot. I don't know any better. No, what could be more misleading? He knew it was wrong and he did it anyway. Once again, if you are letting Hank drag your balls on your face right now, that's what Hank is doing. Hank literally pulled his nuts out and drug them across your face. And he's waiting to see if you're going to react. Aperture, everything else, put it off to the side. Hank just lied about this. What else has Hank lied about? Whereas Hank did himself. Shh. Don't tell anyone. Remember what Hank said? Shh. Don't tell anyone.
That never occurred. That's the topic before some of the most significant and probative witnesses in this trial that the Commonwealth has been attacking from the jump of pretrial. They picked the most opportune, sensitive time to pull this stuff. This is intentional. This is irremediable. This is on the key issue of this case, whether there was any collision at all. On its own, Your Honor, on its own, this is a mistrial with prejudice. But I add to that what just happened, and I'm not going to repeat or go into other than to reference. This comes on just mere days after the Commonwealth raised the specter of absence of DNA on the same hoodie sweatshirt without having the criminalist, the Ms. Kuhn from UC Davis come in. I know Your Honor already ruled on that.
Right, so let's move along from
right,
that.
that's what, and I'm going to come back to this. Why is this occurring, Your Honor? Why is this happening? The Commonwealth has no...
They 100% knew. They 100% knew. Once again, chat. Lally McLaughlin knew this, and all, arguing about anything else, chat. We have to focus on, no. He lied, and you're willing to let him do it. Tell me how Hank's ass tastes out there in the anti-Karen Reed community. How does Hank's ass taste?
No case. They have no collision. They are desperate and are trying to create evidence of specters of collision where the evidence doesn't support it. So what have we come to? We've come to the manufacture of evidence. We've come to, incredibly, taking a hoodie, a key piece of evidence in this case, and holding up to Dr. Wolf, the ARCA expert, to try to make it seem like Dr. Wolf didn't do his job. You didn't account for these holes. How could you be a credible accident reconstructionist when you talk about some holes, but you don't talk about these holes? Knowing all along the holes that Attorney Brennan is trying to impeach Dr. Wolf on were caused by the Commonwealth's own criminalists as part of sampling. I don't believe one could come up with more misleading, misdirecting, elucidation.
Once again, Mark, the other question I have for you now is, if Hank lied about this, what else did he lie about? Are you sure he didn't lie about anything else?
Of testimony than this on the key issue in the case. We have irrefutable, objective evidence, and I will state that it's more than interesting that none of these exhibits that Your Honor now has marked for identification were put in evidence by the Commonwealth. Isn't it some coincidence that these are the one, and the only one of the, with regard to the hoodie, the back of it's not in, although the rest of them are, but these aren't. Your Honor, I think there is one and only one conclusion, in that this is intentional, that it is a matter of such significance and of such misconduct and intentional that it merits the sanction of a mistrial with prejudice. The amount of effort, the amount of work I can't even begin to think to remedy this in front of the jury, to go backwards on this. That should not befall the defense. That should befall the prosecution. Ms. Reed, again, is entitled, like every other defendant in this wonderful Commonwealth, to a fair trial. The prosecution is supposed to be held to a higher standard, to do justice, to create a fair trial. This is the antithesis of a fair trial. Ms. Reed's rights under the Constitution and the Declaration of Rights have once again been trampled on, and it is becoming evidently clear the more desperate the prosecution gets because it can't prove its theory, including its own medical examiner can't support them, that they're now resorting to conduct like this. Your Honor, at some point, this has to come to an end. At some point, Ms. Reed's rights have to be protected. At some point, confidence in the judicial system, the public's confidence in the judicial system, that prosecutors will conduct themselves with their duty to present a fair trial. That has to be enforced at some point for Ms. Reed to receive the fair trial that she and every other defendant in this Commonwealth is entitled to.
All right, thank you. Mr. Brennan.
Your Honor, my brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake.
Oh, my brief review. Pulling that coffin up that little bit of load. Hank, you little bitch. Look at him. He's got a smirk on his face. Look at this piece of shit. This is the guy. All of you out there who think Karen Reed did it and you're supporting the state, this is the man you're trusting now. This smarmy lying shitbag. This is the guy you're supporting. Yeah. Did I do that? Oh, no. It's the guy you're supporting out there.
And so I think what should happen is there should be a curative instruction. There should be a stipulation. The court should instruct the jury that during Mr. Brennan's cross-examination, he asked Dr. Wolf about holes on the sweatshirt or holes on the back of Mr. O'Keefe's sweatshirt. The parties agree the holes were made by a crime.
Notice, he spent that whole time knowing he was fucking wrong. And then he sat there writing up a curative instruction to cover his ass. Notice that. Hank knew immediately he fucked up because he lied. Because he got caught. He got caught. And he spent that whole time scribbling out a curative instruction. Not a, I'm sorry. You're right. My apologies to the defense. My apologies. I may have ruined your right to a fair trial. None of that. I mean, fuck. I mean, ooh. No, guys, I'm sorry. I was just reading something somebody sent me. Sorry there, guys, but God, this is just... Yeah. Every other time he screams and cries. It's the only time he took his beating like a man. This should be a dismissal. You can't come back from this. If I am Alan Jackson when Marine gets up there, I'm hoping he does. If anybody said that came from coverage with the ground, like, you know, and if somebody said that was otherwise, would that make them a fucking liar? I didn't put that on the record. I'd take the reprimand if I was Alan Jackson. Fuck this cocksucker. Fuck this guy. No, that was no, Mark. Because here's how, like, I understand. You're like, I'm engineer and physics, man. No. When you're in court and you fuck up, you say, I apologize. I was wrong. Looking over at them, he's like, fuck you. I'm still going to get this in. That's what he just did. That's what he did. Remember, this is your boy now. You're co-signing for all of this now, Mark. You're co-signing it. You're co-signing it all. You're co-signing it. And then real quick, I need to get this in here because it did get brought up. Jacob's Proud Madre for $50. Says Brennan is such a crooked tool. If I had to go up against him in Boston, I wouldn't fucking trust a word he says after this case. I messed up. You're completely retarded. You don't know your own case like this. He's not worth $250,000. They should get their money back. I wouldn't trust him. I don't care if it's like a simple divorce. Oh, yeah, here's their stuff. I wouldn't trust any of it. I wouldn't trust a goddamn word this man says. The Commonwealth are the ones with the burden of proof, keyword proof, not made up shit. Exactly. What in the world would it make the Commonwealth lie about someone's guilt? The idea that he has to win. Hank is worried about winning, not justice. And it's because his case sucks. And she says, Sean, for what you do, you're one of my favorite creators. Well, thank you so much, Jacob's mom. I appreciate it. Thank you very much for your support. Thank you for the super chat. Thank you. So, yes, literally the one time. I agree. Yeah, this is once again, guys, if you are on the Karen Reed should be convicted, you now have to own this and accept it. You now have to accept it. You have owned it and co-signed that.
Lab technician. This was done inadvertently but should not have been asked. The court should strike the questions and the answers. And you should instruct the jury there to completely disregard any questions or answers about the holes in the back of the sweatshirt. And the court should...
Oh, it's too late for that.
The defense to introduce the lab report.
It is too late for that.
So...
It's too late for that.
I'm not going to allow the mistrial motion, Mr. Lessie. What
That's
I'm going
bullshit,
to do
Deb.
is instruct the jurors.
And notice, when the whole ARCA thing, she was so fucking angry. Notice how cheesed off Beth was. Bev was so pissed off about how much money an expert got paid. She was so mad. Like, you guys, clip this, put it out there. Bev got so goddamn mad over how much an expert got paid and when they got paid and how it might have happened. She threw a tantrum. We had separate hearings over days for it. Over multiple days, over this entire scandal. And Hank comes in and intentionally lies because there's only two options. Hank's a big old idiot. I mean, like, is he a big idiot or is he lying? You've got to choose which one. And if he's really this big of an idiot, what else has he gotten wrong? And if he's a liar, what else has he lied about? I mean, it's clear he's a liar. Hank isn't an idiot. It's not his first day out of law school. He knew what he did. He sat there the whole time writing out that instruction because he knew he was toast. But notice, Bev, when it immediately comes to her, she's like, well, I guess I'm not going to allow that. And that's what Bev just did. You know, it's hard not to say she's biased, but she's such a crappy judge. The line blurs so bad. The line between incompetence and bias is razor thin. And Bev is just, she's like a slug riding it right now, riding a razor blade.
Going to put in what's been marked for identification, Y, Z, A, and B. 4 of each letters. I'm going to put all these into evidence. They can be displayed for the jury, and I'm going to instruct the jury that during the cross-examination of Dr. Wolf, Mr. Brennan asked him about holes in the back of the sweatshirt and whether or not they perhaps could have come from events or implying or something like this. I instruct you, you are not permitted to draw any inference that these could have come from the events of January 29th, 2022. I instruct you further that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on I just put the dates aside. Lizzie, can I see those, please? It's unclear for me. Do you have a better idea, Mr. Alessi, what day these were done? Is it all of those 3 days? Now I see a fourth day. 5/11, no, I'm sorry, 5/11, 5/12, 5/11, 2022, 5/12, 2023, and 6/18, 2023. Those are the 3 dates?
Your Honor, on about May 18th, when the defense filed a motion to test, so that's the probative date.
So May 18th?
Yes, that's good.
Okay.
And that's 2023.
Yep. All right. That's what I'm going to do. Is there anything further you want me to include in the instruction? Your right to save regarding the mistrial, I disagree with you on that.
Your Honor, I'm not going to go any more into the argument, but I appreciate the opportunity to provide perhaps some further instruction for Your Honor.
So I'll hear you. Go ahead.
So the first, Your Honor, is with regard to two things. One, I would like the opportunity to have the hoodie sweatshirt held up, because that's what
Okay.
happened.
Yes.
It's
Yes.
these holes in the
Yes.
back.
Yes.
Thank you. So that's number one as part of the stipulation, and then.
I'm not wording it as a stipulation, and I'm not saying it was inadvertent. I am giving an instruction that they cannot consider it for this purpose, and I am allowing these to be placed into evidence. So it's not a stipulation. It's from me, which I think is more forceful.
I misspoke, Your Honor. I agree, not the stipulation, but just as Your Honor said. With regard to the matter Your Honor said they're not to take an inference, I would respectfully request that this be handled just like Your Honor did with regard to the rock at 34 Fairview. Your Honor said that rock wasn't present, on or about the time against.
So I do say that when I say Ms. Harnett did this. So rewording it just a little bit.
Yes, exactly.
Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt. I instruct you that you are not permitted to draw any inference that those holes were a result of the events on January 29th, all right, this is what I'm going to say. So if you're not going to listen to it, that's fine. I've already said it. All right, we can bring the jury in. It's what I said, Mr. Alessi.
Your Honor, I was consulting with Mr. Alessi. I'm not showing disrespect to the court.
Okay.
Of course you were listening to me.
All right, so it's what I said, Mr. Alessi. I instruct you that you're not permitted to draw an inference that the holes came from the events of January 29, 2025. Those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on May 18, 2023.
Is it possible, Your Honor, last comment, to instead of not drawing inference, you should conclude that these holes were not present in the hoodie sweatshirt. They were caused by the criminalist.
So I can just leave that all out then and just say, Mr. Brennan asked Dr. Wolf about the holes in the sweatshirt. I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection.
It's such a bullshit jury instruction. And the way she treats the defense is so fucking garbage. Like, this woman must have some sort of irrational hatred of Karen or Ellen Jackson or Alessi or something, but she's completely lost her fucking mind. It's absolutely garbage. It's absolutely garbage.
And sampling of the sweatshirt on May 18th. It's probably neater that way anyway. All right, let's bring him in, please.
Just as a housekeeping matter, the sweatshirt's been taken out of the plastic sheet. It might need to be remarked. The plastic sheeting was marked, but if we're going to put it into a bag or something like that, it might need to have it marked. But we don't need to do that right this second.
Okay. See, chat, now you guys might laugh at that or say, why does that matter? That is court staff, and I think that's her bailiff, her head bailiff, because that guy seems to kind of be in charge of stuff. That guy's keeping track of the courtroom. And those people right there, Bev's staff, are worth their weight in gold, because that guy's like, hey, Your Honor, well, I know everybody's fighting over the damn sweater. We need to make sure the sweater's properly marked and controlled for evidence purposes. So, I know, you guys don't care about that, but I do think it's very, very important to point out this guy right there, just bringing that up, that's a very critical thing. Nobody else brought it up. And he's like, hey, we need to double check evidence here. So that guy deserves a gold star for not being afraid to jump in and say, Judge, let me take care of this. So just wanted to say.
May I approach Mr. McDermott with exhibit
Yes.
88?
Thank you.
page remark.
All right, thank you. Oh, sorry. Mr. Alessi, you're simply going to stand and hold the sweatshirt, right?
Yes, Your Honor.
Okay.
Counsel, this is Exhibit 223.
In Your Honor, I would hold it as Your Honor begins to read. Is that consistent with Your Honor's explanation?
No, I want you to hold it up with the back.
Would you like me to start?
You do that first, and then I'll give the instruction.
Thank you, Your Honor.
All right, so Mr. Alessi, why don't you just, where are you going to stand?
Pardon me?
Where are you going to stand?
I would suggest, Your Honor, right about here.
All right? So you can stand there, you can hold it up, then I'm going to ask you to put it down, and then I'll give the instruction.
And then I will return to Mr. Thurman, or the court officer.
Yes.
Thank you.
Court officer.
Bear with me a moment, Your Honor, to be put on the...
All right, then we will take the luncheon recess. When we come back, we'll have the voir dire. Or actually, is Dr. Lapisada here?
She's here, she's on next. We're gonna call up. John Tier.
For just the measurements?
Go ahead.
Your Honor, if I could be able to show the exhibits from Ms. Hartnett, or the class, along with the next second instruction, show the class were made by Ms. Hartnett.
Well, I say it, and I'm going to tell her what they are, so.
Please be seated. Court is in session.
All right. Jurors, I appreciate your patience. Mr. Alessi, why don't you hold the exhibit up for the jurors, please? All right, jurors, that's the back of the sweatshirt that was shown to Dr. Wolf. Okay, thank you. Why don't you go ahead and put it back in the bag? So, jurors, I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt back on May 18th, 2023. Okay? So, I know your lunches are here, but I think we'll... Mr. Yannetti, your next witness, please.
John Tier.
Okay, step up, face forward, and raise your right hand.
You solemnly swear the evidence given to the court and jury in the case now here to the truth, the whole truth, and nothing but the truth, so help you God. I do. Thank you.
All right, good afternoon. Go ahead, Mr. Yannetti, whenever you're ready.
Thank you. Good afternoon, sir. In a good loud voice, would you please state your name and spell your last name?
Sure, my name is John Tedeman. It's Tedeman.
Do you work, sir?
I do.
What do you do for work?
I am a private investigator.
Do you work for someone else, or do you have your own firm?
I have my own firm.
What is the name?
Forum Investigations.
And that's Forum?
Correct.
I'd like to ask you a little bit about your education and work history. You're from this area?
So, chat, when you think about this guy, he is their private investigator. Think of him as their Karen's detective.
Yes, Boston proper.
I'm sorry?
Yes, from Boston.
Where did you attend high school?
The Roxbury Latin School.
Liar, you don't sound like it. You don't sound like it. You're a liar. He's a fake Boston man. He's got stolen valor.
When did you graduate?
1996.
Where did you go to college?
I went to Princeton University.
What year did you graduate?
2000.
What did you do after graduation from Princeton University?
I became a federal agent.
Where?
The agency or the location?
Oh, I meant the location, sorry.
I started out in Los Angeles, and then I was back in Boston.
And what years were you a federal agent in Boston and Los Angeles?
2002 through 2008.
And what agency did you work for?
I worked for the Inspector General for the Social Security Administration, Office of Investigations.
And what type of work did you do in terms of investigations?
We did fraud investigations, identity theft, credit card fraud, fugitive operations, all sorts of things, anything involving a Social Security number, basically.
And why did you leave in 2008?
I went to law school.
Where?
Suffolk.
What year did you graduate from Suffolk Law School?
2013.
And what did you do after graduation from Suffolk Law School?
I've had a small solo law practice and worked as a real estate broker.
And what type of law did you practice?
Mostly real estate law.
When did you start forum investigations?
In April of 2024.
Are you still practicing as a lawyer?
Not very much, no. I still have my license, but my bar card, but I don't practice much.
All right. How did you become involved in this case?
I was contacted by somebody from your office last Tuesday, I believe, the 3rd.
Okay. And was it explained to you why you were brought in at this late juncture?
Yes, it was explained that there was another investigator who had a health issue and would not be able to testify. So would I be able to help out with a small assignment?
What were you asked to do?
I was asked to travel to 34 Fairview Road in Canton and take some measurements and photographs.
Did you agree to do that?
Yes.
When did you go?
On June 3rd. I believe I arrived about 5:30 at 34 Fairview.
Okay, and when you say June 3rd, we are talking about last week,
Yes,
correct?
last week, yes.
Whom did you see when you got there?
One of the homeowners, an older gentleman, greeted me when I pulled in the driveway.
And it was not the Albert family, correct?
It was not.
Did that individual give you permission to enter onto the property?
He did.
What did you bring with you?
I brought an iPhone as a camera, and I brought a wheeled measuring device.
And can you describe what a wheeled measuring device is?
Yeah, it's like a handle with 2 wheels at the bottom, and in the middle there's like a little odometer that measures feet and inches.
Okay. And if we could, Mr. Wolk, could we display the photo of the front of 34 Fairview that's already in evidence with the court's permission?
Yes.
And what exhibit number is that, Mr. Wolk? 46? Do you see exhibit 46 on the screen, sir?
I do.
Do you recognize that?
I do.
What do you recognize that to be?
That is 34 Fairview Road in Canton.
When you got to 34 Fairview Road in Canton on June 3rd, did you make note of the various entrances to the residence on the front, from the front of the house?
I did.
Could you describe those for the jury?
Yes, on the left side center of the building, there's what I would call the front door, up those 4 steps, I guess. Then if you were to look farther to the right, there at the end of the main building, there's another door, which I guess is the second front door or side door.
And with regard to that door, is it fair to say that faces outward, faces toward the road?
It does. It faces directly towards the road.
Okay, continue, please.
And then past that to the right, there are the windows. And then if you can see the little red line, that is a side door that goes into the garage. Yes, right there.
It's been highlighted there?
Yes.
Okay. And then there are obviously the 2 garage doors.
And the 2 garage car doors, yes.
4 cars to enter. Okay.
Yes.
We can take that down. Mr. Wilkin, put the lights on. May I approach the witness, Your Honor?
Yes.
So I placed a photograph in front of you. Can you identify that for the jury?
Yes, that appears to be a photograph that I took of the side front door, the secondary front door, the garage door, and the 2 car doors to the garage.
Okay. Particularly with regard to the side pedestrian entrance into the garage, the red door that you identified in the previous exhibit. Does that photograph fairly and accurately represent the layout of the house in terms of the outside and the entrances that you've previously testified to?
Yes, it does.
I would offer that, Your Honor.
All right, can I see those, please, sir?
All right, chat, we're back. Sorry about all that. Okay, while we're waiting, we got some super chat stuff we got to hit up here. People sent in. Let's see here. Unhung Hero for $2 says, Hank was getting spanked. Yeah, I think so a little bit. Nick's for the member for 16 months. Thank you, Nick, for your support. Says, Hank is the Nick Rekieta of lawyers. Look, I get you guys don't like Hank, but I wouldn't go that far. I will tell you this much. I wouldn't trust fucking Hank where I, like, in here in Ohio, you'd have a shit reputation pulling this nonsense. So I don't think it's fair to call him Nick Rekieta, but he's definitely hurt his reputation, I think, doing this the way he did it. Three Bear says, why did I do an auto repair stream yesterday? Watching me swear and fight with some crusty, rusty bolts and sweat doesn't sound like fun. So that's why I didn't do it. That's why. Unhung Hero for $2 says, can we redo the test with Hank as John? Yeah, I think that'd be a fun one. And then John Coleman for $2. Good to see you, John. Says, look, Peggy is praying the gray away. John Coleman for $5 more says, Sean, I just want to let you know, SLM, sandwich lives matter. Just kidding. Keep up the good work. Annihilate those sandwiches. Well, you know I will. They can't run and they can't hide. Down my esophagus, they'll ride. Brandon, let's go for $4.99 says, you know why I don't go to church? All the sitting, standing, kneeling. Why can't the priest just tell you how he wants to rape you? Thank you, Brandon. Oh. Johan has been a member for 12 months. Thank you, Johan. It says, none of this is truth anymore. It's just narrative. Remember, guys, what I told you. What is a trial? A trial is sales at the end of the day. It's a narrative you are selling. It's a narrative you're selling. I tell you this because I am not joking. It's a narrative that you support with facts. I mean, that's like, I wasn't joking when I say it. Chad, I'm not joking when I tell you this stuff. Like, that's the thing. Like, I'm not joking when I do this. I like how there's like a little line right there now. Anyways, I'm not joking when I say this stuff. I'm not. So, anyways, make sure I caught up everything. I'll get your guys' other comments in a second. Chugi Show for $4.99 says, the protests are kicking off. Restreaming a guy I found on Kick. I don't think he understood what these things are like. LOL. Yeah, I heard Hassan got caught up in it too, so couldn't happen to nicer people. T-Rex Trucking and More says, I feel like Brennan knows he does fiddly messed up. Oh, he knows he did it. He knows he did. Island has been a member for 8 months. Thank you, Island. I appreciate that. Says, Hank is why attorneys have a bad rep. Yes. 100%. 100%. And then Malcolm X, we're going to leave it here. We'll catch up with the other ones in a second. For $14.99 in Australian dollary doodles. That's like 26 cents, I think, American. Thank you, Malcolm. Saying this should be a mistrial. It should have been. The prosecution used altered evidence. Well, they didn't alter it, but they lied about the evidence. And false testimony, because it's not altered. It is what it is. Now, like, altering it means like they had done something else to it. And false testimony on a key issue. The jury saw it. The defense caught it. Too central to fix with a correction. What a joke. I agree. There's no way to fix this. No way to fix this at all. So thank you for that, Super Chat. I appreciate the support, you guys. Let's keep going, though.
Okay, Mr. Wolf, whenever you're ready, if you can display that portion.
I think so too, Buck, but nothing we can do now.
Do you see what has been?
So I'm going to ask you to take that down. Folks, we're going to take the luncheon break. at this
Sorry,
point,
chat.
okay?
Sorry.
Rise for the jury. This way, please.
Okay, we're going straight to lunch. Okay, so they were.
So we'll fix that during the luncheon break, Ms. Giannetti, to what I said. All right. So can we get Dr. Lapisada in here? We'll do a very brief voir dire of her.
I think they've only asked for like twice total, which I would have asked for it a couple more times at this point. Everything's a fucking mistrial. Dr. Lapisada, I know. This is like the other medical expert. I forget how you spell her fucking name though.
Now you're going to step up, face the clerk, and raise your right hand. Please.
Do you solemnly swear the evidence you report in the case of evidence, the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Good afternoon, doctor.
Good afternoon, Your Honor.
We're going to do a brief voir dire, okay?
No problem.
Thank you. All right, Mr. Jackson, foundation on just those 2 points, please. Sure.
Oh, chat, we might have things here ready to go.
Your Honor, for purposes of expediting, does the court wish for me to go through the foundation of the doctor's education, training, and background and experience, which is going to take a minute?
Yeah, no, just focus on the foundation for the dog bites and focus on the foundation for what's been termed to be perhaps biomechanical engineering evidence, those two areas. And if there is support or methodology in Dr. Lapisada's resume to point to exactly where that is, okay? And I expect this whole voir dire should take no more than 15 minutes.
I'll do my best, Your Honor. Doctor, could you please state your name for the record? Spell your last name into the record, please.
Yes, Dr. Elizabeth Lapisada. That's spelled Laposata.
Dr. Lapisada, what do you do for a living?
I'm a medical doctor subspecializing in forensic pathology.
Dr. Lapisada, I'm going to move very, very quickly past the bulk of your training and experience over decades. I'm going to ask you a couple of quick questions. Where did you get your medical degree?
University of Maryland School of Medicine.
And do you have any subordinate degrees to your medical degree?
Yes, I have board certifications in anatomic and forensic pathology.
How long have you had those board certifications?
Now, chat, remember, they're going to voir dire because the jury's gone, so we're speed running this here.
Like 35, 40 years.
Have you ever worked as a medical examiner in any capacity?
Yes, I have.
Have you ever worked as a chief medical examiner for any agency or governmental agency or state?
Yes, I have.
Describe that for the court, please.
I was a chief medical examiner for the state of Rhode Island for 12 years.
How many autopsies would you say in general that you have conducted yourself?
Over 3,000.
How many autopsies in your experience as a supervisor in one capacity or another would you say you've supervised over your tenure?
Over 7,000.
Of those 7,000 that you have supervised, have any of those dealt with motor vehicle incidents?
Many.
Have any of those dealt with motor vehicle and pedestrian incidents?
Many.
Give me an idea, if you have a number in mind, how many motor vehicle pedestrian autopsies you have been involved with, either directly or from a supervisory standpoint?
Hundreds, over 500 at least.
Do you have a significant background and training in the cause and manner of death?
Yes, I do.
Is that the main goal or the main job or duty performed by a medical examiner?
Yes, it is.
Is it also significant in terms of supervising other subordinate medical examiners who may work under your charge?
Yes, you have to make sure they're doing it right.
Is there a methodology that you have employed and that is standard in the industry to employ, including differential diagnoses and inferential thinking in terms of coming to conclusions related to manner and cause of death?
Yes.
Can you explain that for the court in brief, please? I know you probably have a very lengthy explanation. Okay. Do it as briefly as you can, with being as succinct as you can.
Certainly. To determine cause of manner and death, we look at scene investigation, autopsy findings, police and witness statements, and medical history. And using that information, we come up with a differential diagnosis or a list of things that might have happened to that person to cause them to die. And from that list, then we see where all the science and all the data, which one it supports. So we've looked at several different things. I always told my staff, I said, how can we be wrong? What else could this be? So you have to make what in medicine is called a differential diagnosis and then see what the facts support.
Did you employ a differential diagnosis in this case?
Yes, I did.
Do you have to be at the scene in order to understand or analyze information that you get in a police report or photographs or things of that nature?
No, that we use the police investigation and scene investigation, crime lab reports, photographs taken by the crime lab, by the police at the scene.
Have you qualified as a expert forensic and anatomical pathologist in other courts in Massachusetts and other states?
Yes, I have.
Approximately how many times would you say you've qualified?
Hundreds.
I want to talk for a specific for a second about a specific area of interest for the court. Were you provided information and photographs of John O'Keefe's arm and his arm injuries included with the rest of the autopsy information that you received?
Yes.
Were you asked to make a determination about the nature of the wounds specific to his right arm? I know that there's other injuries to Mr. O'Keefe, but I'd like to relegate your attention to the right arm.
Yes, absolutely. That's what the forensic pathologist does.
Without telling me what your opinion was, were you able to come to an opinion or conclusion about the source of those injuries?
Yes, I was.
What methodology did you employ to come to that opinion or conclusion, or those opinions and conclusions?
My experience and knowledge and training, along with the appearance of the wounds on the right arm, which fit a pattern, and then knowing that it fits a pattern, then I can try to look for, okay, what is the item that caused this pattern? And that would be part of the differential diagnosis that I've used for many, many years in making diagnoses and determinations.
Have you ever been trained in pattern recognition?
Yes.
In what capacity?
Oh, as a forensic pathologist and medical examiner, a large amount of our work has to do with recognizing pattern injuries, because that's so important, because it gives us an idea of what might have caused that injury. And then that's clearly of a lot of importance to the police and the investigators as they're trying then to say, well, what could have caused that injury? And so the forensic pathologist could say, well, I think it was X or Y. Then they can carry out their investigation armed with that information as to what might have caused the injury on the body.
Is there such a thing in the world of pathologists as medical literature or academic literature that deals with pattern recognition?
Yes.
Are you familiar with some or most of those publications?
Absolutely.
Have you ever yourself taught classes on pattern recognition?
Yes.
At what level? High school, graduate school,
At
graduate
the
school?
medical school level.
How often have you taught courses on pattern recognition?
Oh, at least a handful.
When was the last time you taught a course in pattern recognition?
Let's see, last month.
Do any of the courses that you've either taken, well, let's take them one at a time. Have any of the courses that you've ever taken dealt with wound pattern recognition as it relates to animal wounds
Courses that I've taken.
that you have taken?
It's part of our basic training and understanding of a forensic pathologist. The board exams we take test for that. Those injuries are described in our basic forensic pathology and medicine textbooks. They appear continually in our medical and scientific journals.
Is that an important skill set to develop, wound pattern recognition as it pertains to animals as a forensic pathologist?
Absolutely.
Do any of those academic courses that you've either taken or reference works that you just referred to, do any of those deal with dog bites and claw marks specifically?
Oh, yes, they do.
In the course or courses that you have taught related to wound pattern recognition, have you ever taught on the subject of dog bite wounds and the recognition of dog bite wounds?
Yes, I have.
When was the last time you did that?
Let's see, it would be in the course in the medical school. It would have been several years ago.
Doctor, with regard to staying with dog bite wounds specifically, have you ever performed an autopsy that specifically dealt with dog bite wounds, known dog bite wounds?
Yes.
So you've seen them in person?
Yes, I have.
Have you ever been qualified in any court in the land, state or federal court, on the issue of wound pattern recognition as it pertains to dog bites?
Yes.
When was that?
The last one I can recall was a federal case involving questions of a police dog.
Did you engage, in that case, did you engage in a differential diagnosis to determine, in your opinion and conclusion, your expert opinion and conclusion, the source of the wounds that you saw?
Yes.
Did the court qualify you to speak on that issue in court?
Yes,
Did you, in fact, testify in furtherance of your opinions and conclusions in that case?
I did.
I want to turn for a second to motor vehicle accidents or motor vehicle incidents. Do you also, some of the same questions, have you also performed autopsies on known motor vehicle pedestrian incidents?
Yes.
How many times would you say you've performed an autopsy on those issues?
Hundreds, maybe even 1,000.
Is that a relatively common occurrence, as sad as it may be, motor vehicle pedestrian incidents in the field of forensic pathology?
Yes, it is, unfortunately.
Have you performed autopsies personally as well as supervised autopsies on motor vehicle pedestrian incidents?
Yes.
And what methodology do you employ in furtherance of coming to opinions and conclusions regarding cause and manner of death specific to motor vehicle pedestrian incidents?
Well, we look at the scene investigation. We look at what the motor vehicle looked like. We look at hospital records, the autopsy, and then trying to understand how the injuries that the pedestrian sustained, what those mechanisms were, and how the injuries show that that person interacted with the motor vehicle.
In doing so, in coming up with injury mechanism analysis, is it important to look at and analyze the actual vehicle that is allegedly involved?
Yes, you want to look at photographs of that or see it in person.
Is that part of the normal methodology that is employed in the field?
Yes, you must look at the photographs. You must see what the vehicle looks like.
Do you also look at the other side of that handshake? In other words, look at the body of the individual that was, in your case, killed, the decedent, in order to marry the two and determine whether or not the cause and manner of death has something to do with the motor vehicle, a motor vehicle impact?
Absolutely.
Describe that for us, please. What are some of the things that you look for that's part of the normal methodology that a forensic pathologist employs?
Well, when we examine a fatality from a motor vehicle, we want to try to understand what led up to it, how the impact occurred, and then what happened after. So we would study information about the injuries to see if we can relate them to certain pattern injuries that would be on the car. There are also evidence of transfer of energy and injuries that can result from the transfer of energy. So using the body, looking at the scene and the vehicle, understanding the motions of the vehicle and how they would have produced or would not have produced certain injuries on the body.
I'm going to take them one at a time. With regard to animal wounds or dog bites, were you able, in this case, using differential diagnoses, using inferential thinking, and using the skills that you've developed over decades of your education, training, and background, were you able to, without telling me what the conclusion is, were you able to come to a conclusion or opinion as to whether or not the wounds that you saw on John O'Keefe's right arm were consistent or inconsistent with a dog bite or claw marks?
I was able to come to a definite scientific conclusion.
And is that conclusion to a reasonable degree of medical certainty?
Yes.
Is it to a reasonable degree of scientific certainty?
Yes, it is.
Is it consistent with the training and methodology that you've employed over decades?
It is.
I'm going to ask you the same series of questions with regards to the motor vehicle incident. Did you review the autopsy report in an effort to look at John O'Keefe's entire body and all of the injuries that he sustained, not simply his right arm?
I looked at everything.
In doing so, were you able to come to an opinion or a conclusion as to the mechanism of injury and whether or not his injuries in total were consistent or inconsistent with a motor vehicle incident or impact?
I was able to come to a scientific conclusion.
And without telling me what that scientific conclusion is at this point, did you employ the same methodology that you've explained to the court earlier concerning differential diagnoses, inferential thinking, and decades of training, the education, training, and background that you've described for the court in coming to your conclusions about whether or not the cause and manner of death was consistent or inconsistent with a motor vehicle impact?
Yes.
Your Honor, is there any area that I have not covered to the court's satisfaction?
So I'll let Mr. Brennan ask questions. I may have a couple of questions.
Good afternoon, Dr. Lapisada.
Good afternoon.
If we could start with dog bites.
Yes.
Did you have any specific training in wound pattern recognition regarding dog bites?
Yes, it's in our literature standard textbook. It's standard information that is needed to be a forensic pathologist.
When did you receive training regarding pattern recognition of dog bites?
Beginning when I took my board, started in 1983.
And what did that entail?
It entailed reading literature, it entailed reading the standard forensic pathology and medicine textbooks, and it is a sub-part of understanding pattern injuries. Dog bite injuries are described in all our journals and all our standard forensic textbooks.
Other than reading about it when you were studying for your boards, did you have any practical experience where you were engaging in the field in pattern recognition analysis regarding dog bites?
Yes, I've had many cases where there have been dog bite injuries.
When you were studying for your boards, were you doing that, or after you completed your boards?
I'm telling you that that it's such a basic part that during studying for boards, it's a section that we study. And I, of course, had many cases since then.
Did you receive any education past reading literature for the boards, where you took classes, seminars, where it taught specifically wound pattern recognition regarding dog bites?
It's all part of wound pattern recognition. It's usually included in...
And this is part of the problem here, I think, and this is something where when you have an expert that's not in a standard field, you have to point out, like, no, like, this is where she should say, and I'm sure she knows the answer, no, nobody does this only. There aren't dog bite seminars. This is the thing. This is how, this is a question that's never been distilled, and Hank keeps hitting it, and then Jackson and Yannetti never go back to it. Is there any dog bite seminars you can attend? No. Is there a board certification for dog bite analysis? No. Like, it's just something there. I think that's something that hasn't been addressed yet. That's something I really struggled with here. Only bites. No, but you guys understand what I'm getting at. You have to, like, to destroy Hank's arguments, go forward on that part. So.
Literature, if there are lectures about
Oh, real quick, chat. We need to refresh. We're at 425.20. Let's see if we can get some. Let's see if we can get some closed captioning here.
Reading literature for the boards, where you took
Here we go, chat.
classes, seminars.
There
where
we
it
go.
Taught specifically wound pattern recognition regarding dog bites.
It's all part of wound pattern recognition. It's usually included in literature. If there are lectures about patterned injuries, it's a subset of pattern injuries like hammer injuries, like gunshot wounds, like baseball bat injuries. There's a huge number of types.
She should be careful because gunshot wounds are kind of very specific. And also, when you get to the point of like hammers and things like that and edged weapons, you generally get a no, not a sociologist. Oh God, what do you call the person? What do you call the person? The study of humans. I almost said a philanthropist, and I'm like, no, that's not it. What would you call them? A person who studies the use of tools. God, I don't have it in my brain right now. No, not pathology. Anthropologist. There we go. Anthropologist. God, I completely. Like, you'll have an anthropologist who can explain these are tool marks. And you can like using like I told you guys, I think when I was an intern in the prosecutor's office in Toledo, there was a guy who died because some dude beat him with a hammer, took the claws of the hammer, was like bop, 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 all over the dude's head. And when his brain swelled, it was like Play-Doh coming out of an extruder, squeezing through the holes. But she was able to demonstrate it was like a roofing hammer. And the dude just like bop, bop, bop with the claw end. And they had an anthropologist on staff. So, yes, your legal commentary, sir. Yes. Nasty is pretty nasty. The guy, and here's the funny thing. The guy was he was a guy who was kind of retarded. He was developmentally delayed. And he'd get his money every week. And his check would get deposited. And he basically got like $30 funny money for the week and the month for the weekend. And he would go buy a couple of tall boys and a couple like cartons of smokes. And he'd have like a 6-pack of tall boys. And he would just sit there, kind of hang out on the bench out in front of his like mobile home where he lived, out in the mobile home park. And he would just sit there and smoke his cigarettes and drink his beers. Well, he had gotten like 2 or 3 beers in, and then they started noticing 2 or 3 of the beer cans were empty. The other one started becoming a mixture of blood and beer, and as he drank more and more, it became more blood than beer. And this guy was mortally wounded, and he didn't realize he was kind of retarded anyway. So it didn't help him. So he just sat there, kept smoking cigarettes, and just kept on dying. So pretty nasty. Or pretty nasty. That's what I was thinking, though. But doing gunshot wounds, that's actually a very, like, you start, we know so much about gunshot wounds that I don't think that's a smart one to put in there, the way she did that.
Of patterned injuries that are part and parcel of what a medical examiner has to understand and diagnose.
Do you remember taking any specific classes or any specific training about wound pattern recognition relative to specifically dog bites?
Yes, it's in all the literature that I keep up with.
Did you take any training or did you attend any classes that involved wound pattern recognition of dog bites?
Yes, it's often included in our seminars and case reports.
Do you list any of those classes or seminars on your resume?
That I took? No.
Can you identify one of those classes, where it was, when it was, who taught it, what the name of it was regarding wound pattern recognition relative to dog bites?
I can't give you a specific time and date.
Can you remember the name of the last class or seminar that you took or completed that has to do with wound pattern recognition relative to dog bites?
I can't recall.
Is there anything in your report that identifies any of your specific education or training on wound pattern recognition as it relates to dog bites?
It's in my CV. It's basic knowledge that a forensic pathologist has to have.
I will ask you about the CV, but Dr. Lapisada, I just wanted to ask you about your report first. Is there anything in your report that points to any specific training
In the report that I wrote on
in your
this
report
case,
relative to wound pattern recognition as to dog bites? Is there anything in your report that identifies that for us?
in my report, I put together the case of what happened to Mr. O'Keefe.
Okay. As far as your experience, though, do you ever make any note in your report about your specific experience and training about wound pattern recognition for dog bites in your report?
No, it's not appropriate.
In your CV, is there any way you can point to us where you had specific training for wound pattern recognition relative to dog bites, where we can see that on your CV?
No, it doesn't say dog bite training specifically, no.
Do you have anything on your CV that specifically talks about wound pattern recognition for animals?
Those are usually classified within other pattern recognition.
Do you have anything specific that would alert us in your CV that you've had such specific training on wound pattern recognition for animals?
Other than I've passed my board exams and have practiced for 40 years.
Have you provided a list of cases where you have testified in court specifically about wound pattern recognition of dog bites?
I don't know if I have given a list. I don't keep those kinds of lists.
You mentioned one case about law enforcement dogs in federal court. When was that case?
Several years ago.
How long would you say, if you had a guess?
How long was it ago?
Yes, please.
A couple years, around COVID time.
Did you testify in that case about law enforcement police dogs?
I testified about an individual who had injuries, and there was a question as to whether Canine Caper, who was the dog's name, inflicted any injuries on this person.
And this was in Boston federal court?
Springfield, yeah, Boston, right.
Is there a difference between law enforcement dog bites and domestic dog bites?
They have the same kind of dog jaw.
So you would say
They're
that-
taught differently, obviously.
Would the wound pattern recognition be the same or different?
That was the most autistic answer ever. Well, they all bite, they all dog teeth, but they're trained differently, obviously. This woman is not suffering Hank right now. That was hilarious. That was hilarious.
If you were looking at it from a law enforcement dog perspective or a domestic dog perspective?
The dog would be the same.
Do you have any other cases that you've testified about wound pattern recognition relative to dog bites?
I've testified in hundreds of cases. I can't say that I remember any particular ones.
Would you be able to identify any of those for us today?
No, too many.
I'll ask you about accident reconstruction experience. And I mean this respectful. You don't have a biomechanical or a medical engineering type background, do you?
No, I'm not a mechanical engineer.
You're not certified by ACTAR or any of those type of organizations, are you, doctor?
No, I relate the injuries on the body to the motor vehicle.
Have you ever been to a car collision scene and investigated a car collision scene firsthand?
Yes.
And when you've done that, do you have a chance to look at all of the...
Have you ever been to a car crash? Yes. Oh, good job, Hank. Walk into that one, buddy. And Natasha with 10 subs. Let's go, chat, tonight. Thank you guys for being here. Big support. 400, almost 350 people watching, guys. We're doing some good stuff tonight. Keep it up. Thank you. Thank you, Natasha, for your support, your generosity.
The physical materials, the properties?
Well, when I go to a scene of a motor vehicle fatality, I look at the pieces that are scattered around. I look at the body. I look at blood stain patterns. I look at damage to the car. And then the body would go back for the examination at the medical examiner's office. And there would be further examination of the scene by accident reconstructionists and examination of the automobile by specialists who could figure out what motor vehicles do. So it's a part of correlating the injuries to the vehicle.
You've never written an accident reconstruction report yourself, have you?
No, that's not what I do.
I understand. In this case, what materials did you look at? Because I don't think in your report it mentions the materials that you studied. What materials did you study as the basis for any potential opinions regarding accident reconstruction?
Well, so you would like for me to tell you everything I studied in this case?
Yes.
I have my list here. Should I read
That's fine
from
by
that?
me.
Okay. I studied the autopsy report, neuropathology report, toxicology, and associated paperwork from the medical examiner's office. I studied 104 autopsy and neuropathology photographs, 70 additional autopsy photos taken by Trooper Watson. I studied Mr. O'Keefe's medical records from the Canton Fire Department and EMS run sheet. I studied the Good Samaritan medical records that also included 35 photographs of the body. I looked at evidence of Mr. O'Keefe's clothing, blue jeans, t-shirt, sweatshirt, boxers, and sneakers. I'm sorry. I looked at photographs that were taken at the crime lab of various pieces of plastic, black, red, and clear. I studied photographs of the outside of Ms. Reed's SUV as it was parked at the police garage. I studied the Canton Police incident report, about 100 photographs taken by Canton Police of the outside scene. So that gave me a very good idea of what happened to Mr. O'Keefe.
Were you involved in the case Commonwealth versus Daniel Tompkins?
Remind me about that. I've been involved in hundreds of cases.
Yes, you have. This case was in Franklin.
Wow. Hank's like, yeah, you actually have been involved in like hundreds of cases. Hank didn't even try to be an asshole to her because she's such a nice old lady. But this woman has a massive CV. So Hank's like, man, how do you not know? It's like, because I've done this a million fucking times. Well, I guess you have.
County Superior Court. It was a case where you had an opportunity to present testimony and regarding blood spatter, which you've been qualified expert for. I'm sorry.
Well, that doesn't quite say what I did, but I remember the case you're talking about.
Did you attempt, or was there an attempt to have you qualified to talk about accident reconstruction in that case?
No, I'm not an accident reconstructionist.
And do you remember whether or not there was an attempt that was denied to try to have you talk about accident reconstruction in that case?
I have no idea. I'm not an accident reconstructionist.
Okay. Do you have anything on your CV specifically that offers any background on accident reconstruction or accident reconstruction type classes or seminars?
I don't think so.
All right. Thank you, Dr. Lapisada.
No, you're welcome.
So can I just ask Dr.
Yes.
Lapisada about, you said you've been involved in autopsies with dog bites.
Yes.
How many?
I've done thousands of cases, probably 50 or so. It's not always the cause of death. And then I've supervised maybe 75 more where that dog bites were involved in the case.
When was the last one?
Let's see, probably 2 years ago.
Okay. Any questions based on my questions?
So remember what Bev said. If it's only like 5, she's like, absolutely fucking not. So let's see where we go.
All right, you are all set now. You step down, Dr. Lapisada. We'll get to you sometime this afternoon.
Thank you, Your Honor.
I do want to give everybody a break, including counsel. Can we do less than 5-minute arguments on this?
Your Honor, I'll make this very brief.
Okay.
Dr. Lapisada is eminently qualified to speak to both the issue of wound pattern recognition as it relates to dog bites, specifically, as well as cause and manner of death as it relates to vehicle pedestrian incidents or impacts. The doctor has an incredibly impressive resume, just a touch of which we reviewed during the course of this voir dire for her qualifications. But with regard to the dog bite specifically, she talked about the differential diagnosis that she undertakes and undertook in this case. She talks about the inferential thinking that she undertook in this case. She talks about how that is the proper methodology in the scientific community and specific to the forensic pathology community in order to come to a determination about wounds and the source of wounds, i.e., was it a dog, was it another animal, was it another source, was it lacerations versus abrasions, things of that nature. She's obviously done, as she indicated, thousands, if not climbing real close to 10,000 autopsies that she's either supervised or that she's conducted herself. She actually has, notably, as per the court's last question, she's actually undertaken personally somewhere close to, I thought it was probably 5 autopsies herself dealing with dog bites. They're not always the cause of death, but sometimes it's attendant to the injuries that led to a different cause of death, but she's undertaken at least 50, or that's what she estimates, 50 of those autopsies herself. She's seen dog bites, she's seen dog wounds, she engages in pattern recognition, she also teaches classes on pattern recognition as it pertains to dog bites, and she's eminently qualified to speak to that in this particular case. She has been able to come to an opinion and conclusion as to whether or not the injuries to John O'Keefe's arm are consistent or inconsistent with dog bites, and I expect that she would then give that opinion and conclusion to a reasonable degree of medical certainty and to a reasonable degree of scientific certainty. As it relates to her differential diagnosis and her ultimate conclusions concerning the automobile impact, obviously, many more autopsies dealing with that because it's more common. She also engaged in the exact same differential diagnosis. She has training. The subfield of, or the sub-issue of vehicle pedestrian impacts is included and subsumed within much of the medical literature that she's been taught on going all the way back to the 1980s, dealing with her boards, and she's consistently passed her boards. She's consistently kept up with the literature. She's consistently engaged in autopsies herself, so she has firsthand training. She also trains other medical professionals, other doctors, other medical examiners, and she supervises other medical examiners. She's been the chief medical examiner for an entire state. I cannot imagine somebody more eminently qualified to talk about the two subjects that she's been called to talk, well, she's called to talk about several other subjects, but these two subjects that's before the bench right now, than somebody with Dr. Lapisada's qualifications. I will submit on the voir dire that we just completed.
All right, thank you. Mr. Brennan.
I do not think that Dr. Lapisada has articulated the experience the way it's been summarized. She could not provide any specific training other than her boards and her references to literature. She could not articulate one single class or seminar that she took that pertained to differential diagnosis of dog bite injuries. She has no specific memory of having any type of experience in differential diagnosis as far as being in a training seminar or advanced education. She has the experience of a medical examiner who has seen what she believes to be dog bites in the past. She has no publications or references that she has studied the issue of differential diagnosis or pattern wound recognition relative to dog bites. If we look at the standard Dr. Russell employed, Dr. Lapisada does not have any of the merit to be an expert in dog bites. While she has taught, we did not hear about anything in particular that she has taught about specific pattern wound recognition analysis regarding dog bites. She is an experienced medical examiner.
Hold
has a
on.
Wealth of experience,
Hold on.
past experience in
Is
autopsies.
Haight now claiming
but she
that
has no experience that is a basis for her?
Is Haight now claiming Dr. Russell is now credible? Is he claiming she's far more credible than this doctor? Really? Really?
As an expert in being a dog bite expert. Particularly, she mentions one case that she's testified in federal court that we've heard of today, and she has nothing whatsoever in her report or resume to establish that she has used, studied, and knows this methodology. In fact, her CV and her report don't have any basis for one to look at and see that she has any specific experience in dog bites. And so Dr. Lapisada, from the Commonwealth's perspective, should not be able to give an opinion regarding or about whether or not the wounds on Mr. O'Keefe were caused by a dog. She simply does not have the training and experience in education and methodology to make her a so-called dog bite expert. Regarding accident reconstruction, she said it best. She is not an accident reconstructionist. She saw some of the materials in this case, but it is a fraction of the materials in this case. She is not in a position to give an opinion whether or not the wounds are consistent with broken taillight. There is nothing we see on her CV. There's nothing we see in her report. There's nothing we heard on direct examination that she has any experience in breaking glass, breaking plastics, and the causation of wounds. It also overlooks the fact that the opinion that would be offered would extend beyond just the wounds on the arm. It would extend to a general opinion that he was not involved in a collision, and that's improper. There's no predicate or basis for it. So based on her testimony and absence of being able to provide any education or experience, she should not be able to testify about either of these two matters.
Okay, thank you.
Okay. Mr. Brennan suggests that, well, she's only been qualified in one court, federal court. The federal government, the federal judge that was handling that case, qualified her as a dog bite expert in that case. That is not a small thing. That, as a matter of fact, it's a very big thing for Dr. Lapisada and her credentials. In addition, she indicated, contrary to what Mr. Brennan just suggested, she indicated that she has been training on wound pattern recognition as it pertains to dog bites for her entire career, not just when she was studying for her boards, since she's been studying for her boards. And it's been constant and consistent throughout her entire career. She's made these differential diagnoses. She's seen the autopsies. She's seen the wounds during autopsies firsthand, probably 50 or more. She's supervised another 75 or more autopsies dealing with known dog bite wounds. She has the credentials. The court will recall that, for instance, Dr. Isaac Wolf was called to testify by the Commonwealth. He had absolutely nothing, no credentials whatsoever to talk about wound pattern recognition. He was a neurosurgeon. And yet he was allowed, over Mr. Alessi's objection, to talk about and to discuss his opinions and conclusions as to the wound pattern on the back of John O'Keefe's head.
Very
Certainly,
good points.
Dr. Lapisada brings much more to the table than Dr. Isaac Wolf. I'm not comparing them. They're apples and oranges. Dr. Lapisada is she doesn't have to be a sole dog bite expert to be expert in dog bites. She doesn't have to be Dr. Russell. She just has to have that level of knowledge, that level of skill, that level of expertise that's beyond that of the average layperson in order to opine as an expert on a particular issue. She certainly brings that to the table as it pertains to dog bites, and I think her skill and her education, training, and background certainly speaks to the fact that she has that in spades with regard to motor vehicle pedestrian incidents.
All right.
Awesome.
Thank you. All right, I'll get your ruling as soon as I can. So we're going to start back up at 20 past 2, and I expect to go straight through the rest of the afternoon.
All rise for the court, please.
So, I mean, I don't know what's going to happen here, but I already know what Bev's going to do. She's going to say no. She's going to say screw this judge or screw this witness. We'll see. We'll see. We'll see here. We'll see. Yeah, it doesn't really matter. Bev is such a shitty judge. She will still deny no matter what happens. And no matter what comes her way. So. Just a thing. Just a thing here, chat. Just a thing. But let's see what happens. Everybody goes to lunch. Bev's like, I need a margarita. I need a margarita now. All right, so here we go, chat.
We're back in session. You may be seated.
All right, I appreciate the court personnel waiting so that we could have that voir dire. It was helpful. All right, so my rulings are very similar than they were this morning. So first of all, on the Darbert analysis regarding Dr. Lapisada being able to testify as to the dog bite wounds, I find that she is not qualified. I'm not satisfied that the Darbert requirements have been made. Specifically, not just the experience, but the reliability of the methodology she used and how it was applied. So based on that, she cannot testify to the dog wounds. And I want to take a minute to differentiate this testimony with Dr. Russell's. I found that Dr. Russell was an expert, qualified to testify as to dog bite wounds, mainly from her experience in the ER, coupled with her being an ME. Dr. Lapisada does not have that experience. I found that Dr. Russell's methodology was reasonable and was sufficient, and I found that it was appropriately applied. Remember that Dr. Russell was published in the area here. So regarding pages 10 and 11, all of the text on Dr. Lapisada's report on pages 10 and 11 that start with the injuries on Mr. O'Keefe's right arm are excluded. Now, moving on to the testimony regarding not being consistent with a motor vehicle strike, I find that Dr. Lapisada's opinion on these not being the result of a motor vehicle collision exceed what is within her scope of expertise in some regards, not in all. In some regards, significantly, like I said this morning. So on page 17.
How in some regards? She's a doctor. The fuck is wrong with this woman?
The first sentence is in. The second sentence, tail lights are typically made of durable polycarbonate or acrylic plastic. That is out. I know the Commonwealth objected to, but I'm letting in. Mr. O'Keefe's patterned injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting the arm. She cannot say tail light, but she can say that based on her experience.
Why can't she say tail light? Why can't she say tail light? Because as part of her job as a thing, she had to examine the whole case file. Why can't she say tail light? You are sweeping fucking... Bev, you are a scumbag.
Bruising from impact, that also comes in. In the next sentence, neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes at various angles and depths. That's within her realm of expertise as a medical examiner. The next page, though, I may have said this morning that first sentence, importantly, in review of that, in review of the Tompkins case, that first sentence stays out because to me, it seems like that sentence depends on a biomechanical analysis, factors such as speed and force and the position of Mr. O'Keefe. So that's, I'm sorry, page 18, the next page regarding the same subject matter. And portion of the next sentence is also out. This results in bruising or bleeding under the skin. That's out. But Dr. Lapisada can testify that Mr. O'Keefe had no bruising on his arms or torso. And that's it for that sentence. In particular, Mr. O'Keefe did not have bruises on his legs as shown by dissection of leg tissue and muscle at autopsy. That's it for that. And the conclusions are problematic to the extent that is consistent with this ruling and what we discussed on Friday. So that's it. That was just the text of her report. I have not begun to go through all of there's no PowerPoint with this, Mr. Jackson, right?
There is no PowerPoint.
All right. Do you intend on displaying any of these photographs?
I'm sorry.
Do you intend on displaying any of the photographs that are in her report?
Yes, I have to go through it now, of course.
All right, so you likely not get to that today. We've done important work, but we've wasted an awful lot of the jurors' time today. So I want to bring them in. And
That's on you, Bev. That's on you, honey.
We have to finish that.
right, we're going to do that now. So that'll give you an opportunity to pull your thoughts together.
Right, and I expect what I would do is my intention. I will go through her thing. That will take me a good amount of time. I will go through the part of her initial analysis that will not include any photos, but I may be organized to actually go through the court's ruling. It's very specific, and I'm going to be as
Okay, so
that as possible.
let me know what you intend to put in. All right, and there's a lot of text describing the photos that is out, right? It's just hearsay.
I mean, we've had Dr. Welch's PowerPoint.
That was not objected to. There's a big difference.
Yes, it was objected to.
So we'll deal with this tomorrow, with the photographs
I
tomorrow.
just want to let the court know. Now it's the court's time.
Okay, thank you. And we're bringing the jurors in. Did the Commonwealth want to respond in any way?
No, thank you.
Okay. And there's a motion on Dr. Rentschler. We will give that, I haven't read it yet. We'll give that no more than 5 minutes.
She literally did everything Hank wanted. So Hank's like, I'm good with this. And Bev's too stupid to realize, oh my God, I just did everything Hank wanted.
Tomorrow morning, each side. This jury, you can tell just by looking at this jury, they're fed up. So,
Your Honor, the only thing I want to put on record is, with regards to the court's ruling, I do want the record to reflect, that is, obviously, it's over the defense objection.
Sure.
And I just want to make for the record a quick comment. The Commonwealth waited until June 5th to even bring this up, to file a motion regarding Dr. Lapisada. They had a report, and all reciprocal discovery was done in March 6th, 2025. That's document number 45.
Yeah.
And the Commonwealth was ordered to file whatever motions they wanted to, whatever motions in limine they thought were appropriate by March 7th. And they did not do that. They were supposed to be heard on March 18th.
okay, so the jurors are coming in. We're going to mark the report and the CV for identification.
I just need to know when I can make it.
You just made it.
I made it ish.
Okay. Okay.
The point is,
Go ahead, real quick.
the point is, the Commonwealth has not explained the delay
So-
in making this motion. They haven't, and we're playing by the same rules, Judge.
So the basis of my ruling was not late disclosure. Okay? Late disclosure. Commonwealth says they're part.
That's not the court's missing the point. It's the opposite. We got late disclosure. We got late disclosure that they were objecting. They've had since March to object. They moved the motion in limiting time, and then they come in just before Dr.
All right.
Lapisada testifies, and now they're sort of sandbagging this and getting court moves against us. So I want to make sure that the record imminently clear.
Very clear. Mr. Brennan, do you want to respond real quickly?
Your Honor, we can always object even during proffering testimony. There's no foundation. It's a foundational issue.
And that's consistent with what my rulings were when I allowed other witnesses to testify that the defense could object if the foundation weren't properly laid. So bring them in, please.
Rise the jury.
Guys, I mean, it's really coming down to for Bev. It's like you have to be a doctor who only does dog bites. You only do dog bites. You do so many dog bites. You bite dogs.
Okay. All right, Ms. Giannetti, is your witness ready? All right, Mr. Tedman, whenever you're ready, sir.
Thank you. Thank you, Your Honor. Sir, before the lunch break, you had identified 3 entrances to the front of 34 Fairview, leaving aside the 2 garage car doors. Do you recall that?
Yes.
May I have that last exhibit displayed, please? Not that one, the one that we discussed right before. There it is. Maybe zoom in on that a little. Okay. What do you see on the screen at this point, sir?
I see the 2 rightmost entrances to the house, excluding the main front door.
Okay, which would be obviously to the left
To the
of this
left.
photo, particularly with regard to the third entrance, the one in red. Could you describe that?
Yes, so it's if you're facing the house from the street, you're looking towards the west. So that door goes directly into the garage facing north.
Okay, so basically from the street, you don't have to enter the house, you can go into the garage directly.
That is directly into the garage, yes.
All right, and as we're looking at the house from this point, are we looking at it from the vantage point of Fairview Road?
Yes,
And that is a westerly direction toward the house, sir?
correct.
In the course of doing your further work that you were asked to do in this case, did you peer inside the garage?
Yes, I did.
Did you see concrete steps and a ridge there and a hard concrete floor?
Yes.
Sustain. Jurors disregard that answer.
You mentioned that you were asked to do some measurements. Can you describe what you were asked to do for the jury?
Yes, I was asked to measure from basically the mailbox area of the driveway to the various entrances to the house.
Did you take those measurements?
I did.
Okay, if I'd like to take them one at a time. First, did you measure from the end of the driveway next to the mailbox all the way to the main front door, which is not depicted on this photo?
Yes, I did.
How did you measure it?
I used my wheeled measuring device, and I walked directly across the lawn to the front door, well, to the bottom of the front steps, and then used it to go up the front steps straight to the door.
And what was the measurement, if you recall, from the mailbox area near the end of the driveway to the main front door on the left?
I believe it was 65 feet 9 inches, but I have notes if I
think you got it right, sir.
Okay.
Next, did you measure from that same location near the street, the end of the driveway next to the mailbox, to the second front door, which is actually depicted in the exhibit that's on the screen?
I did.
And how did you measure that?
I walked along the edge of the driveway on the asphalt, right next to the grass, towards the house from the mailbox and the edge of the street, towards the house. I took a left onto the brick walkway, proceeded along that walkway, then took a right to the walkway that you can see right there, heading directly to the door, and went up onto the little decking area, and then those 2 steps directly to the doorstep.
Okay, so you walked essentially almost the whole length of the driveway?
Yes.
Before you took the left to get to where the steps start, going to that second front door?
Yes.
And then went up to the door itself?
Yes.
Do you recall from your memory what the measurement was?
I believe it was 70 feet 1 inch.
And finally, did you measure from that same end of the driveway near the street next to the mailbox to the red side door, which is the pedestrian entrance into the garage directly?
I did.
How did you measure that?
I did the same thing, walking directly from where the mailbox and the driveway intersect, basically, all the way up the driveway, took the same left onto the red brick pathway, took a right to go towards the front door, went up the 1 step that you can see, and then instead of going up the next 2 steps, I took a right directly towards the garage entry door.
So essentially the same path of travel, it's just you didn't go straight into the second front door, you took a right to go into the pedestrian entrance to the garage.
Correct.
And what was the measurement that you discovered having done that?
I believe it was 78 feet 3 inches.
Now, finally, could we have displayed the map of Cedar Crest, Fairview, and Chapman? There it is. Sir, are you able to see the street names from where you are? And if
Yes.
not, could we have the top street magnified so that the witness can see it? Okay, you see that?
I do.
What do you see that to be?
Cedar Crest Road,
Okay, if we could have the connecting street where the, that's it.
Fairview Road,
All right, and finally, the one down the bottom?
Chapman Street.
Okay, if we can get the whole map back up. Having seen those 3 street names, does that orient you as to what this is a map of?
It does.
And what is that?
This is the surrounding area of 34 Fairview Road, the neighborhood, basically.
Okay, and it includes the 2 connecting streets on either end?
Correct.
Does the red dot symbolize anything for you?
It looks to be where 34 Fairview Road is located.
Okay, and if you're on Fairview Road to the right of that red dot as it exists on that exhibit, and you're looking toward Fairview Road, what direction would you be facing?
It would be facing west.
If I may have a moment to...
Okay.
Questions, thank you very much, sir.
Any questions?
Yes.
Good afternoon, sir.
Good afternoon.
You had a wheel to measure?
Correct.
And so there's like a tape measure, and when you wheel it out, it gives a straight line?
No, it's two wheels with a meter in between them, and you roll it out in front of you.
I see. Your first measurement was from the driveway to the front door?
To the main front door to the far left, yes.
And that was about 63 feet?
I believe it was 65 feet, something like that. I have
65?
my notes, yes.
So suffice to say, if you were to leave the front door and come back to that spot, it would be an additional 65 feet back, right?
Yes.
The second measurement was from the bottom of the driveway to the middle door on the side?
Yeah, the second front door, yes.
Did you say that was about 70 feet?
It was, yes.
Okay. And again, if you were to come back, that would be an additional 70 feet?
It would.
And the last one was the door near the garage. Did you say that was further, around 80 feet?
78 feet, 3 inches, I believe.
So one way?
Correct.
And back is another 78 feet?
Correct.
When you measured these, was it from the asphalt of the driveway or to the left of the mailbox as you're looking at Fairview?
It was to the right of the mailbox on the asphalt, as close to the mailbox as I could get.
Did you happen to take any measurements from the flagpole to the front door as far as distance?
I did.
And what was that?
I do not have the exact measurements. I'm not sure.
Do you have it in a report? That you
I
could
don't.
look at?
I don't. No, not with me.
How about the flagpole to the middle door on the side? Did you take any measurements of that?
I'm not sure I took that one.
How about the flagpole to the furthest away door, which would be the door next to the garage? Did you take any measurements of that?
I think I took a direct measurement to that, yes.
Right. And what was that number?
I don't know.
Do you have a report you can share with us?
I don't. No, I'm sorry.
It's okay. Did you ever measure if you were at the flagpole area, how long it would take to walk up the street? Or how far it would be to walk up the street, up the driveway, to any of those doors? Did you ever measure it that way?
I did.
And what was the distance if you were going to start at the flagpole, walk up the street, up the driveway, down the walkway to the front door?
I'm not sure that distance. Not positive the distance.
Was it over 80 feet?
It was.
And if you did the same route up the street, up the driveway, to the middle door, would you agree that would be well over 80 feet as well?
Can you repeat the question? How?
Sure. If you were to measure from the flagpole, up the street, up the driveway, to the middle door, that would be well over 80 feet?
Yes.
Same to the door next to the garage?
Yes.
Thank you for your time.
Thank you.
All right, you are all set, sir. Thank you very much.
Okay, guys, so that sets up the whole thing about John O'Keefe, like, you know how he could have gone 80 feet where he was walking around? That sets up he could have gotten to the house.
Okay, Mr. Jackson.
Thank you, Your Honor. We would ask the court to ask Dr. Elizabeth Lapisada to join us.
Okay.
And it's very interesting. It's very interesting. Hank wasn't acting like a big dickhead there. And he could have been. That's a guy you could have acted like an asshole to. But Hank just left him alone. It's kind of weird. Who Hank pick and chooses to fight with is very weird. Yeah, he asked a bunch of vague questions. Like, it was very weird how Hank handled that. Like I said,
You promise that the evidence you report in jury in case anyone learns the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Good afternoon, Doctor.
Good afternoon, Your Honor.
May I inquire?
Yes.
And Dr. Lapisada, please speak right into that microphone,
I
okay?
will.
Thank you.
Doctor, can you please state your full name and spell your last name for the jurors?
Yes, Dr. Elizabeth Lapisada, spelled Laposata.
I'm going to ask you, you have a softer voice. I'm going to ask you to pull that microphone right under your chin, if you don't mind. It's pretty adjustable.
Okay. Better?
That's better.
Okay.
That's better. Doctor, can you tell the jurors what you do for a living?
Yes, I'm a medical doctor and I subspecialize in forensic pathology.
Can you summarize your professional background?
Certainly, I graduated in 1975 from Bucknell University with a Bachelor of Science in Biology. I went to University of Maryland School of Medicine, where I graduated in 1979 with a Doctor of Medicine. I did my internship and fellowship at Johns Hopkins Hospital in Baltimore, where I studied anatomic pathology, which is the study of the diseases of the body. I then did my subspecialty fellowship in St. Louis in forensic pathology, which is understanding causes of death and injuries to the body.
Currently, are you a professor?
Yes, I am.
And tell us where you work.
I own my own independent consulting practice, and I'm also an associate professor at Brown University School of Medicine.
How long have you taught at Brown University School of Medicine?
Since 1993.
And how long have you been a clinical associate professor of pathology either at Brown or before that?
Oh, gee, then that would have been since at least in the late 80s. I've been associate professors at the universities and medical schools where I've worked.
Doctor, at Brown University, let's take Brown first. What do you teach there?
I teach the second-year medical students. I teach a lecture in diseases of the heart, cardiomyopathy and myocarditis, and I've been asked to give some specialized lectures in toxicology and forensic pathology.
Are you responsible for training medical students in the field of forensic pathology?
When I was a chief medical examiner, yes, we would have medical students, residents come into the office so they could learn about what we do to understand cause and circumstances of death.
When you first got your medical license, did you then undertake to get certain board certifications and the like?
Yes.
Before we get to those board certifications, did you begin a practice in forensic pathology in some way or another?
After I finished my medical school and my anatomic fellowships and forensic pathology fellowships, then I was working in medical examiners' offices where I was examining deceased people to understand how they died.
When you get a medical license, is that statewide or is it nationwide?
Usually you get a state medical license.
And do you hold a state medical license?
Yes.
How many?
I have an active medical license in Rhode Island where I have my consulting practice, and I have inactive license in Maryland, Delaware, Missouri, Pennsylvania.
And you've been previously, at least before they were inactive, you were licensed in all 5 of those states?
Yes.
You already told us a little bit about your college. Did you mention Bucknell University? Your Bachelor of Science degree?
I think I did, yes.
At some point after you graduated from the University of Maryland School of Medicine, did you complete any residencies?
Yes, I did my residency at, at Johns Hopkins Hospital in Baltimore in anatomic pathology.
Forensic pathology is different from anatomic pathology, correct?
Yes.
Did you also do any kind of residency in forensic pathology?
Yes, I did a fellowship in forensic pathology.
And what is the difference between, if you can sort of take us through that little by little, what is the difference between forensic pathology and anatomic pathology?
Anatomic pathology is sort of hospital-based pathology where we understand diseases of patients who are in the hospital and try to make clinical pathologic correlations to see if their diagnoses were correct, if the laboratory tests actually showed what we find at postmortem. And then forensic pathology deals more with understanding why the body stops functioning at a particular time. So that would be cause of death, and that can be sudden unexpected death or death due to violence.
And in forensic pathology, is that often associated with testimony in court cases that may deal with either on the civil side or the criminal side, coming in and testifying about things like cause of death and manner of death?
Yes.
What types of cases did you work on during your forensic pathology residency?
Oh, sudden unexpected natural death, gunshot wounds, knife wounds, sudden infant deaths, blunt force trauma, skeletonized remains, decomposed bodies, strangulation, the whole gamut of ways people can die unnaturally.
And what type, to contrast that, what types of cases did you work on during your anatomic pathology residency?
There you're mainly dealing with natural diseases and understanding heart disease or how somebody gets pneumonia, or looking at the brain to understand if a stroke was present. And that's especially important then to the doctors who are treating those patients, that they can see if the diagnostic tests were appropriate or if their treatments worked.
You mentioned fellowship a little earlier in your testimony. What is a fellowship?
A fellowship is after you've done your internship and residency. A fellowship is more specialized training, and I did that in forensic pathology.
So that answers my next question. You do hold a postgraduate fellowship position, correct?
Yes, yes.
And that was in forensic pathology specifically?
I'm board certified in anatomic and forensic pathology.
Were you a research associate at the Department of Pathology and Laboratory Medicine at University of Pennsylvania School of Law?
Yes.
I'm sorry, School of Medicine?
Yes.
Old habits. What about postdoctoral research fellow? Were you ever a postdoctoral research fellow?
Yes, I did. I had an NIH research grant where I worked on, how alcohol affects the heart.
Where was that?
That was at St. Louis University, and then when I was on staff at the hospital of the University of Pennsylvania in Philadelphia.
What about postdoctoral research fellow at dealing with the cardiovascular division of the Department of Medicine at Washington University?
Yes, that's where I did research on how alcohol affects the heart.
Was all this in furtherance of your broad education and training as a pathologist?
Yes.
I think you indicated that you have served as a chief medical examiner in answering one of the previous questions. Can you tell me a little bit about that?
Yes, I was appointed chief medical examiner for the state of Rhode Island in 1993, where I was responsible for all unexpected, unnatural deaths or deaths that involve violence in the state of Rhode Island. So I had to supervise the office, make sure I have adequate staff, made sure my forensic pathology staff were doing a good job, made sure I had an adequate scene investigative staff, so running the whole office.
Is that the highest appointment in the OCME's office?
Yes, it is.
In that position, did you oversee every single medical examiner in the state of Rhode Island?
Yes.
Did you also hold a position as the co-chair of Child Fatality Review Committee in the state of Rhode Island?
Yes, as part of being chief medical examiner.
Tell us a little bit about that. What was that appointment?
Well, there's a big concern about infants who die and children who die. So those are reviewed specifically by a group of doctors from the pediatricians and also then the medical examiner's office. So we look at every child and infant death.
How long did you serve as the chief medical examiner in the state of Rhode Island?
For 12 years.
Starting when and ending when?
Starting in 1993 and ending in 2005.
As the chief medical examiner for Rhode Island, did you ever have the responsibility to work on any mass disaster cases?
Unfortunately, yes.
Okay, tell us a little bit about that. If you could start with the Egypt Air issue.
Yes. Excuse me, I'm so sorry. In 1999, the Egypt Air 990 took off from New York airport, and it crashed off the coast of Massachusetts, and 2,065 passengers died. And because of the force of the airplane going into the water, all the bodies were fragmented. So all the fragments were brought to my medical examiner's office. They actually vacuumed the ocean floor, and we had 2,600 some fragmented remains from that airplane crash, and that involved working with FBI, TSA to identify those individuals and understand exactly why they died.
What was your role and the role of your staff that you supervised in dealing with those other government agencies, the FBI, the NTSA, other entities, in terms of the fatalities that you did review as a medical examiner, the chief medical examiner of Rhode Island?
Well, I dealt with families from around the globe who had relatives on that flight, and then the FBI was looking into what may have caused the crash. The Egyptian government, who owned the airplane, was also there and interested in understanding what happened. And we were also, tasked with identifying everybody who was on the plane and to see if that matched the passenger manifest list. So were there people on the plane who shouldn't have been on the plane? So that sort of thing.
In terms of matching that manifest, were you the head of the department for the medical examiner's office that was responsible for trying to figure out who was on the plane and match those remains with the individuals that were on the manifest?
Yes, we made the positive forensic identifications and returned the fragmented human remains to their families.
Doctor, did you also deal with the tragic Station nightclub fire?
Yes.
In what capacity did you deal with that?
Again, this was a nightclub that burned down. It burned down very rapidly with a very hot fire, and that was in Rhode Island, and there were 100 fatalities from that. So those come to the medical examiner's office. I had my investigator at the scene throughout that time of recovering the bodies, and I was charged with determining the identity and the cause of death.
Were you successful, or your staff successful in determining the identity of most of those individuals who perished?
Yes, all of them. We worked around the clock for 3 days to get that done.
And you were the head of that task
was.
force. Before you became the chief medical examiner in Rhode Island, did you previously work as a medical examiner under somebody else?
Yes.
Tell me about that. What was your first post as a assistant medical examiner?
My first post was after I did my fellowship training in St. Louis, Missouri. I was an assistant medical examiner for the city of St. Louis.
Were you ever an assistant medical examiner in Philadelphia?
Yeah, so after St. Louis, I moved to Philadelphia, where I was on staff at the hospital of the University of Pennsylvania, and I ran the autopsy service there at the hospital, and I was also an assistant medical examiner for the city of Philadelphia. After that, I was an assistant medical examiner for the state of Delaware, and then I came to Rhode Island as I was chosen to be chief.
Dr. Lapisada, can we put dates on that? Assistant medical examiner in St. Louis from when to when? Do you remember?
Oh my, let's see. May I look at my CV?
Sure, with the court's permission.
Yes.
Okay. Yes, from 1983 to 85, I was an assistant medical examiner for the city of St. Louis. Then in 87 to 91, I was the assistant medical examiner for the city of Philadelphia. 91 to 93, assistant medical examiner for the state of Delaware. And then 1993 to 2005, I was chief medical examiner for the state of Rhode Island.
Thank you for that. Dr. Lapisada, have you held any faculty positions as in field of forensic pathology that qualify you as an expert in this case?
Yes. Every medical examiner's office I worked in, I also had faculty appointments to teach medical students and pathology residents. So I had faculty appointments at Washington University School of Medicine in St. Louis, at the Hospital University of Pennsylvania, in Philadelphia, and in Rhode Island.
Let's talk about those one at a time. Describe your teaching responsibilities at Brown Medical School, if you wouldn't mind. And that, by the way, that's from 1994 to present, correct?
93 to, well, as a medical examiner, it was 1993 to 2005. And there I would teach the medical students. We had rotations through the medical examiner's office, and also the pathology residents would rotate through the medical examiner's office, where I would teach them how to do a medical legal autopsy, how to understand the cause and manner of death, especially non-natural and traumatic deaths.
With regard to your teaching responsibilities specifically, are you still teaching?
I'm teaching in the cardiovascular section now, but since I'm not chief of the medical examiner's office, I obviously don't have students rotating through there anymore.
Were you a lecturer in the role of medical examiner? Did you do a seminar in that regard at or associated with Brown University School of Medicine?
Yes.
Did you do some sort of a forensic pathology rotation for pathology residents from 1994 to 1995 in that capacity as well?
Yes, we would have the pathology residents who were at the hospital studying anatomic pathology come to the medical examiner's office so they could understand the discipline of forensic pathology.
What is cardiomyopathy?
Cardiomyopathy is a muscular disease of the muscles of the heart.
And what is myocarditis?
Inflammation of the heart muscle.
Did you ever teach or lecture on those issues?
Yes, I teach every year. I teach the second-year medical students about those heart diseases.
Have you ever taught anatomy and physiology to EMTs?
Yes.
Or in the EMT setting?
Yes.
I was going to say, is she talking about myocarditis? Jack, she can talk about the clot shot! Surprised Bev's like, sorry, we only have vaxxed people in this courtroom.
Yes.
And what about
vaccine?
A class known as the 2-hour primer on forensic pathology?
I've taught a lot. I don't recall that particular.
How about pathology residents morning conference in 2009?
Oh, yes. I give lectures to the pathology residents at the medical school at Brown Medical School in forensic pathology.
You also mentioned that you were an adjunct professor for biomedical forensic sciences and forensic anthropology in the Department of Anatomy and Neurology. Is that a division of the graduate school, Boston University School of Medicine?
Yes, I taught in the master's program in the medical school at Boston University School of Medicine for a master's in forensic science, where I taught a 40-hour course on forensic pathology and another 40-hour course on medical legal death investigation.
Were you actually the course director in that position?
Yes.
And were you also a course director in medical legal death investigation from 2006 to 2013?
Yes.
And what about a course director in forensic toxicology from 2006 to 2012?
Correct.
Did you direct the studies in biomedical forensic sciences, GMS, from 2012 to present?
Yes.
Describe that. What is that?
The graduate medical sciences?
Correct.
Okay, yeah, I would review and be on the board to examine projects that the students were doing to get a master's degree.
Were you also an assistant professor in the Department of Pathology and Laboratory Medicine at University of Pennsylvania School of Medicine?
Yes.
Without going into every single class that you taught, did you teach from 1987 to 1991 attending staff medical pathology?
Yes.
What is that? Just a general outline of what that teaching course was.
That's when I was at the hospital, University of Pennsylvania. I ran the autopsy service, so I taught medical students and pathology residents about autopsy practice.
I want to ask you sort of broadly, can you describe your major teaching and clinical responsibilities when you were at University of Pennsylvania School of Medicine in the field of forensic pathology? What were your main clinical and teaching positions?
Well, I ran the autopsy service there, so I taught the medical residents and medical students autopsy pathology, and I was also a assistant medical examiner there, so I taught and started the forensic fellowship in forensic pathology.
Have you ever been qualified as an expert witness in forensic and anatomic pathology in state and federal courts?
Yes.
How many times would you say you've qualified as an expert?
Over 40 years, maybe several hundred.
How about in Massachusetts?
That includes all of them.
Okay. Have you ever qualified? Let me list a couple of states. In Massachusetts?
Yes.
California?
Yes.
Connecticut?
Yes.
Delaware?
Yes.
Florida?
Yes.
Illinois?
Yes.
Maryland?
Yes.
Minnesota?
Yes.
Missouri?
Yes.
New York?
Yes.
Pennsylvania?
Yes.
Rhode Island?
Rhode Island, yes.
Have I left anything out?
Did you say Massachusetts?
I did.
Okay,
We
then you're
started
fine.
with Massachusetts.
Okay, you're fine.
What types of topics have you qualified to testify about as an expert forensic and anatomic pathologist?
Really, anything that has to do with circumstances and cause of death. So it doesn't really matter, what type of injury or a sudden unexpected death. Usually it involves examination, study of information from the scene, information from the autopsy, police and investigation and medical records, and we put that all together and figure out the circumstances as to how someone died and why their body stopped functioning. So that's the basis of forensic pathology.
Dr. Williams, excuse me for just a second. You want to maybe approach with one brief.
Okay, well. All right, let's skip ahead here. Geez, I think she's like the kid from Malcolm in the Middle, where it's like, we need to talk about the things. I just waiting for her to fucking die.
Jurors, rather than send you downstairs and back up the stairs to come back in 5 minutes, I'm gonna sit here, you all can sit here, we're just gonna be in recess for 5 minutes while we sit here.
5 minutes.
As an expert by those courts.
All right, here we go, chat.
You can have a seat.
May I inquire?
Yes.
Thank you. Dr. Lapisada, you mentioned several topics about which you testified and qualified as an expert. Testified as an expert in several different states, several different courtrooms. Have you been qualified as an expert by those courts in those topics about which you just discussed?
Yes.
Do you hold any specialty certifications in the field of forensic pathology?
Well, I'm board certified in forensic pathology.
What about the American Board of Pathology?
Yes, the American Board of Pathology puts forth examinations that are a 2-day examination in the various disciplines of pathology. And if you successfully complete those examinations, then you become a diplomat of the American Board of Pathology in whichever subspecialty you're in. And I became a diplomat in the subspecialty of anatomic and forensic pathology.
What about a certification in basic bloodstain pattern analysis, the International Association of Identification?
Yes, I had a week-long course in understanding blood pattern analysis.
Can you tell us a little bit about the National Registry Emergency Medical Technician certification that you hold?
Yes, I took a training to become an EMT.
Have you received a number of honors and awards in the field of forensic pathology?
I have.
What do those awards include?
May I look at my CV again? Sure. Thank you. I had teaching awards from Brown University School of Medicine. I was featured in a book by Faces of Public Health as having run a good medical examiner's office. I was nominated for Woman of the Year in Rhode Island for my work as chief medical examiner in improving the office and handling those 2 mass disasters. I was honored by Victims' Rights and Services Awards because I've always been aware of the fact that as a forensic pathologist, I am the last doctor this person is going to have, so I try to help the family understand what happened. I was honored for my work in the mass disaster in Egypt Air 990 plane crash. Let's see. I was Outstanding Woman in Public Service for Providence, Rhode Island. I've gotten teaching awards from Brown University School of Medicine. I was elected to the Board of Trustees in the Delaware SIDS Foundation and the Philadelphia SIDS Foundation. And then we're back to my medical school.
If you could pull the microphone a little closer to your chin.
It's very hard because the chair doesn't push in.
Oh, the chair doesn't move. Okay.
Oh, I got it. I moved.
We'll make do.
Okay.
Thank you, Dr. Lapisada. What is the American Academy of Forensic Sciences?
That's one of our medical associations that is specific to forensic sciences.
Have you ever held a chaired position there?
Yes.
What position was that?
I was voted into a fellowship position.
Were you the chairman of Forensic Science Research, the Forensic Science Research Committee?
Yes.
What's the National Association of Medical Examiners?
It's also called NAME. It's another international association of forensic pathologists.
Were you a member of that organization?
Yes.
And at some point, did you get elected to the board of directors for that organization?
Yes.
And ultimately, did you become a fellow for that organization?
I did.
What is the American Society of Clinical Pathologists?
That's a society that is for people who practice anatomic pathology and understand how to interpret laboratory results and biopsies.
Did you become a fellow in 1991 until present for that organization?
Yes.
What's the difference between a member and a fellow?
A member is a lower level, and then you can be promoted to fellow if the board of directors feels that you've contributed in your field.
And were you associated with the College of American Pathologists?
Yes.
Were you a fellow there as well?
Yes.
What about the World Association for Medical Law?
Yes.
What about the American Association for Clinical Chemistry?
Yes, I'm a member.
Rhode Island Medical Women's Association, what is that?
Well, it's basically what it says. It's women doctors in Rhode Island.
Were you elected to the board of directors for that organization?
Yes,
Ultimately, were you elected as the president of that organization?
I was.
This woman, like, I love how Bev said she doesn't know what the fuck she's doing. And when you listen to her, it's like, how the hell else could somebody know what the hell they're doing here? This is probably the most qualified person, like, of doctors and medical examiners you could have. This woman is probably one of the best. And Bev's like, well, I don't think she could talk about that. It's like, honey. Although I wonder, does she know the difference between a woman or not? Like, can she tell what is a woman? But this is ridiculous. This is ridiculous. Listen to all this, and Bev's like, no, you can't talk about that. It's like, Bev, you are fucking retarded.
Rhode Island Medical Society, what is that?
It's an organization of doctors who practice in Rhode Island.
Are you a council member there?
Yes.
And what about the Massachusetts Medical Legal Society?
Yes, I was a member there. They have disbanded since.
It doesn't exist anymore?
No.
When it was up and running, you were a member in good standing?
Yes.
Good, good. Pennsylvania Association of Pathologists, what about that?
Yes, when I practiced in Pennsylvania, I was a member of that organization.
Did you, in addition to be a member there, did you also hold a chaired position? Were you the chairman for the Committee on Forensic Pathology?
Yes.
Have you served on any editorial boards of any scholarly journals or
Yes.
publications? Tell me about that.
I've reviewed articles submitted for the Journal of Forensic Sciences and the National Association of Medical Examiner journals.
Did you also hold an editorial position for the American Journal of Forensic Medicine and Pathology?
Yes.
Is that one of the medical journals that is used throughout the country by other medical professionals, other medical examiners?
Yes.
It's a resource?
Yes.
And a text?
Correct.
Have you authored any peer-reviewed publications in the field of forensic pathology?
Yes, I have.
Can you tell us about some of those publications?
Let's see if I can here. Yeah, I've written chapters in textbooks about medical legal death investigation and forensic pathology. I've published articles involving alcohol metabolism, some drugs, cocaine. Let's see. Alcohol metabolism in the heart, I mentioned. Let's see. And so I published 22 papers, and I've written several chapters.
22 papers.
You already said that you're board certified, double board certified in anatomic and forensic pathology. Is that correct?
Yes.
Now that you've gone through your
Anatomic
education, training,
anthropology,
background,
there we
publications,
go.
teaching positions and chairs that you've held, I want to ask you a really simple question. What does a forensic pathologist do?
Yeah. We are the last doctor that the dead person has, and we figure out what happened to the body to cause their death. And we sign the death certificate that says how the body came to die and also indicates the circumstances under which the death occurred.
Are medical examiners also tasked with determining both manner and cause, not just one or the other?
Both, yes.
What is the manner of death and how is it distinguished from the cause of death?
The cause of death is what happens to the body to cause it to stop functioning. And the manner of death refers to circumstances under which the death occurred. So there's hundreds of thousands of causes of death or why the body stops functioning, but there's only a few manners of death, which would be natural, accident, suicide, homicide, or undetermined.
Those 5 main categories of manner of death, is that the responsibility or one of the responsibilities of a forensic medical examiner to determine that the death fits into one of those 5 categories?
Correct.
What does it mean when the death is deemed undetermined?
Now, when the manner of death is undetermined, that means at the time the death certificate was signed, there was not enough information to put it into either accident, natural suicide, or homicide. So at the time the death certificate was signed, there was not enough information to put it into one of those other categories. It doesn't mean that if more investigation takes place, then you might be able to put it in one of those other categories.
If a manner of death is deemed at a particular time undetermined, at that time, it's because it lacks sufficient additional information. Is that correct? What information, what types of information does a medical examiner, forensic pathologist consider in making these determinations between natural accident, homicide, suicide, undetermined?
Well, first you have the findings from the examination of the body. So that's sort of a starting place to see what happened to the body. Then you need to also look at the scene investigation. You need to look at any police reports and witness statements, and also medical history of the deceased. And using those 4 sources of information and using your training and experience, you can either say this is a natural death, this is a self-inflicted death, it's a suicide, it's an accidental death, it's a homicide, or if all that information doesn't allow you to put to a reasonable degree of medical certainty into any one of those categories, then you have to leave the manner undetermined. And if more information becomes available later, then you can change that death certificate.
What if no more information comes available later?
It just stays as undetermined. There are cases where there's just not enough information to put it in one of those other categories.
Without getting into what they may be, did you reach any opinions and conclusions in connection with this case?
Yes.
What materials and information did you consider in reaching your opinions and conclusions in this particular case?
Yes. I have my list of materials I reviewed. I reviewed Mr. O'Keefe's autopsy report, the report of the examination of his brain, the toxicology report, and the entire medical examiner file. I studied 100 and some autopsy photos, including photographs of the brain, and then there were 70 other photographs at autopsy taken by a state trooper who was at the examination. I reviewed Mr. O'Keefe's medical records from Good Samaritan Medical Center and the EMS run sheet. I reviewed photographs of Mr. O'Keefe's clothes that were taken at the crime lab. I reviewed photographs of pieces of tail light, hard plastic, clear, black, red. I reviewed photographs of the outside of Karen Reed's SUV. I reviewed the Canton Police Department incident report on the death.
Exactly.
I reviewed 100 and some photographs taken by Canton Police of the...
By Hank's logic, have you ever written any papers about being sideswiped by a Lexus into a snowstorm on a Saturday morning in Massachusetts? I thought not. You're not really an expert.
outside of the house at 34 Fairview Road in Canton. I reviewed some photographs taken by the real estate agent who was going to sell the house of the inside.
In total, putting them in categories, did you review the forensic autopsy?
Yes.
Did you review all of the files associated with the medical examiner's office in this particular case related to the autopsy of John O'Keefe?
Yes.
Did you review the scene investigation through police reports and other things?
Yes.
Photographs as well?
Yes.
Did you review the police reports that were associated with the initial investigation in this case as well as follow-ups?
Yes.
Did you review witness statements and things of that sort?
Yes, if they were included in the police report.
That was my next question. Those witness statements would be included in the police reports that you otherwise reviewed, correct?
Yes.
What about Mr. O'Keefe's medical history as much as you had of it?
Yes, I reviewed his medical history.
And what about hospital records?
His medical history was in the hospital records.
Understood. What method did you use or methodology did you use in forming the opinion that we'll get to in just a few minutes?
Well, in order to arrive at a conclusion of how somebody dies and what the cause of death is, we have to put all our facts out, and then we say, how could these facts have come to be? So it's called like a differential diagnosis. So like if you go to your doctor and you have a white blood cell count, then the doctor would say, well, how many ways do you get this white blood cell count? So that's a differential diagnosis, and then you go from that list and pare it down by getting more data till you come to one final diagnosis. So that's the process of determining how somebody dies and the circumstance around it.
Is it fair to say that you have a pretty significant background, training, and experience regarding coming to the conclusion of cause and manner of death?
40 plus years.
And how many autopsies in total?
Well, myself, I've probably done over 3,000, and then I have observed and reviewed maybe 7,000 more.
So that's in total over 10,000 autopsies if you would estimate over 40 years?
Probably.
In addition to just autopsies, how many death investigations, separate and apart from autopsies, have you been involved with?
Well, the autopsy usually has a corresponding death investigation with it.
Do you have experience in examining, identifying wounds, not necessarily the cause and manner of death, but wounds that are associated with someone on whom you're performing an autopsy or you're supervising an autopsy?
Yeah, so looking at the injuries on the body and understanding what caused them is a huge part of forensic pathology.
Have you ever conducted or overseen any autopsies of individuals involved in vehicle-pedestrian collisions?
Yes.
How many times, if you had to estimate?
No, hundreds.
100 or hundreds?
Hundreds.
When was it that you first started training on the issue of wound pattern recognition that helps assist you with coming to your conclusions, whether it be auto pedestrian incidents or otherwise?
Yeah, well, understanding wound patterns and injuries is a big part of forensic pathology because we want to identify what caused a particular pattern. So understanding that whole complex bag of injuries begins when you start your forensic pathology training, which was when I started back in '81.
In addition to the cause of death, which might be whatever, gunshot, something, does the pathologist also undertake an examination of the rest of the body that's not so obvious, other wounds, etc., that might tell a more defined story?
Yes, we look at the entire body, we look at the clothing, we look at the outside of the body, then we do the internal examination in order to understand not only why the body stopped functioning, which is the cause of death, but also things that could have contributed to it or helped to understand the circumstances around how that death occurred.
When you say the body, you mentioned the clothing. Why is the clothing important? Is that part of the body for a forensic medical examiner?
Oh, yes, it is. You always have to look at the clothing because it has materials on it that may be important as to how injuries occurred. So it's every time you do an autopsy, you have to always make sure you have the clothing. Many times it would have been taken off at the hospital, but then I would always ask my staff, tell the police, we've got to get the clothes, have to look at the clothes.
What is a gross examination?
A gross examination is not actually like gross, grotesque, but it means like without microscopes. It means just looking with your naked eye.
Is it important to look at a body, a deceased person, when you're conducting an autopsy from head to toe for outside obvious wounds that you can see on the gross anatomy outside?
Oh, yes, and also to collect any trace evidence that may be present on the body.
Are forensic medical examiners trained to do that?
Oh, yes.
Are you trained to do that?
Absolutely.
In addition to a gross examination on the outside of the body, is it also important to look on the inside of the body?
Yes.
Are there wounds and injuries that might be hidden by the dermis, for instance, the skin, that might not be so obvious on a gross examination of the body?
Yes, you have to look inside the body.
And what's the mechanism of doing that?
Excuse me. We make surgical incisions in the body so we can examine the brain, the neck, all the organs in the chest, all the organs in the abdomen, and depending on the case, we may make incisions in the arms and legs to look for evidence of injuries.
What about x-rays? Are x-rays an important part of an examination in an autopsy?
Yes, they're usually done before the autopsy is started, and we look for changes in the bones or any foreign material that might be present in the body, like a bullet.
This is interesting.
Dr. Lapisada, have you ever exercised wound pattern recognition in your position as a forensic pathologist? Or do you do it every time?
Oh, all the time.
Have you ever taught any courses or given lectures on wound identification and wound pattern recognition?
Yes, it's part of...
Do you want me to go back through those photos again, or what's the issue? Do I still have the stream from right before the first trial when you went over the autopsy photos? I mean, I can grab those up again real quick. I got them. Hold on here. Let me pull them up. If you guys want to, we can just show them again real quick. KLF was so kind to send them our way. You guys want to see them once again, chat? This is might be a little grody for you, might be a little gnarly, but this is the real world. This is the business end of what we're dealing with here. We'll go through the photos real quick, chat. We'll go through the photos real quick. If you die with a Baldo in you, she's the person that finds it. Yes. All right, chat. So here is the arm. There is a picture of the arm. It still doesn't make any sense that the taillight fragmentation grenade covered that. Here is the back of John's skull. MMD says, I'm going to get disappointed for what? What am I get disappointed in? And then here is kind of the composite pictures of everything. Once again, there's, there's scratches and they go part way up the arm. There's John with his raccoon eyes, which aren't even really that substantial. So, but look at him. He's like, I don't listen to Karen anymore. Sweet release. Calm saucer tot. That's what he's thinking to himself. We were talking before you showed last year. There was a mine. I was of a mind. She hit him. When these photos came up, I went, "That's a dog bite. That's a punch to the face. He wasn't hit by a car." Okay. Yeah, no, I don't. I probably have it up somewhere. Like if you go back through, we can see it, but I don't have it otherwise. Mark says it's terrible looking at those photos, man. This is looking at rapes and murders and stuff, man. This is, yeah. You know, especially when you're working like defense attorney too, but like when I'm working at a prosecutor's office, you have to sit there eating, like you're eating your lunch and you're like clicking through approving evidence, or you're reading through a case and you're just like, oh, wow. Yeah. Oh, yeah. That looks like a stabbing. Nope, like eating away. Yeah, but he's dead. Yeah. Dead bodies do that. Shit, I wish I could show you the aggravated murder case I had where the drug robbery and somebody got clipped. The lady was alive still when the cops found her. So. Mark, no, Hank doesn't believe they're dog bites. Hank postulated the theory that could have been a bush on his arm, which at that point is more reasonable doubt. You watched a murder yesterday? Yeah. So. Tosh says, the only good part is not having to smell it so you can still eat without a problem. Well, I've never gotten that far, but yeah, see a lot of stuff out there, kids. And we're almost done. Let's get through this.
Understanding blunt force trauma, sharp force trauma, gunshot wounds, they all make injury patterns on the body that the pathologist can then relate to what caused that injury.
With regard to the case that's before us, what injuries did you observe with regard to Mr. O'Keefe's head, specifically?
I observed that he had evidence of blunt force trauma to the back of his head.
Are those injuries consistent with a particular type or pattern of patterned injury?
Yes.
Describe that for us, please.
There in the back of his head, a little bit to the right-hand side, was a horizontal tearing of the scalp, and that's called a laceration. And surrounding that were linear scrapes that were vertical in orientation. So that is an injury pattern. And then you have to think, well, what could cause that injury pattern? And so then you go from there.
Did you also, in addition to looking at, by the way, how did you make that assessment about the injury? Was it photographs?
Yes.
Is that a normal way for a forensic pathologist to make an assessment? Is that an acceptable methodology to make an assessment of a wound pattern by the use of anatomical photographs?
Oh, absolutely.
Have you done it before?
Oh, hundreds of times.
What is a coup contra coup injury?
No, it's a very interesting, peculiar injury to the head. When you have a blow to the head, the blow can either be the stationary head and there's a blow to it, or you can have the head that's moving and gets the blow. So looking at a pattern of coup contra coup helps the forensic pathologist differentiate that. A coup contra coup injury examines the coup, which is where the impact occurred, and then we look at what's 180 degrees opposite that impact, and that's called the contra coup, or like opposite the coup. And that injury pattern helps us determine whether a person was just having a fixed head and somebody hit it, or whether the head was just standing and went down to the ground. The coup contra coup of a falling or being pushed backward has injury patterns where the impact occurred, but then there's also injury patterns 180 degrees opposite from that. And that happens because the brain is floating in cerebral spinal fluid, and when the head comes down, the brain is a little bit behind, so you get the bang on the back of the head, but then because the brain is floating, it hits the inside of the opposite side of the head. And so that makes the contra coup pattern, and that tells us that there's been a fall backwards and hitting the head.
Is that consistent, a coup contra, just in general, a coup contra coup injury, consistent with a linear acceleration of the head by a fall, an unbroken fall straight back?
Correct. There's also some angular force in that as well.
Understood. In order to determine whether or not Mr. O'Keefe suffered from a coup contra coup injury, can that be done by a gross examination, or does it have to be surgical?
We would look at, well, first we look at the outside, but then we have to look at injuries to the scalp, and we look at the skull, see where the skull fractures are, and in particular to look at the brain and see where the damage is to the brain. And there should, in a fall backwards, you have damage to the brain at the site of impact, but you also have damage to the brain 180 degrees opposite from that, and that tells you it's a fall backwards.
In the case before us, dealing with John O'Keefe, Were you able to look at the scalp and the injuries associated with the scalp from a gross perspective?
Yes.
Were you also able to look at the skull and possible fractures that Mr. O'Keefe suffered on his skull?
Yes.
And what about the brain? Did you have evidence of a dissection such that you could see the brain and determine whether or not there was a coup contra coup injury associated with the brain?
Yes, I had a full examination of the brain available.
Were Mr. O'Keefe's head injuries consistent with a coup contra coup injury?
Yes.
Could you describe that, specifically his head injuries, to the jurors, please?
Well, as we say, he has a pattern head injury on the back of his scalp, where there is a tearing of the scalp, and then vertically above that, there is some little areas of scraping to the skin. So that tells me that Mr. O'Keefe went backwards onto something that had a little ridge, but it also had some irregularity to it to cause the different scrapes before you get to the tearing of the scalp. Then when we look at the skull, he had massive skull fractures that started in the back of his head. They came around to the front. They went under the base of his brain, under the skull, under the base of the brain, and it came into the front of the skull at the orbital plates and fractured that, and that caused some bleeding in his upper eyelids. When the brain was examined inside the brain, I could see that the brain had become swollen and parts of it had herniated or moved down the area where the spinal cord is, and that's called brainstem herniation, and that is why the brain stops functioning and why your body stops functioning when you have a severe head injury.
Your brainstem
You indicated
herniate.
that
Ugh.
the wound pattern suggested a ridge or ledged surface.
Yes.
Could you explain that in more detail, please?
Yes. So if I were looking at it, I would see the break in the scalp. Then I would see several sort of irregularly placed scrapes of the skin that kind of look like pencil marks. And so that means that something with granularity he hit first, then it moved up a little, broke the scalp, and then moved on a little bit above that.
Would you expect to see that if Mr. O'Keefe had fallen backward onto a perfectly flat surface?
No, it has to be a surface that has some small ridges in it to make those little vertical patterns.
Dr. Lapisada, what is ecchymosis?
Ecchymosis is a medical term for bruise.
Did you see any ecchymosis on Mr. O'Keefe that he suffered as a result of the coup contra coup injury to the back of his head?
He had a bruise on his brain at the back of the brain and at the front of the brain.
What would the outer, let me rephrase that.
Yeah.
What would you see around his eyes regarding ecchymosis?
Yes, when you have, when the brain slaps forcefully against the base of the skull, the delicate bones above the eye break, and that's again the coup contra coup where the brain slaps forward. And when those delicate bones are broken, there's bleeding, and that bleeding then goes right down into the upper eyelids. So it kind of looks like you have black eyes, but there's not been any punch to the face. It's only come from the skull fracture. That's sometimes called raccoon eyes because you look like a little raccoon.
Did you see any skin injury to either one of Mr. O'Keefe's upper eyelids?
Yes, he had a small kind of slit-like defect horizontal on his right upper eyelid.
Would the ecchymosis on its own produce that type of injury, that laceration over his right eye?
No, the blood seeping down into his upper eyelids was from the skull fractures.
Was the laceration above his eyelid on the right side a separate injury altogether?
Yes, it was.
Based on your training experience, do you have an opinion as to whether or not what that eyelid laceration might be consistent with?
Some application of force which broke the skin.
Could that be from an object?
Possible.
Could it be from a fist?
Possible.
Sustain us to the floor, Mr. Jackson.
Give me some possibilities of what might cause that laceration above his right eyelid.
So it's not possibilities.
Give me, in your opinion, what you believe could have caused or produced the injury to the upper right eyelid.
So I'm going to see your sidebar here.
All right, chat. Now we're getting to the good stuff. But that herniated brainstem sounds awful. Awful. Oh, sorry, Natasha. I didn't mean to leave that up there. Yeah, her face, yeah. Guys, I'm sorry. I'm working on my thing for Nick. Just leave me be. I'm trying to get work. Chat, I'm trying to write a brief that I'm not going to get paid for, okay? Let me work on my motions. I'm working on the body cams, okay? You got to let me do it. Just stop. Stephen Bunt says, regarding the jacket and holes, does the defense going along with that bullshit jury instruction and waive their right to appeal? No. We objected. She overruled it. And now the next thing is, okay, now that she overruled it, you have to move on and keep moving forward. So they're just going to say, okay, fine. We object. We preserve that. Now you need to move on to the jury instruction, because if you don't cooperate with that, you could waive things. So you do have to move forward there. Nima's saying Roxbury Latin's one of the highest prestige private schools in the area. There's no way that guy would have had an accident. Okay. All right, real quick chat. We are going to knock the rest of these out real quick. T-Rex Trucking and More says, Alessi, better motion prepared for the morning, requesting the judge strike all testimony about the holes and instructing the jury not to consider the holes. Well, it's too late now. They already agreed to the thing. Whiskey 77, can we get muted Sean back? He had better commentary. Thanks for hanging last night. Oh, you're welcome. Guys, Whiskey 77 and 3 Beers doing Assholes React. Watched the riots last night. And thank you for 12 months. The little Jen that could says, your Clyde proof of life fee. I don't know if he's going to come in here right now. Let me see. Clyde! I hear click-clacks. Come here, Bubber. Come here, Bubba Bear. Come on. Clyde. Come here. Come here, Clyde. Clyde. Come here, Bubba. He was on screen earlier, I promise. Come here, buddy. Come on. Come on. Yeah, good boy. Good boy. Clyde, hey. Hi. Up here. Come on. There we go. Ah, such a good boy. Just for you, Jen. Here comes Clyde. Oh. Here comes your Clyde. Here comes your Clyde. Here she comes, Miss Clyde. America. Ooh, or can you do it a woo? Come on. Ooh. Ooh. Come on, do it, Clyde. Do it. Do it. Do the woo. Do the woo. Somebody wanted it a woo for 26 months. Come on. You can do it. He's like, I'm just going to lean back, fat man. Help me, chat. I'm stuck. I'm stuck. Help me, chat. Help. Help me. Oh, he moved. Okay. I got stuck under Clyde. Little Jen that could says I was late to chat, but politely told he was in chat earlier, so I rewound. I saw his cute little face. Well, you got him again. Natasha says, Sean, we can't read the closed caption. I'm sorry, Natasha. Natasha says, what's the current count on potential appellate issues? A gajillion of them, but remember, chat, harmless error. Courts could say she was guilty anyway. They can also do, remember, the cool thing they can do, we can distinction. That's different. We can distinguish this case from that one. Been there, done that. It's been here for 14 months. Thank you for being here. Said, use ChatGPT for the brief and call it good. No, don't do that. I don't do that. That's just not how we operate. I appreciate it, though. Yes, Clyde Coin's going to the moon. Yes, death by Clyde. Yes. Clyde's woos are so random. What causes them? Is it can I reproduce it? Can I repeat it like a science experiment? No. It's usually like when he gets like a big stretch in. So like when we go to sleep and he wakes up in the morning, ooh, he'll do a big one. Other times it's like just like he's been hanging tight. Like this evening, he's been sitting on 2.0's lap. She sits down and he sits on her lap, and he sits on her feet. I think he's, normally that's enough for him at times. So I don't know I don't know. I think it's part of it. You just got to get him to relax, and he'll just like, Oh, yeah. He likes a good scritch, though. He's such a good boy. He's such a good boy. He's such a good boy. All right, let's keep him going. Mystery Sniper has been a member for 19 months. Thank you, man, for the support. 88 Clyde. Oh. The content lasagna. Or it's like layers of content, chat. Or is it the content lasagna? We don't actually know. Do we know? I don't know. He's never told us. Excuse me, but Clyde cannot testify as he's not Bev approved for dog bites either. That's true. That's true. All right, guys, let's get back to this. Let's keep going.
May I inquire?
Yes.
Thank you. Dr. Lapisada, you just mentioned that the laceration above the right eyelid was consistent with the application of force, correct?
Correct.
You said it could come from some object, is that right?
Yes.
Correct. It was fairly small. Could be some sort of
How about we get some subs to get Clyde off of me, chat? Can we hit it?
object.
Is it also consistent with a fist?
Sure, a fist is an object.
Okay. Your Honor, at this point, I hate to do this again. May we approach? This is probably a good time. We talked about it at the sidebar.
Can you do anything to fill up the jury's time for the next 10 minutes and then we can do this?
Not without what we discussed at sidebar.
I love you, buddy.
A minute.
You're such
okay?
a good
Both of
boy.
you call out quickly.
Okay. So they're going to do something that's going to take more than 10 minutes. And Paul's in the back like, does doctor bite dogs? Why would doctor bite dogs? Dog bite people. Doctor bite dogs. Confused Paul.
I'm told that we're still on track. We will start. I'm going to have you show up a half hour later than we normally do because I expect to have 10 minutes with the lawyers, but we see sometimes with 10 minutes naturally in the course of any case can turn into. So I don't want you to be waiting.
Well, yes, that's.
So
All right, Clyde, I gotta
we
set
take
you
a
down,
half an
Pupper
hour,
Bear.
I want to get in here whatever time we normally meet. The court officers will tell you. We'll see you tomorrow morning. Tomorrow will be a full day, and we will make every effort that it's filled with as much time here in court for you without sidebar conferences, without delays for us to have hearings. So tomorrow, plan on a full day. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Be careful again with your social media use. I'll see you tomorrow. So Dr. Lapisada,
Yes.
you can step right out. Please follow the jury. We'll see you tomorrow morning. And if you will be here, make sure you're ready to go at 9.
I'll be here. Thank you, Your Honor.
She's like, thank you, Your Honor. Sounds like me walking across the parking lot. Jesus Christ, lady. Sounds like me, chat. It don't make no sense because she ain't fat. So, all right. Let's see. Oh, we got some fighting, chat. Here we go.
All right,
Oh.
so can you argue the Commonwealth's motion that I received this morning regarding Dr. Renshaw? Can we just do that now? Okay. No, that's fine. So we'll do that first thing at 9 o'clock tomorrow morning. The basis of the Commonwealth's Act, I've read the motion. I think the motion is clear. I'll hear you both tomorrow on it. All right. And you'll take care of the photographs, whatever photographs in her report you intend to put in.
The court hasn't made order yet, but it seemed like the court was leaning toward not allowing the text on the photographs.
So that was just a quick review. I just read the text part for the arguments for today, the arguments that were brought up today. I wasn't anticipating everything that we heard today on this, so it took a while. I did not get to look at specifically those. But to the extent that it's hearsay, whether it considers anything about dogs, clearly the dog, things that have been excluded have to come out of the photographs. All right.
The other photos deal with Patrick because
I think those have been shown, and I know the Wisniewski spots one is in evidence. The brain photographs are not coming in. The brain photographs that are different than what's already, the brain photographs in her report.
understood.
They're-
The stomach lining is a bigger issue, and some photographs in as well as like the car is probably logging in, things of that nature.
So tell me what you think is more of an issue, more of what you want. So I don't think the photographs on pages 4 or 5 come in. They don't add anything and they are extremely inflammatory.
I'm not looking to enter the but I'm not looking to get those from Brennan.
All right, the photos on page 6, I believe, are already in evidence. So this is,
That's a Lucas machine.
right, just a textbook photo of a Lucas machine?
Correct.
Is there an objection to that, Mr. Brennan?
No, thank you.
Okay. So do you want all of that in, or just the photograph that's got color to it?
I'd actually like all of it. She will explain what that effect it has on pancreas and stomach lining, send it to the reducing spots for lack thereof.
Okay.
Page 14, I think these are all in evidence otherwise, but I would like this particular all in one spot.
Hold on one second. Okay, so 1 is in. Point number 1, that was in evidence, and those 2 photographs. This is all for number 1. What was?
These are all close-ups of the same photo that is already in evidence.
Okay.
Right sleeve. So I'd like to use this because it speaks to her evaluation of these particular.
All right, how does she know it's blood staining on the fabric around the puncture? I'm just curious.
The blood stain on fabric around the puncture.
Yes.
She's getting that from the lab. They tested.
Okay, I don't recall testimony regarding, doesn't mean it didn't happen, I just don't recall it, so I just need to know the source, all right?
Pull that out.
No objections to the photos, if you have an objection. Yeah, go with the photos.
Okay. 13A and 13B?
Yes.
Yep, so 13B's out because of the dog bite. Let me see.
Jeez, buddy.
All right. So if we keep out the blood staining, Mr. Brennan, is there an objection? Oh, puncture. What's the objection for the Commonwealth on 13A?
The opinion outward tearing, the opinion blood staining.
I have no issue with blood stain coming out. Outward tearing that is her opinion of what it looks like.
Okay, so we're going to have to see if she's qualified to do that, to testify to that. All right. What's the next page?
Page. Figure 3 in the report.
What page?
I don't have page right there. Hold it up.
Page 5.
Page 5. It shows the cross-section of the brainstem.
That's what I was saying. I didn't see how that was coming in.
I certainly don't want the one in that is installed. Highly graphic. This is no more graphic than the side.
I disagree, but why does she have to use this photograph?
In furtherance of her determination of the constitutional injury, it supports that. I didn't put it in during that conversation.
Okay.
I'll
There's no contention that coup contre coup is the cause of the brain injury, correct?
There is contention that the coup contre coup is. Yes, that is the contention. I don't think there's any controversy. That's what the
I thought that's what Dr. Wolf testified to, no?
Consistent, I don't think there's any disagreement.
Right. So I don't know why we need this photograph.
Because this shows, it is, for her, this shows a bleeding of the brainstem, which talks about whether or not he's immediately incapacitated or not immediately incapacitated. which
Okay.
is an issue if
No, I understand that's an issue. Okay.
It is an issue.
Yeah. Okay. What else, Mr. Jackson?
I think you've seen this, Your Honor, and I'm looking at figure 5. So the use spots.
Yeah, I think that's already in evidence, isn't it?
It is, but not the Mr. Leslie saying something at chalk at this point, so.
I recall it was up, and I usually don't put up chalks, but okay. Excuse me?
Mr. Leslie. Say it again. Thanks.
There's only one person who can talk at a time. I'm told it's Exhibit 164.
Yes, Your Honor, my understanding is it's marked as an exhibit only. It was used as a chalk, but not in evidence.
Okay, so if it's marked as an exhibit, it means it's in evidence.
Sorry, marked for identification.
I'm told I think it's an exhibit. We can find out. If it's an exhibit, everybody's fine with it. It's in. 164, I think. We'll know. Okay, what are those? All right, so we'll have to see what's in and what's not. I'm just trying to make the best use of the time here.
The next is figure 9. Just intended to, these 2 photographs are intended to be exchanged.
Hi, Jesus, buddy. What are you doing?
So you're saying 9 in evidence or 9 on the form?
All right, I'm going to set you
9A
down,
and B.
but you're not getting comfortable.
Is there an objection to these, Mr. Brennan? Going to the Lucas compression device? On someone who's not John O'Keefe, and then this is on Mr. O'Keefe.
No objection.
Okay, so those will come in. Okay.
Okay.
All right. How much longer, and I'm not curbing you in any way, how much longer do you think? It seems like after the very lengthy qualifications, we're now moving along quicker with Dr. Lapisada.
I would guess, I probably finish under an hour.
Okay. Any idea, Mr. Brennan?
I guess it'll probably be about a half hour.
Okay. So we should finish with Dr. Lapisada's testimony either by the morning break or shortly thereafter. So we'll discuss Dr. Rentschler's testimony, the objections to it, Why don't you just tell me briefly, Mr. Brennan, what the objections are?
There are a number of slides that attempt to frame what the contested issues are in the case, to proper opinions, assumes facts, not evidence, and properly summarizes the Commonwealth position. There are a number of slides that provide credibility determinations about Dr. Welcher, and there are a number of slides that summarize opinions by this expert. So the improper summaries, the credibility determinations, trying to frame issues to the jury, none of that should be admissible as part of the PowerPoint. So we've articulated each slide and what our objections are, each slide that we have, and the objection is quite a few.
All right, so I'll look through that tonight, but the same restrictions will be, you don't criticize the person, it's the data, what you saw, what you didn't see. So if it's different than that in the slides, it's going to have to come out.
Understood. I'll take a closer look at it. I just haven't had a chance.
Yeah, no, I understand. I haven't read it either. Okay.
4 documents. These are documents that are attended to Dr. Lapisada's opinion and conclusions concerning the dog bites.
Okay, so
I'd like to have those identified for the record.
yes. So we'll make that part of the record. I need a clean copy of Dr. Lapisada's report and her resume for the same purpose. Yes.
I'll have those 2 running.
Okay.
And just finally, the redacted version of the 3430 post is not marked. Can I have that marked as an exhibit now?
Okay. There was no objection, Mr. Brennan?
This was never marked as an exhibit. That's all.
Why don't we do that right now?
Exhibit 224.
So I would like us to be as efficient for these jurors as possible tomorrow. I'm not suggesting that today was a waste of time. Everything we did was important, but it's very difficult for the jurors to spend so much time back there. It seems that they're just about ready to get this case, and everything that we hear now is very important. So I don't think anybody wants the jurors to tune out at this point. So let's try and keep things moving along. Mr. Jackson, how long do you expect?
I'm
to
sure
be
they've
with
already
Dr.
tuned
Wrenchler?
out, Bev.
Hour and a half. 2 hours. I'm being corrected. 3 hours. 4. She has a better pace than I do. I don't watch my watch enough. But maybe it's going to be a whole thing. I'm between us and cross-examination.
All right. So I told you all the other day, I thought I might be in a position to regret giving you last Thursday off, and that's where we're at. So let's be as efficient as we can possibly be.
I promise you we are. It's a murder trial, right?
I understand. All right.
One more item, when Your Honor.
Okay. So, Mr. Jackson, do you expect that Dr. Wrenchler will be the last witness that you call?
That's my expectation.
Okay. On rebuttal, any idea how long that will be, Mr. Brennan?
I'd like to keep it to 2 hours.
Okay. All right. That would be for everything, including Dr.
I'm
Wrench,
sorry,
Dr. Welcher?
Dr. Welcher, and then the DNA, all those witnesses. I think it should be done in less than an hour.
All right. So will Dr. Welcher be called after the DNA people?
Trying to schedule that. I expect to call him last minute. It all depends on when we get the DNA people, and Dr. Welcher will be here tomorrow or tonight, so he'll be here. So what is, if they're available, I'd like to get the DNA people first. But we haven't had confirmation on the flight.
All right. Because I told Mr. Lessie that he could excuse himself from this testimony if there were other witnesses first, so that he can prepare once he gets the discovery from Dr. Welcher.
Thank you, Your Honor. Could we understand from the Commonwealth the names of the rebuttal witnesses we're talking about?
They were in the motion, right?
Well, we heard some different things at Sidebar. If something happened with Dr. Lapisada, they were going to be different. We heard that at Sidebar.
Oh, okay, so the motion that I allowed was Ms. Kuhn, I believe Dr. Gillespie's name was in there,
Hartnett?
and Ms. Hartnett. Okay,
So that's the excessive scope of Dr. Welcher or the scope of the rebuttal witnesses for the Commonwealth.
yes, I allowed the motion. Mr. Brennan says he's not calling Dr. Gillespie. Mr. Gillespie, right? Okay,
And nor Dr. Crosby. Sorry.
or Dr. Crosby, right?
That's what I think there's.
Sorry, I know.
Well, it's important to know.
You're not calling their dog expert or your own, correct?
Not calling Dr. Crosby.
Okay,
The other item, Your Honor, we want to alert you to, we will come tomorrow with a suggestion with regard to the curative instruction that was given to the court today. We're going to come tomorrow with, and ask to be heard on that. So we're going to come in with that. What happened, what was discussed before, I'm not so sure.
you asked me to change it, was my recollection, Mr. Lessie.
We looked at it at lunch, Your Honor, and appreciate the opportunity to confer with you on that. Don't want to keep the staff later today.
And I don't want to keep the jury waiting, so file something with me and I'll take a look at it. All right. All right, so that's it. We expect to be ready to go when the jury's here tomorrow morning, probably no later than 9:15, 9:20, right?
Yes.
Okay, and we'll use a full day, as much of it as we can.
Yes.
Yes?
Yes, Your Honor.
Okay, all right, thank you.
All rise to the court, please.
Well, God, Bev is so fucking weird. So, ultimately, I mean, if I had a grade today, Hank won. Hank absolutely won. His cross-examination of Wolf, including his lies, fucking blew a hole in Karen today. Blew a fucking hole in Karen's case today. That's how powerful that lie is. Karen's fucking hurting now. Probably, actually, right now, without seeing Rentschler, I mean, yeah, we're back to oh yeah, this hurt Karen a fucking shitload today. That's why State's not allowed to lie, but Hank Brennan could. He lied. So we'll see, chat. We'll see. What lie did you imagine? What lie? I mean, really? He happened to completely fuck up what one of his own people did on an exhibit and brought up something that nobody else had ever figured out. Hank had figured out the only thing wrong with that exhibit, like that he found more injuries to John O'Keefe. Well, there's none of that marked on his back. But he found new things. Like, come on, man. He didn't crack the case. The jury instruction wasn't. There's no way to make the jury instruction firm enough other than saying the prosecutor's a fucking liar. And even then, that's probably not firm enough. It's not firm enough. It's not long enough. It's not hard enough. It's not going to bottom out the way it needs to. No, this should have been a mistrial. Oh. Gun to head right now, guilty. Right now, guilty. That's how powerful your boy's lie is. That's how powerful a lie is. Guilty. And Hank lied because he couldn't afford to lose. Bella says, what was the lie? The lie about what happened to the back of the sweater. Hank lied. It's clearly lied. Wasn't a mistake. It was a lie. I mean, how exactly was this cross effective? Torgo, at times it was very, very good. Remember what I told you? There's a lot of times he was scoring points. Then there's other times he's acting like a big vapid asshole. And, it's the attaboys are getting outweighed by the fuck-ups, but Hank was doing good work when he wasn't acting like an asshole. And I told you that, guys, this whole time. If Hank doesn't act like an asshole on cross, Hank is doing really good cross. Hank's no slouch. Hank's not an idiot. Hank is really good at what he does, man. If you guys don't believe me, go on to Hank's website. Hank brings home the dubs, man. Hank will get you a dub. Hank's a very good lawyer. It's just he's prosecuting somebody like defense work, which is absolutely fucking obnoxious. Absolutely obnoxious. And he's fighting it the wrong way. So, Cyanide Clone says, so they can still take it that the Arca guy's an idiot and didn't know stuff? Oh, yeah. Yep. Unlike Lawson says, that was not harmless error. I mean, I've told you, I don't know if unlike Lawson, you may not be around for this. I'll share a war story with you. And if you want to, email me and I'll send you the appeal. Dude is accused of manslaughter. Goes to trial. Gets all the way through trial. And twice in the prosecution's closing arguments makes clear references to the defendant's right to remain silent, the fact that he didn't talk to the police, and the fact he could have provided a story for everybody. Well, where is he to tell us what happened? Among others. Among all kinds of other shit that didn't add up. Did he do it? Sure. I could definitely see it. But we get to closing argument, and his Fifth Amendment right is violated twice, blatantly, very clearly. Both times. Defense team objects. Court sustains. Second time, defense says, we want a mistrial. Court says, I'm not doing that. Merely gives it, doesn't give a curative. Defense attorney says, fine, give me a curative. Court says, no. Keep going. The Court of Appeals said it didn't fucking matter because he's guilty anyway. I mean, what good is the Fifth Amendment if you could stomp all over it? As long as the guy's guilty, who the fuck cares? So, you like to think this is harmless error, but buddy, let me tell you. Let me tell you what, honey. I got news for you. I got news for you, honey. There is a myriad. There is the cases of clear bullshit that's gone on that gets you know what courts are? Appellate judges are jannies. I hate to say it like God. I'm gonna run into some fucking appellate judges in my future. They're gonna beat me up in a hallway. Appellate judges are jannies. They pull up the rug and they just sweep all the injustice underneath it. And they go, harmless error or distinguished. That's different. And that's their way of saying we don't care. Because remember, chat, appellate courts have only one job: to keep the lower court system from imploding. Because if they actually did their job, for example, that prosecutor's never going to learn that what he did was unacceptable. If he had gone to if the court had reversed this guy's conviction and vacated it and declared him not guilty for prosecutorial misconduct, the prosecutor would remember that. And he'd go, holy shit, I don't want to do that again. His boss, the actually elected prosecutor, might go, you fucked up. You're fired. But none of that happened. So the circle of accountability never actually circles. It stops. So nobody's held accountable. If appellate courts did their job, trial courts would implode. Appellate courts find excuses to punt. An appellate court is like an NFL team that punts on first down. That's their job. Their job's not really to play football. Their job's to protect the institution. It's true, man. It's true. Wish I could tell you otherwise. So, there's your black pill. On a wall says circular logic. Yeah. Well. You're black pilled as fuck. Well. Just telling you, man. Oh. Mount Reza says that's a story from when Hank was a prosecutor. Well. Don't monkeys, did you hire Hank to defend you? Probably. I mean, that's the thing. You want the nastiest, most aggressive attorney you can get. I guarantee Hank's a good one. I mean, it all depends. Like if Yannetti, I'd let Yannetti defend me. Whichever one's probably cheaper is who I go with. Both of them are going to be good. So I'm a good attorney. I care about pizza. Thank you. Here comes a cope if she gets convicted. Oh no, I mean there's got to be. I'll just say it like this: there are a surprising number of people who have decided that the way this whole thing occurred is acceptable to them, and it's solely because they want to score because they've now backed into a corner and are willing to say fuck Karen Reed. If that's how this investigation turns out, it's okay. That's the scary part of this. The amount of people who know everything and are like, you know what, this is okay. This is okay. And if it happened, and I asked her routinely, if it happened to you, if you knew this was happening to you, would you sit there and go, well, golly gee, I guess it's okay? You wouldn't. But be honest with yourself on that. Unlike last instance, what's the case name? DM me, I'll get it to you. I still have the appeal. They'll stuff you in a locker, nerd. Oh. Brandon, let's go for $5. Hey, Brandon. We don't need pizza casserole. We don't need no pizza casserole. Doesn't work out the tongue as well. Hey, Sean, tell your friend to leave them kids alone. Well, I mean, you know, he was saying nothing illegal, and it's not like he's watching Redo of Healer. I mean, if we're talking about people who need to leave kids alone, that's some stuff. Redo a Healer, man. Ooh, buddy. Ooh, buddy. Sweet to say, do you think Hank did that on purpose? 100% he did that on purpose. 100%. Tim says Hank admitted the error. People make mistakes. Prosecutors don't have to be perfect. You want to lock somebody up in an iron box for the rest of their life, you better be fucking perfect. This isn't like a zoning appeal or something about somebody not having a fucking dog license. This is about putting Karen in a fucking box. Possibly until she dies. You better be on top of your fucking game, Sparky. You want that. But the idea that Hank somehow looked at his exhibit, like I would like to have Hank should have been examined. What made you decide that was something to ask? And Hank's gonna be like, well, in between, sucking down tall boys at the truck stop in the glory hole, I was looking at the picture and I go, oh, I didn't know anybody knew about this before. Like, why did he do that? He should be questioned on that. Why did he lie? Because he lied. He lied. She got grounds for appeal. No, she don't. I already told you, man. Appeals courts will find a way not to do it, and they will find a way to skip out on this one. So, anyone who doesn't see the doubt in this case feels that way because they hate Turtle Boy. I mean, there's part of that too, but for a lot of people, they've bought in on a side, and one way or another, when the things are changing, they dig in harder. Although it's very interesting in the Karen Reed case, it transcends political. Karen Reed transcends everything, political and ideological. You have people from all over the place on the same side. Bush is saying, I don't think King's career is hurt. Oh, I think so. A lot of judges will see that and say, wow, he fucking lied. A lot of attorneys, like, interacting with him, he's a fucking liar. You can't trust him. You do that out here, man. Bush, he might be fine in Boston, Bush, but I can tell you this much, dude. He did that out here, your name's fucking dirt. Your name is dirt. So. So Clyde appearance. We just did a Clyde appearance. Are we watching any of the rights tonight? I don't know yet. Sean, if I Twitter DM you, would you ping me the linky, please? The linky to what? The opinion? Sure. Marco, where do I practice? Ohio. I'm in the Cleveland area. Northeast Ohio. So on the east side of Cleveland, not the west side. Yeah, Hank already had his jury instruction written by the time Alessi got done pitching. So. Yeah, they don't have to be perfect, but they need to be. Yeah. Marcos, he looked over the reads. That doesn't mean anything. Oh, I'm sorry. I just literally fucked your daughter's constitutional rights in the ass. My bad. That doesn't mean anything to me. Fuck him. Tim says it's correctable. No, it's not. You don't get to go back. It's too late now. The jurors have already made up their decisions on things. That's why it's like you do this. This is a massive error. Massive error. It's not structural, but it is huge. The idea you're going to get the jury to go back and like all that shit you just listened to, don't listen to it anymore. Like, no, it's not going to work. Like, the damage is done. So, Kathy, you're a realtor living in New Jersey. Yes, chat. When you are in New Jersey and you need a realtor, get a hold of Kathy. Appeals always work to the God Emperor, though, yeah. Well. I mean, the other thing, too, is, guys, like, here's the idea. If she goes through to appeal, you're looking at, maybe 3. Let's say she get sentenced and convicted. The appeal will finally probably get submitted to the appeals court in 3 years. And then 4 or 5 years, we might get a decision. So guess what? 4 or 5 years in prison, sitting there waiting for a retrial. Or maybe they toss out her conviction. 5 years sitting can. The fucking asshole. Think about that. I'm not going to lie. If I was Karen and that happened to me, I'd be looking to collect a fucking scalp after that. I go in, run Hank down and be like, no, I didn't do it. Your Honor. I'd be like, hey, look, apparently we're allowed to lie. So, would I hire Ricada to defend me? No. I'd let you defend me before him. Okay. Let me see here. Stephen Cooper says, how much cardboard do you think Bev goes through? Oh, she tours the Franzia almost once a week, I guarantee you. She tours the Franzia once a week. Selena says, oh, I wish every dog had a loving home like Clyde. I do too. There's a guy on Twitter, I link his shit every once in a while. Niall Harbison. He's a guy in Thailand, and he runs a thing called Happy Doggo. And he feeds a lot. So he adopts dogs that are critically injured in really bad shape, and he rehabilitates them and adopts them out. But he also has a thing where he feeds thousands and thousands of street dogs every day so they don't starve to death. But yeah, there's a lot of doggos out there, guys. Adopt, don't shop. Really, I mean it. You want a dog like Clyde? Go to the shelter. You'll find him. I promise. Stephen Bunt says, how can you object to the judge? Days off, short days, only 5 minutes for arguments. Short voir dire on midday, blasting defense with time management. None of that's going to be shown bias. Just appeals court will say, sorry, she's a shitty judge. Nothing we can do about it. Amon Rezu for 13 months. He says, Toga frickin' Leps. Thank you. Thanks for the support. Brandon says, okay, we got that one. Kathy says, who has what over Bev's head that she is throwing this trial? No. Guys, she's just an idiot. She just sucks. Remember, it's a bell curve. And she's on the below average side somewhere. Like, she may not be a 10%, like the 10th percentile judge, but she could be in the 30th percentile. And if she's like 30th percentile, she's like middle of the road for shitty judges. But that means 70% of judges are better than her. It's scary like that, man. It's scary like that. Kayleen Swantek says, Alessi's seething. I'd be seething too, man. You have no idea. I would be fucking livid if that happened to me. So, like, that's a thing. It's a thing. Like, I don't think you guys, like, getting fired up this time. It's a thing when you get angry. You have to be very calm and still get your stuff done. Creed M asked a great question from earlier. He says, how many DLA Piper lawyers? And that's Alessi's firm. Alessi works for DLA Piper. It's Alan Jackson worked there for a little while too. But DLA Piper, the third largest law firm in the world by revenue. The partners there get a automatic partner share of like $3.5 million. It says, how many DLA Piper lawyers are billing their clients $100 an hour while watching this trial? I bet a lot of them are watching, Bob, cheering them on. But yes. Look out, Alessi! He's got steel chair! How could a jury not watch Hank and think he's not a complete tool? Because there's times he's not acting like a tool. There's times he's being very effective. And they also, remember, guys, we tell you, I told you this. Robert Barnes told you this. I know if you ask Andrea Burkhardt, she'll tell you this. Emily Baker, Peter Tragos, Phil Holloway, Nate Brody, Ian Runk. Well, I don't think they have jury trials really in Canada. But Nate Brody, Law Talk with Mike. I don't know what Mike's last name is. Who else? Even Legal Eagle. Juries focus on sometimes the weirdest things out there. So sometimes it doesn't matter what you want them to focus on. They've made their own decisions. So just saying. Who else could I throw in there? Anyways, you guys get the point. Ask all those people. And by the way, well, except for Legal Eagle, every single one of those people, plus Ian Runkle, I would highly recommend to watch. Oh, don't forget, Lawn Lumber. I know you guys might not like her. Natalie Lawyer Chick and Bross Attorney Bree. Those are all ones too have trial experience. They'll tell you the same damn things. Sometimes jurors do stupid stuff, man. They do stupid stuff. So who knows what they'll focus on. Suki needs more some sort of plant. Says, my 23-year-old kid got selected to be in consideration for our local grand jury. I say it could be a great experience for him, but his dad thinks he shouldn't. Your opinion? Go to jury duty, man. Grand jury is a great experience. I mean, he gets to sit in there and decide. No, it's one thing when you're on a petit jury at trial. He gets to be at the first step, and he can say, "No, I don't want to indict this guy." Maybe he gets outvoted, but he could sit there and while the jurors are deliberating, he can say, "No, we should indict this dude. It's wrong. It's not what the law is meant to be." Or maybe he goes, "Yeah, this guy's guilty. Let's do it." And he argues the other way, which it might be fine as well. But no, he should totally go in there. You are, as a juror, you shape governmental policy. You shape governmental policy as an attorney. I mean, as a lawyer, on a jury. You shape policy. You're shaping the law. I would highly recommend it. Highly recommend the opportunity for a grand jury. So Jack D says, will the feds allow Karen to go to prison if she's found guilty? What's going on? I don't know if you're trolling or not, but yeah, like the whole Fed thing. I mean, like the idea that somehow, like halfway through this, like Jen McCabe, Bev, and all these people were gonna get frog marched out. No. The reason why they got involved is because the fucking government out there is notoriously corrupt, and they knew about like the whole like Sandra Birchmore and the whole like law enforcement in Boston is horribly crooked. That's why they got involved. That's why there was a probe. Something didn't add up. Even the U.S. attorney in this district was like, something sketchy here. So, So let's see here. Let's see here. Okay, let's see here. Sonal Trap says about Dr. Wolf earlier. Oh my God, did he get a haircut? Oh, with that said though, there is a hilarious video on Twitter right now of you guys need to see this. This is from the Glare. This is absolutely hilarious what happens here. So here you guys go. Ready? This is hilarious. The Glare is one of the channels that's been following the Karen Reed stuff the whole time. They're actually, the guy who runs it, I guess, is really good friends of Karen. And this is actually pretty freaking hilarious. Let me see here. This is really good. This is really good. Here you go, guys. Go.
Everlasting love. This will be the one I've waited for. This will be the first time anyone has loved me.
Oh, fucking ate it. Now, I'm not gonna lie. I think this shit is cringe as fuck. Like, it's like, I hate to say, I'm like, well, there's Turtle Boy. But I guess I'm like Shooter McGavin, I guess a little bit. Like when Shooter McGavin's sitting there and a beach ball comes out and he's like, this is a goddamn golf tournament, not a rock concert. Yeah, like this is a little bit ridiculous. But yeah. Paul Goodyear says the Emmys report indicated there would have a broken arm. I think it would have been obvious. We touched on this earlier. Yeah, any competently trained doctor can generally tell a broken arm by looking at it or have a very good idea there's a broken arm. You know, Dr. Scorty Bello didn't think so, and nobody else has thought so. So, yeah. Let me see here. Oh, you guys all a bunch of start comments about my Jiffy Lube shirt. You know, you guys are just something else. I don't know what to tell you. I just have to settle for chubby chasers. Jolly Jake Lovell. Hey, good. It's good to see you, man. Hey, we've been working on the MIG, so thank you again for that. Karen Reed said I hit him, but is it clear she said I hit him? We don't even think that's the case. It's not even clear from basically all the testimony there. So, anyone know how Turtle Boy's trial is going? Yes, He is having a bench trial, and it's going to be held 2 hours tomorrow. And he said, hold on here. Turtle Boy made his comments about his case. Hold on, we'll bring it up. Okay, so Turtle Boy's case here. Let me bring it up to you. Let me see here. Where is... Yeah, here we go. Got it. Found it. All right, chat. Here is Turtle Boy's situation. He said, I just agreed to have a bench trial instead of a jury trial. The trial will take place in the courtroom in Dedham in front of Judge Pomeroy. It'll take place over 2 days from 11 to 1 today and 11 to 1 on Wednesday. He says, I'm now sitting in the Karen Reed trial. So I got one of the standby passes and will remain here until my trial at 11. I will tell you this much, guys. I mean, obviously his attorneys, Braley and Mark Bedrow, Tim, I think it's Tim Braley or Brawley. You know, he has really good attorneys. And, you know, his one attorney that's there, the Massachusetts guy, was arguing his last motion bond hearing very well. And you guys have heard Mark Bedrow. You guys have heard him. Well, you've heard him on a lot of channels, just not this one. I'm probably a little bit small for him, but Aiden's got really great attorneys. But God almighty, man, I don't know how he could sit there knowing he's got a fucking felony trial. And he's like, I'm gonna go watch someone else in the meantime, man. He did this. Look at the time. Look at the timestamp. 10 a.m. There ain't no way. You got an hour to go before a massive felony trial for yourself. I'm gonna go do something. There's no way I could do that. There is no way in hell I could do that. But good for him. Good for him. Like I couldn't do it. I couldn't do it. Oh. So. Ooh. What a mad lad, yeah. And this is true. The grind never stops. Yes. The Journo and a half shell. Nobody's streaming the Turtle Boy trial. He wants somebody to. If it's broadcasted, I'll cover it. If it's broadcasted, I'll cover it. I mean, shit, it's only 2 hours. I'll cover it. I mean, like, I got stuff tomorrow. I mean, like, it's funny because, like, I've got things. Like, if it's on... God damn it. Hold on. Using my phone as a coaster here. Hold on here, chat. Hold on. Tomorrow. Oh, no. Damn it! I was just looking at my schedule and, like... I'm, like, in court that... I'm going... tomorrow, I have a couple of hearings. I got, like, probably 4 or 5 total. And they start at, like, 10 a.m. Like, one at 9 and, like, 2... One at 10, one at 10:30. And it's like 20 minutes from that court. And it's funny, it's like 10 miles away. And it's like 20 minutes to court because it's not a straight line into the suburbs. And then I have to be back there at 1 o'clock. I thought it was like 1:45. It's 1 o'clock. Fuck. I could have covered it. I maybe covered it live, but I can't. I can't do it. I'm not going to have time to run back and forth. And my luck, that 10:30 case, it's actually probably not going to be in front of the judge till like 11 anyway. So, like, I'm probably just going to bring a lunch with me. And there's a nice park nearby, and I'll probably just sit and I might watch it live, but I'll stream it. I'll 100% stream it. I just don't know if it's going to be live anywhere. But tomorrow, you know what we might do? I hate to do this, chat. Let me look at my things here. Okay, if this is from 11 to 1, so 11 to 12, 12 to 1. It's only going to be a 4-hour trial. Tomorrow we'll start at 4 o'clock. We'll cover Turtle Boy's trial. There you go. 4 p.m. tomorrow, Turtle Boy's trial. If it's somewhere I can do it, I will go through it. He said it's on Zoom. Is there a way to record it? Yes, it's a bench trial. So he's being charged with witness intimidation. Take a worst case sick day. Well, I've done this. I'm now to the point where there's courts that know I do this for like fun. So like if I show up on screen somewhere, it's going to be a little awkward. Kathy says it's Wednesday. What do you mean Wednesday? It's going to take from today and Wednesday. Yeah. Oh, it's okay. Sorry. So what happened today? Because I'd like to cover today. We'll cover today tomorrow. And yeah, I can't do Wednesday either. I'm going to be Wednesday. I'm all over the place. So Wednesday will be at 4 p.m. if it's recorded somewhere. Would you get in trouble streaming from the courthouse? I mean, I've done like laid back law from a courthouse parking lot. Hate to do this shit, but I'm putting you down. Yes, an emergency continuance. Yeah. I'm just like, I don't know if I can do it. It was not on the Zoom today. Fuck. Well, I'm gonna message Turtle Boy, see if it's out there. So, get my second screen working? Yes, I have this one, and now I'm reading this one. I'm reading the second screen right now. So, Sula is saying, I have a wake and a funeral tomorrow and Wednesday, the second in 2 weeks. Jeez, man, I'm sorry to hear that. Sorry for your losses. I hope your family and friends have some closure, and you know, if it's somebody you guys cared about, remember the good times, and if it's, you know, that's all I can say, and hopefully they're off to a better place. You know, they got to shuffle off the mortal coil, and they got to go on to, well, hopefully they found Jesus, and hopefully they are onto a better place. So, yeah. James, where did the drinking glass come from? The glass came from the Waterfall Bar or CF McCarthy's or wherever the fuck they were. John and Karen, like there were multiple people, like, and you know that happens all the time. People like take their drink outside, take it with them. Like that's not that uncommon. So I can handle that. So yeah. Well, this is still something big there. Where did the pig DNA come from? It's still something that isn't answered. So, but no, people taking a glass outside really. The inside man, it doesn't matter what the attorney says. That's not a statement. So that it was an accident. Well, great. The attorney can say whatever the fuck he wants. He could say Karen was riding a unicorn while she did it. It doesn't mean it's admissible. So, oh. And the bigger thing is, too, imagine if the police had been a little more thorough about their investigation. Karen probably would have pled out. This is one of the reasons why you do a thorough job. People tend to plead because the attorney says, I got nothing. Shoddy police work leads to trials. So, something to think about. Something to think about. So, it does matter when you're asking why they didn't check for DNA. I mean, well, they, like, at the time, they had no idea what those scratches came from, so why didn't they check? I mean, nobody knew about this idea of the exploding taillight, the taillight hand grenade, the shrapnel bomb, until we just got around to this now. That's, remember, nobody had an excuse for that until Aperture came in. So, why didn't we check that? When we learned that the one piece of glass on the bumper doesn't match everything else, why didn't we check that and see what kind of glass it was? There's just a bunch of stuff that doesn't match up. Once we find out all the witnesses dumped their phones, and one of the witnesses destroyed his phone, why aren't we checking that out? Like I said, there's a lot. Like Limp Bizkit says, check it, check out of me, check out. A lot of stuff you can check out. Go being full detective. Put their detective hats on. So when'd you put your detective hat on? They didn't offer a plea because O'Keefe is a cop. No, they did offer her pleas. They did offer Karen a plea. 100% they did. I forget what it was, but they offered her a plea. Now, allegedly, there's people saying the plea was for like 90 days in jail and shit. Who knows? And I mean, if they offered her 90 days, I mean, you almost fucking take that plea. You almost have, like, if it really was like a 90 days offer, you have to fucking take that. I just quoted Limp Bizkit unsubbed. We'll deal with it. Well, selling the house isn't the issue, but yeah, the dog disappearing, destroying the phones. Yeah. I mean, like, that's a thing. There's a lot of problems. If this was any other investigation, the cops would be like, that's not right. So there's a lot there that's, yeah. So you take 90 days and divide the hours by 500K. Yeah, well. Oh. Yeah. Did they originally move to get the trial from somewhere not in Canton? No. I think they wanted it there. They were taking advantage of the PR machine. So. Mark says Proctor should have destroyed his phone and Karen to be in prison. Yeah. Isn't that the scary part, Mark? Once again, this is where something you're co-signing on to, that the rest of this was acceptable evidence. Like, you look at all this, you're like, no, that's okay. I'm like, just like I said, humor me. Pretend you're getting accused of DUI and all this shit happens. You're just going to go, oh, well, I guess I better plea. You're going to say, wait, none of this add up. But isn't that hilarious? That if Proctor had destroyed his phone, Karen Reed probably would go to prison. Isn't that insane? Or if he had just wiped his phone, she probably would have gone to prison already. Isn't that scary? Isn't that fucking scary to you? I mean, isn't that absolutely scary? I mean, like, once again, it's the other ideas of like this evidence that sat on the floor of their office for a month. The evidence that didn't have evidence logs. Like, imagine that you get a DUI and they take a blood draw and the blood goes in and there's no evidence logs. You know what happens to that? It's probably going to get suppressed. It's like, oh, it sat for a month. Do you have any evidence for it? No. No logs of it? No. You wouldn't just sit there and go, oh, well, I guess I'm guilty. I'll plea out. No. You'd be like, what the fuck? You'd be like, no, this ain't acceptable. This ain't acceptable at all. And here's the more interesting thing, Mark, and I guess to those of you out there, because I know we've got, it looks like a couple of pro prosecution people out there. Let's say you were a DUI and you know you were guilty, but you found out the police screwed up really bad. Would you just plead guilty, or would you take advantage of the fact the police screwed up? I'd like to know. I'd like to know what your answer to that question is. Let's say the police completely screwed up your blood test when they took your blood, and it was unusable. So they actually had no proof you were intoxicated. But you know you were drunk. You know you were like fucking fall down drunk. Would you still plea out, or would you say, well, too bad, so sad, and walk out the door? I'm just curious. So. Why was Karen suicidal? Well, I mean, like, wouldn't you want her to be? Like, if she came in there and just sat there and said, oh, hello, officers. My name's Karen Reed. How are you today? Yeah, it's sad John died. Oh, wall, wall, wall. If she acted like that, you would consider her a liar and a killer. So you got to pick a lane. Is she allowed to be emotional or not? So just something to think about, chat. Just something to think about out there. It's just my questions to people. Is this acceptable conduct for you? So, all right, guys. What we're gonna do. Remember, guys, this is a two people. One screen, two movies. So, like I said, if you're on one side or the other, you're not going to change your mind, and that's okay. So from here, guys, tomorrow we are going to start this at 6 p.m. again. If I can get the Turtle Boy video or any video of Turtle Boy's case, I'll definitely watch it. I'm going to ask him if it's available. If it is, I'm going to ask for it, and we'll watch it. So keep your eyes peeled, chat. I'm going to message him right now and see if it exists. And yeah, chat, please remember until next time. Actually, make sure I caught everything from everybody. Yep. Thank you for all the likes. Thank you for all the subscribes. And chat, thank you for all your super chats and all your comments out there. And to those of you on Twitter, I know there's a couple of you out there, even though you're mainly ghosts. Just remember until tomorrow night at 6 p.m. What if I'm wrong and all those witnesses are asked? Oh, fucking well. I would let 1 million guilty men walk free than to jail one innocent person. Also, number 2, Mark, all these witnesses are harassed. Jen McCabe sounds like an awful cunt of a human being. The Alberts sound like awful fucking assholes for people. Brian Higgins sounds like a big piece of shit, too. There's 2 types of people who destroy evidence. Assholes, criminals, like asshole criminals, and morons. You could choose which ones they are, but don't tell me these are nice people. None of these people are nice people. So they can all suffer. They can all suffer for what they do. I don't care. I mean, not really. Shit happens when you play in the road. I don't care for people that destroy evidence like that. I mean, you want me to cry for Jen McCabe? Like, ain't crying for her. Ain't crying for her. Well, if it's a troll argument, you know what you do? You're just like, nope, not buying it. Sorry, no. Do I believe the 100-person conspiracy? No. Like I said, do I buy this theory that's all happened because Brian Higgins wanted to sniff Karen's puss? Because that's the main theory why John got attacked. I don't buy the theory that Colin Albert was selling drugs and John O'Keefe confronted him. No, I could buy the theory that Brian Higgins wanted to sniff Karen's puss and John was in the way and he didn't realize that they were on the outs. Okay. But I mean, what's the real story? Drunk guy falls over in the snow and dies. That's a tale as old as time. But I will tell you, if you're trying to convince me you're not into conspiracy, you don't destroy your phones. You don't wipe your phones. You don't snap your phone in half and then throw the contents away on separate military bases. That's not what innocent people do. If you're trying to convince me you're a good person, I'm not convinced. So that's their own fault. They robed themselves in suspicion, and they did so intentionally. That's their fault. I have no pity for these people. I have no pity for these people. So it's likely the drunks got scared, overreacted. That too. I could buy that. That's also a tale as old as time. But I still think drunk guy falling down and dying is a very easy one. Okay, you don't lie on the stand, correct. You don't refuse to let the cops in your house. Well, no, actually, you have every right to refuse the cops coming into your house. You have every right to refuse the cops coming into your house. You don't destroy evidence. That one I actually agree with. So 2 out of the 3 I agree with. The middle one, no. So, am I going to cover the strip shooting? Yes, just not tonight, guys. I got to there's a bunch of videos to put together on that. But yes, we're going to do it. So, yeah. Suffer evidence, suffer. Jonathan, don't forget your last super. Oh, there's a new one now. Okay. Let's go. Brandon for $5 says, remember the 12th man sucks a ton of meat bats. So we can't measure so many we can't measure in feet. Oh, funny stuff. Oh. Let's see here. So let's see. But yeah, we are gonna cover the Las Vegas shit, and then I'm gonna get a hold of Turtle Boy, see if anybody covered his case. Because if I ever record the stream, I will watch that shit. That should be a good one. So, and the neat thing is a bench trial. It's gonna be like speed running it compared to this. You're gonna be amazed how fast it goes. You're gonna be amazed at how fast it goes. Finish the brief, please. Yes. J-Rock says, Sean cares not for my chats. Well, where are your chats, son? Shun? I haven't seen you chatted, J-Rock. So. Oh. Ugh. All right, chat. So we are all done here tonight. It's 12:30. We better get to bed. You guys have a nice time. Remember, tomorrow at 6 p.m. If we get Turtle Boy, we'll do it earlier. And just remember, chat, just because you did it does not mean you're guilty. I still think Kieran Reed's not guilty, chat, but I don't think the jury's going to see it that way. The tide is turning against Karen, and I don't know how they're going to stem the tide at this point. But Hank lying definitely hurt Karen a ton. Guys, riot stream is 12:30. I don't know. Not tonight. So, anyways, chat. Good night, you guys. Take care, and I will see you tomorrow. Welcome to all the new people.
Weapons black. smithing and models of planes, esoteric works and even some trains. Much merriment had while drinking White Claws, tips on hunting and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy Rick Hayden yelled at? Why, yes it was.